Does it may be permitted to mention?
Yes, please.
This is relating to a matter where this honorable court
Original side.
Original side.
Yes.
No, well, this is not original side. I am mentioning one matter.
I'll take up appellate side mentioning when I take up the appellate side. My officers will be there. Yes. Original side mentions you can.
No.
Lordship, I am mentioning up a notice, item number 16 of today's
16.
Tuesday's cause list
For what?
for urgent hearing. Predicament is that the board of managers has been changed. Election has been conducted and new result has been out and new board of managers will be there. So, Lordship, I'm praying for any time. I know the predicament of this bench.
Sorry, because we cannot jump the queue. So many others are waiting in the parted list also. And most of the matters, if you see from 6 to 10 or 11 are the same matter. So let us hope for the best. No, no. Sorry. Yes. Follow the list.
One appellate side mention. Sorry, my lord.
When appellate side is
The time for the petitioner.
seeing Mr. Sen after a long time, but for the wrong reason. Yes, Mr. Chaudhary, what is the content?
There is an order of injunction. Usual arbitration award, 130 crores. There was an order restraining them from operating their bank accounts without setting apart the awarded sum. As is usual, State of West Bengal has continued to operate their bank account
Without keeping that.
without keeping the money apart. Affidavit says, there is a budgetary allocation for us with NHAI. So, this was a joint project between NHAI and State of West Bengal. Now, with all of this happening, NHAI has kept this money apart in their budget. It's not tangibly kept apart. It's in
Please,
their budget.
please show me the ordering portion of the impugned of the order under contempt.
Page 15 of the petition.
Yes.
Learned Counsel submits applicant 36-2 are pending. Then EPICOM is listed along with execution.
Award holder shall be.
Award debtors shall remain restrained from operating their bank accounts without setting apart the awarded sum of 129.1 crores until further orders.
So this has nothing to do with whatever is kept, allocation is kept.
It has nothing to do with
Unless you
No challenge was referred to this.
no nothing.
Mr. Sen, what is your?
May I try and explain? Lord, this is a Lord, kindly give me 2-3 minutes, Lord, to
Absolutely, why not?
Because your Lordship usually would not.
You can take your seat, sir. Yes.
Lordships usually don't want to go behind the order because in contempt, Lord, there is no scope for that. But may I just explain what has happened? Lord, this is a project in relation to NH31. Now, Lord, all the national highways, Lord, are vested in the central government. Lord, all maintenance and development work is done by the central government through the Ministry of Road Transport and Highways, which is, Lord, may I use the expression MORTH for short, Lord. Now, Lord, sanctioning, Lord, payment, financial liabilities are all borne by MORTH. Lord, the PH wing or the NH wing, the National Highways wing of the PWD is only the executing agency. Lord, the budgetary allocation for each work is done by MORTH, and we are not entitled to spend funds directly. All payments are made directly by them through a process known as the DPP process, Direct Payment Procedure process. And Lord, so far as this is concerned, initially, Lord, when the contract was awarded, Lord, there was a budgetary allocation about 398 crore. Now, Lord, thereafter, Lord, the project was executed. There was arbitration. The majority award is in favor of Mr. Chaudhary's client, Lord, to the extent of about 129 crore. There's a minority award which rejected most of the claims. Having regard to the fact that there was a dissent award, Your Lordship, in the section execution proceedings and our section 36 proceedings said no, it should not be deposited in the registrar, let the sum be kept apart. Now, Lord, the National Highways wing of the Public Works Department does not even have a bank account. Lord, all operations are done directly through MORTH. So we wrote to MORTH that in the allocation of the state of West Bengal, please keep this sum reserved on account of this proceeding in terms of the order passed by Your Lordship. And Lord, now, Lord, the delay which took place, Lord, between Your Lordship passing the order and now, Lord, is because of the innumerable correspondence that that we had to have with them to explain what the matter was about and why it was imperative and what ought to have been done. In fact, Lord Learned Advocate General also, Lord, opined and directed that it should be done immediately. And ultimately, Lord, if your Lordship is pleased to come to, Lord, I'll not trouble your Lordship with the intermittent correspondence. If your Lordship is pleased to come to page 25. Lord, just in case, Lord, it's not legible in your Lordship's copy, may I hand over
25 of the opposition.
of the, Lord, it's an affidavit of compliance, Lord, we not file
Compliance.
as opposition.
All are similar. Three are
There's 3 contemners, 3 have been filed.
There is no order saying because of the dissent.
25.
There is no order, but I understand that was what transpired.
No, don't understand.
And it was not, that was what I was instructed.
No. No copy was given.
No, no,
My
no.
lord, I was quite taken aback. My lord, there is no order which says that because of a dissenting award, money doesn't, my lord, have to be deposited and has to be kept
Passed by
apart.
your Lordship, it was shown by.
There is no such order. Mr. Sen, my lord, was perhaps not correctly
So let us,
instructed.
yes,
Now, Lord, if your Lordship,
25.
Lord, if the if annexure F is not fully
No,
legible,
it's legible in
Very
my.
Lord, may I place this, Lord?
Yes, please.
Your Lordship will find in the reference portion, your Lordship's order is mentioned. 3rd of October 2024. And 2nd of May 2025 is another order passed by Lordship directing us to explain why it was not complied with. These 2 orders are passed by Lordship. If your Lordship please sees the text of the letter, my Lord, in compliance to the order under reference 2 passed by the Honorable High Court at Calcutta, and as per the direction of the competent authority in the ministry, an amount of 129 crore. This matches with the amount directed by Lordship. Has been reserved out of the budgetary allocation under NHO head of the state of West Bengal during financial year 25-26. A confirmation to this effect has been conveyed by the regional pay and accounts officer, Ministry of Road Transport and Highways, Kolkata. Vide the next letter, Lord, if your Lordship please turns the page over. Lord, is this, Lord, readable, Lord? Reference is invited to your office digitally signed letter dated 26 June 2025, wherein it was requested to keep in reserve an amount of rupees 129 crore in compliance with the Honorable High Court at Calcutta, Commercial Division, order dated 3rd October 2024 and 2nd May 2025, passed in EC such and such. In this regard, this is to inform you that an amount of 129 crore has been kept reserved out of the total allocation under NH office head of the state of West Bengal in 25-26 as recommended by you in the light of the Honorable High Court at Calcutta aforesaid order as per details below. Now the chart, Lord, if your Lordship please sees the bottom of the page.
Mr. Shen, if you direct you to pay the amount tomorrow, you can do it from this allocation.
Lord, kindly, Lordship may direct, Lord, there is no difficulty.
No, can it be done? Is it feasible? If you direct that you furnish the amount, say on Monday, can it be done from this allocation?
May I just find out, Lord? না সোমবার যদি বলে Yes, I am told that it is possible. Lord, I understand. Lord, my understanding, I was.
Sir, Shen, this is contempt because it is entirely different to say some fund has been allocated and which is kept in abeyance and whatever
Lord,
that has been kept reserved. I directed you to
It's
keep
apart.
it aside
Keep it
in
aside.
your. Do you say that none of the contemners, none of the respondents in that matter, none of the judgment award debtors rather have any bank account?
No, Lord. The
None
state
of them.
The state of West Bengal certainly has a bank account. Because the
Good to know that, but we thought
Lord,
maybe that it does not have.
No.
If it has,
Yes,
then it's a palpable contempt, Mr. Shen.
Lord, your Lordships, Lord,
Because
order-
you have not set aside any award from your account.
no, Lord, this is the fund allocated to the state of West Bengal.
Allocation is something entirely different.
Now, Lord, out of that, this amount has been kept reserved, cannot be used by us.
No,
in
this
any-
was directed not to be kept apart in some allocation which is very vague. Now, your bank accounts, it had to be set apart in your bank accounts, which has not been done. So why shouldn't you be hauled up for contempt? This is palpable contempt.
Lord, may I
You cannot interpret. There is no scope of ambiguity in this order.
There is no ambiguity, Lord. There is no
And it
scope
could have been
for
pointed out, Mr. Shen, it was passed in your presence.
Lord, we should have applied for.
So now,
modification of your
now you
Lordship's
can
order.
only purge the contempt. You can direct you to furnish that amount in by whatever mode, bank draft or whatever, and we'll direct you to deposit with the registrar.
Kindly do,
We'll
sir.
do that.
Kindly do
That
my
will purge the contempt.
Yes, but instead of Monday, my lord, kindly give 2 or 3 more days so that my lord, there is no my lord, procedural delay again, my lord, inviting
Mr.
another
Chaud-
contempt.
Very well. Mr. Chaudhary, find there is contempt.
Yes, yes, my lord,
Personal, I mean, prima facie. But let us give them, because it's a money award after
Yes.
all.
My lord, as I was
Let them
telling
purge the contempt
Mr.
and-
Sen, my lord, that I find no pleasure or, my lord, privilege
Right,
or
right, right.
exaltation, my lord, asking for important people to be hauled
Right,
up in
right,
contempt.
exactly.
But, my lord, the deeper question is, there is an order of court.
Definitely,
My lord,
you're
they
right.
will vary it in their own mind sitting
Cannot,
in office.
cannot,
This is
cannot.
what somewhere it irks me.
Unless
Lord,
there
I
is
have
a
no
prima
problem
facie
with that.
contempt, Mr. Chaudhary, there would be no question of purging it.
Yes, yes.
What
So
will you
please,
purge if
please
there is no
let them
contempt?
purge it. I'll not, my lord, make
We'll keep
any
it next
submission.
Friday. It has to be done
Yes,
within
yes.
that. Deposited with the registrar, original set.
And, my lord, an apology in the form of an affidavit to court.
Lord, we file that. Your lordship will
Mr. Sen
file
must have
the
put
correct-
something in if he has
Lord,
settled it.
Your lordship will take it.
Must be
Lord,
something.
if Mr. Chaudhary kindly has a
Show us
look
the
at-
apology.
I have nothing to do there, but I
Correct.
No,
feel
no,
that-
no. It's about the dignity of court. Mr. Chaudhary, you are
Yes.
absolutely right on this. This is not
Yes,
about
this is
you or
not the
me or
way.
Mr. Sen. No.
Milord, this is not the, Milord, I have also,
May I request Mr. Chaudhary to have a look at paragraph 3 if that satisfies your lordship and Lord Mr.
no, no, I am no one to be satisfied.
Lord, we've tried to.
I have stood in your shoes on numerous occasions.
Yes, yes. Unconditionally.
Milord, they have to take it more seriously. That's the only.
Apology is there. Now we'll impose the condition.
Yes.
Learned senior counsel appearing for the petitioner submits that there has been palpable contempt of the order of this court dated October 3, 2024, passed in EC-com stroke 396 stroke 2024. Full stop. By the said order, comma, this court had restrained the award debtors from operating their bank accounts without setting apart the awarded amount of rupees 129, 01, 14, 018.76 small p until further orders. Full stop. Next para. Learned senior counsel for the petitioner submits that in gross violation of the said order, comma, the accounts of the alleged contemners, accounts of the award debtors are being operated without leaving the reserve as directed to be maintained in the said accounts. Full stop. Next para. Learned senior counsel, Mr. Sen, what is your designation? I regularly forget that. I'm sorry.
But
It's
he's
quite
the-
forgettable. Lord.
Milord, he's the assistant additional advocate general.
So many things in between.
Yes.
And threshold I will.
I remember because my ex-superior.
Learned assistant additional advocate general, comma, appearing on behalf of the alleged contemners submits that there was no intention on the part of the alleged contemners to violate the order of this court at all. Full stop. Learned counsel also places reliance on paragraph 3 of each of the affidavits of compliance which are filed today, comma, to indicate that in the perception of the court, comma, any contempt has been committed, comma, unconditional apology in that regard has been submitted. Full stop. Next para. Submitted na kore offered kore. Full stop. Next para. Learned assistant additional government advocate general ওটা একটা short form করে দেবেন. Further submits that in compliance of the order, comma, an allocation has been reserved under the head of the award debtors comma, which has been duly communicated in the letters annexed to the affidavits of compliance. Full stop. Next para. However, comma, upon hearing learned counsel, comma, I am of the opinion that prima facie there is a contempt of court since the order in question was passed in presence of the award debtors and it was never pointed out that the amount would not be kept set apart in the bank accounts of the award debtors but would be kept in some form of allocation under the head of the award debtors. Full stop. Next para. However, comma, this court is of the opinion that since the order pertains to a monetary component, comma, an opportunity to purge the contempt ought to be given to the alleged contemners by depositing the entire amount which the award debtors were restrained from operating with the registrar original site of this court. Full stop. Next para. Learned Assistant Additional Advocate General submits that the same will be done and seeks some time to comply with the said direction. Full stop. Next para. Accordingly, let the matter be listed, let the matter stand adjourned till July 11, 2025, when it will be listed under the same heading. Full stop. The alleged containers shall ensure that the amount of rupees 129,01, 14, 018.76 small p is deposited with the registrar original site. Should it be registrar original site or the registrar general?
Register original side.
Registrar original site by Mr. Shen will give you till Wednesday, next Wednesday, by July 9, 2025. Full stop. The particulars of such deposit shall also be the factum and particulars of such deposit shall also be communicated to the learned advocate on record for the petitioner by his counterpart appearing for the alleged contemners within July 10, 2025 in writing. Full stop. Next para. The amount, comma, as and when deposited, comma, shall be invested in a short-term interest-bearing account stroke scheme with any nationalized bank by the registrar original site and will be subject to the outcome of the execution proceeding. Full stop. This much. The parties shall act on the server copy of this order without insisting upon prior production of a certified copy.
Lord, your Lordship has said deposited, Lord, kindly also make it to be renewed from time to time. Because
No,
the Lordship has said short term,
No, not a bank guarantee. The amount of
fixed, the register will make a fixed
acha.
deposit, that to be renewed from time to time.
very well. It is further clarified that the registrar original site shall take steps for renewing the said short-term interest-bearing deposit stroke scheme from time to time on the verge of expiry of each of its tenures. Thank you.
There's one thing, Lord, we had forgotten in the original order, but now your Lordship is in contempt jurisdiction, that subject to this deposit being made or the security being given, the award should have been stayed.
Lord,
Justice Sarkar.
That's what I'm saying. We forgot when
Yes.
your Lordship passed this order, where Lordship had jurisdiction and determination at that point of time.
that was in execution.
Whatever.
It's in execute. It's for you to move your 36.
I understand that.
36(2) is not moved.
No, it's not moved. It's filed but not
I
moved.
understand that, but I understood it. This is
Mr.
why-
Shen, you can cite this order and
Yes,
get
but
that.
then I'll be entitled to a further deposit because awarded sum also includes interest now after that judgment. And then I'll will give a bank guarantee and take the money.
Thank God the scope of contempt is very limited.
Grateful.
Thank you, Mr. Shen also. Yes.
Reminded of Shylock in Merchant of Venice.
No, it's my money.
No,
I
there was
have
a
put-
question, remember, Mr. Shen, Shylock was more wronged against or wronging?
No wrong.
Yes.
He was
Yeah, I'm more wronged
So-
against
So
because
that
it's my
question
money.
remains.
It was this.
And I always chose to take the side of Shylock. Just imagine the ignominy he suffered because of his community,
because of his community.
even in literature.
And that has
Shakespeare
continued right
recognized that.
now. And now they are making people suffer.
Yes, history has its own cycles, Mr. Shen. Anyway, absolutely
That-
beyond.
To digress,
It will be entirely beyond my jurisdiction.
Millard, to digress, Millard, from heavier topics, Millard, it's my money with which the road has been built.
This is much more heavier than the other topics.
Yes,
It's metal.
it's metal.
Metal road. Free freight.
Heavy metal.
Free freight and transportation for your client. Wait
Colin,
till you back.
Thank you. Thank you. Next. Yes. What is the nature of the content?
Matlab, there was an order, matlab, this is an application or content for willful violation of an order dated 18 July 2024.
The- Paul, they had been directed to
Yes, Matlab, we have served, Matlab. This is a copy of the affidavit of service, Matlab.
good service affected.
Yes, Matlab.
Have you checked up?
Yes, Matlab. Matlab, the track report is there, Matlab. Matlab, they have received, that is in page 8 of the affidavit of service, my lord. Item delivered.
Yes, yes. There's only one contemner.
Yes, my lord, one contemner.
Just show me the order, please, the ordering portion, which has been
My
violated.
lord, in page 19, order dated 18 July.
The direction on the contract to pay the balance amount due to this. Mr. Paul, only one thing. Yes, you were right that arguably contempt may lie, but there was a default clause which says stay granted shall stand automatically vacated. Now, if it's a conditional order, the stay is vacated, you take steps in implementing your order.
My lord,
Why should you issue a rule of contempt? Contempt cannot replace execution.
my lord, order of stay, my lord, there is, my lord, the company is no more there, my lord. My the person, my lord, that was, my lord, the contributor, my lord, he was liable to pay, my lord. My lord, so, my lord, now, my lord, the company there is not in existence, my lord, so that person is running away, my lord, without paying violating the, my lord, court's order, my lord. My lord, even if, my lord.
No, that is not my question, Mr. Paul. My question is whether contempt lies because it was a conditional order.
My lord, conditional order, my lord, there is a, in the order, there is two, if they fail.
Suppose like the previous matter, it was a condition of stay and they were to pay it. Where will issue a rule? The affidavit of service filed today be kept on record, comma, which indicates that service has been properly effected on the alleged contemner. Full stop, next para, however, comma, at the time of call, comma, none appears for the alleged contemner. Full stop, next para. Thus, comma, since a prima facie case of contempt has already been made out, inasmuch as, comma, in gross violation of the order of this court dated July 18, 2024, passed in IA number CA 6/6/2024 in CP /517/2013, comma, the payment due to the security agency petitioner to the tune of rupees 4,45,000.
My lord, one in, I think, my lord, in the order dated 18 July, my lord, it is 4,55,000. My lord, in the order dated 2nd May, my lord, it is wrongly in a written 4,45,000, my lord. My lord, in the ordering portion, my lord, in
2nd May,
my lord, 2nd May in order.
আচ্ছা amount টা quantify করতে হবে না, the amount directed
The payment to the security agency of the petitioner.
as directed in the said order has not been made. Full stop, accordingly a rule to issue calling upon the alleged contemner to show cause as to why the alleged contemner should be penalized in terms of the prayers made in the contempt application for the above act of contempt. Full stop. The rule shall be made returnable on August 8, 2025 at 10:30 a.m. August 10:30 time দিয়ে দেব। Pass over, we take up the next matter.
I appear for the award holder.
Court করব। Yes. Mr. Mitra is to argue today.
Well, I am now appearing for the company. Well, since I have not been deleted, so now I have got locus standi to come before your lordship and assail the award.
Yes.
So, I shall confine my submissions on a short point as to whether the arbitrator had jurisdiction to, my lord, go into the issues. Because, my lord, our submission is this, that this is really a company matter which had the jurisdiction of which, my lord, should have been the company code or the NCLT. This is a short point I shall take, no other point. My lord, other points have been argued by the respondents. I don't want to multiply the submissions.
Thank you.
My lord, I will respectfully first, my lord, show to your lordship the award. Your lordship has got a copy of the award separately or no? My lord, in the compilation, it is there. Volume 2B. page 391 in
Convenience
the
compulsion, yes.
convenience volume.
এটা না? এটা অ্যাওয়ার্ডটা? এটা অ্যাওয়ার্ডটা? Yes, thank you.
Well, I will refer your lordship, my lord, to the, this is, my lord, my lord, kindly take
Companies Act 2013, last company, latest company.
I will just show your lordship, my lord. Kindly come to page 108.
Yes, Mr. Mitra.
Page 108. My lords, this is with regard to jurisdiction, para Roman 10. Your
Yes,
lordship,
yes.
well, if I may just place it, the respondent group A fully participate in the claimant's application for emergency relief and through their counsel raise 3 jurisdictional objections in the course of hearing before the emergency arbitrator. Then first is the claims are not admissible because the claimants have failed to follow the mandatory pre-arbitration steps. I am not making any submission on that. Then the B is the claim advanced by the claimants are not arbitrable under the Indian law, which is the governing law of the SPA and the law of the arbitration agreement contained in SPA, non-arbitrability objection. And C is by submitting to the judicial waiver. I am not, my lord, placing waiver. I am only, my lord, confining my submissions on B. Then your lordship will please to come to page 111. Paragraph 245.
Yes.
245 to 2. This is, my lord, the submissions which were made.
Right.
The respondents group A's objections, non-arbitrability, are twofold. First, they assert that relief sought will affect third-party rights. Following the test articulated in the Indian Supreme Court case of Vidadrolia, a dispute is not arbitrable if inter alia a cause of action and subject matter of the dispute affects third-party rights, have ego omnes effect,
Yes.
require centralized adjudication, and mutual adjudication would not be appropriate and enforceable. In the present case, the rights of third parties, such as the company's shareholders, who are not parties to the arbitration, would be affected by the claimant seeking inter alia the alter in the constitution of the board of directors. Thus, the dispute is not arbitrable. Then second, they argue that the subject matter of the dispute is not arbitrable since NCLT has exclusive power to adjudicate the company law related matters. They assert that the claimants seek to enforce specific statutory rights for which Indian Companies Act vests an NCLT with special powers to enforce such rights. Section 430 of the Companies Act provides inter alia that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal of the appellate tribunal is empowered to determine by or under the Companies Act or any other law for the time being in force. It has been noted to the Supreme Court in Shashi Prakash Khemka that the effect of Section 430 is that the jurisdiction of a court is completely barred in respect of matters in respect of which the power has been conferred on NCLT. Further, the ouster of jurisdiction of a civil court implies that the ouster of jurisdiction of any arbitral tribunal. In the present case, the claimant is seeking to rely on its rights under the Companies Act in order to, for example, gain access to the company's financial documents. Thus, the dispute is not arbitrable according to the respondent. Then, in response, the claimant's position is that no third-party rights are affected by the reliefs the claimant is seeking, and that NCLT does not have exclusive jurisdiction over what are essentially claims for purely contractual nature. First, the claimant states that the relief it seeks does not directly affect the rights of any third parties, such as shareholders. The claimant is merely seeking to enforce the contractual rights under the original SPA, as amended, and has referred to the relevant provisions of the relief sought, directing the respondent to comply with their contractual obligation will not affect the rights of third party. The fact that the sum of the contractual rights and obligations sought to be enforced are matters addressed to some degree in the Companies Act or are consistent with the Companies Act does not result in the relief having ergo omnes effect. Second, the claimants do not fall within the exclusive jurisdiction of NCLT. There is no overlap between the categories of intra-company disputes and the exclusive remedies carved out for the NCLT and the claimant's request for declaration of or injunctive relief. The claimant notes Section 14 of the Companies Act permits alteration of a company's articles subject to NCLT's approval. However, this section only requires such approval where the alteration has the effect of converting a public company into a private company. The claimant's request for the respondent to approve and authorize the amendment of the Companies Act article to reflect the appointment of claimant designee in the company's board does not fall within the scope of Section 14. Then Section 97 and 98 of the Companies Act permit the NCLT to call an annual general meeting of the company that fails to do so itself and call other kind of meeting of members, shareholders, on the application of a voting member or director of the company respectively. First, the claimant requests the tribunal to direct the respondent to convene a meeting of the local board. This is not covered by the subject sections since they concern meetings of shareholders. Second, while the claimant requests the tribunal to direct the respondents to call a general meeting of the company's shareholders in order to amend the articles, this differs from NCLT's power under Section 97 and 98. The subject section only gives the NCLT power to call a meeting and issue procedural directions regarding how the meeting is to be conducted. They do not, as required in the present circumstances, permit NCLT to direct the respondent to convene a general meeting to approve and authorize the amendment of articles or to direct the respondent to actually approve the amendment. The fact that NCLT's jurisdiction under these sections might cover a very limited amount of the relief requested by the claimant, the calling of the shareholders meeting, should not mean that the tribunal lacks the power to grant the entirety of the reliefs requested. Then the claimant also relies on the judgment reported in 2022 SCC, where the High Court of Bombay held that the courts have held that NCLAT does not have jurisdiction to deal with issues relating to enforcement of contractual provisions between the parties, and they have no jurisdiction to decide civil suit of specific performance. The claimant also argues that under the law of the seat of arbitration, its claim as fall within the scope of the parties' arbitration agreement are arbitrable, including the extent that the statutory rights of the relief may be at issue. Then waiver objection, I am not troubling. So these are the submissions which have been recorded.
Yes.
Then your lordship will be pleased to come to now these submissions were ultimately the court.
116.
Yes. Your lordship will be pleased to come to page 116, the tribunal's decision. Paragraph 255.
Yes.
Having carefully considered the party's submission, the tribunal finds it has jurisdiction to hear the present dispute. The respondents' group A's objections are without merit for the following reason. First, clause 14.2.2 of the original SPA reads, in the event that any party assert that there exists an arbitrable dispute, sorry, well, this is, I am not troubling your
This
lordship.
is on the other.
Yes,
objection.
on the other point, I am not troubling your lordship.
Yes.
My lord, kindly come to page 118, paragraph 259. Paragraph 259.
Yes.
Second, quite plainly, NCLT does not have exclusive jurisdiction over the present disputes, given the fact that the parties have expressly agreed to refer their disputes to arbitration. The respondents group A argue that the claimant sought to enforce statutory rights, as a result of which the NCLT would have exclusive jurisdiction. However, the relief sought in this arbitration pertains to enforcement of contractual rights under the SPA and not necessarily or solely rights under the Companies Act. It also bears mention that the Calcutta High Court has found NCLT does not have exclusive jurisdiction over the issue in dispute in this arbitration as set out below in para 263. Well, this is of some importance. The NCLT architecture does not preclude contracting parties from enforcing through arbitration their contractual rights, and no case law or other authority has been cited to this effect. Then para 260. Further, the respondents have also not explained how third-party rights might be affected if the tribunal grants relief sought by the claimant. Although they refer to the case of Vidyat Rolia to argue the dispute is not arbitrable, if inter alia a cause of action and subject matter of the dispute affect third-party rights, have ergo omnes effect, requires centralized adjudication, and mutual adjudication would not be appropriate and enforceable, unquote. This is not relevant. In the present circumstances, the relief sought in terms of the damage is only against the respondent for breaches of the SPA. The injunctions sought relate to enforcement of terms agreed in the SPA, giving effect to the terms and making information available. It is difficult to see how such reliefs ought to be denied on the vague basis that they might affect third-party rights, perhaps those aligned to the respondent. Third, there is also no merit in the respondent's argument on waiver. I am not troubling your lordship. Then, my lord,
You can come to 263 because that has been referred in the previous.
yes, my lord will be pleased to come to,
Calcutta High Court judgment.
yes, my lord, this is kindly come to page 120, 120.
Yes.
263, I should say 119.
Yes.
The tribunal has independently considered the submissions and determined the jurisdiction for the reasons set out above. It bears mention that prior to this decision, the tribunal's jurisdiction has been confirmed on at least 3 separate occasions. First, the emergency arbitrator concluded that she had jurisdiction to hear and grant emergency relief. Second, the Honorable Justice Ravi Kishan Kapoor of the Commercial Division of the Calcutta High Court, when directing the respondents Group A to comply with the emergency arbitrator's order, concluded that there is no question of non-arbitrability. The emergency arbitrator stated inter alia that I find no merit in the argument, the respondent Group A, that the proceeding they initiated against uphill holding before the National Company Law Tribunal is a bar to the arbitration process. The arbitration clause between the parties is wide and explicit. The disputes raised are capable of adjudication and settlement by arbitration. There is no question of non-arbitrability of any of the disputes raised in this proceeding. Then, my lord, C. Subsequently, Justice Kapoor on 23rd August 2023 also unequivocally emphasized the following in his decision to affirm the enforcement affirm and enforce the emergency arbitrator's order. Then paragraph 13 has been quoted. There is also no merit in the argument of the respondent that the proceeding before the National Company Law Tribunal is a bar to the arbitration proceeding. The arbitration clause is a bedrock of any arbitration. The words any dispute, controversy, or claim arising under or relating to the agreement are of wide import and embrace the disputes raised in the present proceedings. Any arbitration agreement is a matter of contract, and the sanctity of the same must be given its full effect. To decide whether a claim falls within the arbitration clause, it is the substance of the claim which has to be seen. One cannot get technicalities or conduct a hair-splitting exercise. A holistic and common sense approach is required to be adopted on the basis of the text of the arbitration clause. On a combined reading of inter alia clause 4.1.8, 4.2.15, and 5.2.1 of the SPA, the dispute raised in these proceedings fall within the scope and ambit of the arbitration clause. Then, my lord, next paragraph. In this background, there is no question of arbitrability of any of the disputes raised in this proceeding. All the disputes raised in these proceedings are covered under SPA and are ex facie contractual disputes. Then the arbitral tribunal is fully competent to consider and decide all other issues, including the jurisdictional challenge of the proceedings having terminated and not the time, terminated or not, and the time period for publishing the award within the extendable time limit or the interplay of laws, if any. The autonomy of the arbitral process must be preserved, unquote. In these circumstances, the tribunal finds that it has jurisdiction over all the respondents in these proceedings to hear the disputes raised. Well, this particular order is an ad interim order. And well, in appeal, ad interim order, which was confirmed by this.
Yes.
This order was passed on, the ad interim order was passed, my lord, earlier, and this was confirmed on 23rd August 2023, against which, my lord, the appeal was preferred. And my lord, the order in appeal, your lordship will please to find that. Compilation and current. My lord, will be pleased to find page 291 of this compilation. My lord, this is a compilation, other side ki copy though.
Compilation.
Well, this is the order day of the division bench dated 6 December 2024. The court is saying,
Yes.
in view of the fact that arbitration proceeding has commenced after the impugned order was passed and has culminated in an award dated 15th March 2024, and a proceeding under Section 48 of the Arbitration and Conciliation Act 1996 is presently pending, we dispose of the appeal with the observation that the decision of the learned single judge with regard to the arbitrability of the dispute in view of the proceedings pending before the National Company Law Tribunal, having the nature of dispute as discussed in paragraph 13 and 14 of the impugned order, would not operate as res judicata, since the said observations was made only for the purpose of deciding the application for interim relief. Therefore, my lord, insofar as that part...
This appeal was directed against the final order which confirmed Justice Kapoor's order.
Yes. And my lord, my submission is this, that in view of this order, the reliance on that part in the award perhaps is not justified. I shall come to that afterwards. My lord, now, this is the position with regard to the submissions made before the arbitrator, the arbitral tribunal. Now, my lord, I will request your lordship, I shall very shortly, I shall present in the form of list of dates, my lord, the chronological list of dates as to what really transpired, which is encouraging me to make this submission. My lord, kindly see, my lord, the proceedings which were undertaken before the Company Law Tribunal at that stage. My lord, before the NCLT, the first initiation of the proceedings took place on 20th September 2022. This your lordship will be pleased to find in this compilation.
Yes.
At page 24. The one that has been handed up to your lordship.
Yes.
This is made by the respondents in the arbitration proceedings. And my lord, the inter alia for delivery and cancellation of certain equity shares and for injunction and various other reliefs. This your lordship will be pleased to find at page 109, the relief. Or I should say page 107. The prayers which were made are all under the Companies Act. The injunction restraining the respondent number 2 from representing and or holding themselves as shareholders of the respondent number 1 company, Then injunction restraining the respondent number 2 and all other persons claiming through under it from dealing with, disposing of, encumbering, transferring on any manner, dealing with the shares of the respondent number 1 company. Then C is injunction restraining the respondent number 2 from holding or convening any meeting pending disposal of the company petition. Then injunction restraining the respondents and all persons claiming through under them from dealing with or disposing of, alienating or creating third-party interest or changing the nature and character of in any manner, any form whatsoever in respect to the movable, immovable, fixed assets of the respondent number 1, that's the company. Then injunction restraining from operating the bank accounts. Then the consequential reliefs are there. On to this application, on 27 September, the claimant made an application. And that is on the, your lordship will be pleased to find in page 137 of this volume. This your lordship will be pleased to find at page 137.
Yes.
This is dated 27 September. Yes. The date your lordship will be pleased to find at page 161. But all these had been raised, these submissions had been made with regard to the jurisdiction of the NCLT. And my lord, kindly see page 150. This is the submission of my lord, the claimant, before the NCLT. The applicant declares that the subject matter of the application is within the jurisdiction of this honorable tribunal and is pursuant to an order dated 26 September passed by this honorable tribunal. And then, my lord, facts of the case had been stated. I am not troubling your lordship with the details of it. Kindly come to the prayer at page 160. Subparagraph 7, Roman 7.
Yes.
The applicant humbly prays with the Honorable Court, direct the petitioner and the company in the captioned petition to give effect to the resolution proposed in EGM held on 26 September 2022 and as voted by poll by shareholders holding a majority of equity shares in the company. B. In the alternative, direct the petitioner and the company to reconvene the EGM to vote upon the resolution proposed in the EGM notice dated 4th September 2022 with the voting done in compliance with section 109 of the Companies Act, that is by way of poll. Then pass directions to convene an EGM which is conducted by a chairperson appointed by this honorable tribunal who is not current employee of the company. Then pass direction restraining the current directors of the company so and so from acting as directors of the company. Then pending hearing and final disposal of the present application, restrain the petitioners from initiating, taking and or pursuing any action, steps or being taken. So therefore, my lord, what I am submitting to your lordship, that even though they contend, and it was recorded in the award, that the rights of the claimant was emanating from the agreement, but my lord, basically the rights are, my lord, are all rights which are given under the Companies Act and enforcement also under the Companies Act. So that was fully appreciated by them and this application was made. Now, my lord, this application, after they made, I suppose, my lord, they were advised that perhaps this application should not be pursued. So, my lord, 11th October 2022, the claimant applied for withdrawal of this application. And that your lordship will be pleased to find in this volume, page 186. It starts at 186. If your lordship comes to page 206, I think. Yes, 206. The relief claimed was allow the applicant to withdraw the 27 September application bearing IA number so and so, read with Rule 11 of the National Company Law Tribunal rules, without prejudice to its rights and remedies available under the law, with liberty to seek appropriate steps permissible under the law. Now, my lord, two things I shall point out to your lordship, that this particular withdrawal, your lordship will be pleased to see.
Paragraphs, I mean, Roman 6
Yes,
may also be important.
yes,
The backdrop of this withdrawal,
yes,
that they want to vindicate their contractual rights,
contractual.
so which is in line with what you were
The
saying.
lordship kindly comes to subparagraph 6, Roman 6, at page 205. The applicant is filing the present application under Rule 44(2), read with Rule 11 of the National Company Law Tribunal rules in the 27th September application defined below, filed in the caption petition CP number.
Last sentence of that, Mr. Mitra, probably
Yes.
is the
The
applicant seeks to
applicant
withdraw.
seeks to withdraw this application without prejudice to its contractual rights and remedies available under law.
And also in para 3, third line, they say without prejudice to its rights available under any contracts,
Yes,
which also might give a clue, which they
yes,
have
my
to
lord,
give,
I shall also in
that
all.
the other dispute is regarding contractual.
Yes, quite right, my lord. I think in all fairness, I shall also point out to your lordship
Yes.
that in the main application, which is your lordship is pleased to see at page 137, kindly, my lord, come to that. That is 137 to 161. I think I should point out that to your lordship also
Yes.
to be. Yes, kindly come to page 159. In the application, my lord, which was made by them, they made this paragraph. That's why I am not pressing the point of waiver. Kindly come to para 25 at page 159. This is in the original application they filed. This application is without prejudice to the contention of the applicant that all matters arising
No,
out of
no question
this-
of waiver, because that they want to withdraw with liberty to sue for those contractual rights.
Yes.
What I meant, Mr. Mitra, is that it may be an indication, you may argue that they withdrew this with liberty to press their contractual rights,
Yes.
and therefore the arbitration proceeding pertains to that contractual rights,
Yes.
which is in
Only.
line with your argument that contractual rights can be specifically performed before an arbitrator, and one need not go to the company tribunal for that.
But I will submit to your lordship that when they are asking for enforcement of the contractual right, they are in fact, my lord, going on the basis of the provisions of the company.
Exactly, indicating, no, they indicate also because they reserve that right to pursue their contractual rights.
But my lord, I will submit to your lordship the contractual rights are such, well, under this SPA. And my lord, the prayers which have been made by them necessarily will involve, my lord, the
Company law.
company law jurisdiction. And this is the point I am making. I am saying that it is not possible to bifurcate, so to say, the contractual rights I pursue before the arbitrator, and so far as company law rights.
That would be their argument. I'm sorry.
Yes, I am meeting that point, my lord, foreseeing as to what argument they will make. My submission is this, that this so-called contractual right that they are claiming is really, my lord, for enforcement of rights under the Companies Act. This is an intra-company disputes, and disputes are between two companies with regard to, my lord, holding of shares.
Mr. Mitra, when they withdrew, the arbitration proceeding had begun.
And no,
That-
I am
can we-
coming to that. Well, I have given your lordship the date, 27th September, 11th October 2022. I am going, that is why chronologically, so that your lordship, well, I shall give your lordship a short list of dates, so that my
Yes.
the next day important date is 25th November 2022. This your lordship will, this date is also important because NCLT allowed on that day, my lord, to withdraw the application. And this your lordship will please to find at page 248. তুমি দেখো না। Well, kindly come to page 248.
Yes.
Paragraph 3, appearing on where the applicant submits, the applicant wishes to withdraw IA number so and so. Senior advocate appearing for the petitioner does not have any objection for simplicity of withdrawal of the application. Accordingly, IA number so and so. Both IAs are accordingly disposed of. So this is the date on which, my lord, the withdrawal took place. Then, my lord, just before that, well, I will show to your lordship. Just before that, on the 3rd of October 2022, the claimant, as the registrant, filed Form 8K pursuant to Section 13 or 15D of the Securities Exchange Act of 1934 in America. This, your lordship, is to find at page 300 of this compilation. At page 300 of this, yes. So this is 3rd October, and my lord, on 11th October, they've made the application, as I told your lordship, applied for withdrawal, and my lord, on 25th November, the withdrawal was allowed. Now, my lord, this application was made by the uphill in INC, your lordship sees at page 300.
Yes.
This they have been described as the registrant in Form 8K. My lord, kindly come to rather small, it is typed up in very small letters. না না ছেড়ে দাও, জজ সাহেব যা পড়ছেন আমিও তাই পড়বো, এখনো পর্যন্ত দেখতে পাই চোখে। জজ সাহেবকে দাও দিয়ে দরকার আমার দরকার। Lordship will please to come to, I am not troubling your lordship of the entirety of this. Kindly come to page of this volume, page 302. Last paragraph. Yes, on September 27, 2022, Holdings filed an application with NCLT to request the NCLT to give effect to the votes by poll of shares, or in the alternative to call another EGM where the prior written order of NCLT would be complied with by Global and Shahbat Azim. On September 30, 2022, the NCLT heard the application and, in accordance with the standard procedure, at the request of the petitioner, granted them an opportunity to submit a written affidavit in response. The NCLT set the matter for hearing on 25th October 2022. Then, my lord, next page. Holdings and upheld intend to the full extent provided for by Indian law to defend against the claims of the petitioner and to enforce the holdings right under the Indian law as the holder of 94.81% of the equity of Global and under the SPA, including the hearing before the NCLT set for October 25, 2022, as well as by way of bringing a petition against the Global board for oppression and mismanagement. Upheld and Holdings are of the position that Azims, having been the beneficiaries of many millions of dollars of consideration paid by Holdings and are upheld as a part of the acquisition of Holdings ownership of 94.81% of the equity of Global, are engaging in fraudulent behavior in asserting the existence of an oral agreement and attempting to deny Holdings ownership of 94.81% of the equity of Global. Now, my lord, therefore, at this stage, that is on 3rd October 2022, the intention was quite clear on the part of the claimant to proceed before the this alternative forum of NCLT. Then, my lord, kindly come to page 304. Kindly come to page 304, internal page 11. The last paragraph, I should say penultimate paragraph. Yes. Prior to the Global board calling the EGM and setting it for September 26, 2022, the non-party Global shareholders had brought both civil and criminal action in India against the Azims regarding the acquisition of equity interest in Glocal held by the non-party Glocal shareholders and alleged mismanagement by the Glocal board and oppressing of the minority shareholders' rights of the non-party Glocal shareholders. The criminal action against the Azims is still pending in India. Therefore, my lord, here also there's some extent your lordship gets the at least my lord some impression that also the non-party shareholders' interests were involved.
But Mr. Mitra, aren't the operation mismanagement and this fraudulent behavior allegations entirely divorced from the present release? I mean, entirely different.
I shall submit your lordship so far as criminal proceedings are concerned. To the extent, my lord, it will have impact on the arbitration proceedings. Apart from it, my lord, I am not going to urge anything of that.
Collateral impact, yes,
Yes.
Mr. Mitra. Collateral impact, does
I
that
am
decide
not going to
jurisdiction?
make any submission on that, my lord. Mr. Bachawat, Mr. Ghosh, and Mr. Thakkar, all three of them have made submission.
Yes.
What I am submitting for your lordship is this, that look at the nature of the reliefs which are sought to be claimed. I shall show to your lordship the nature of the relief, and I shall show to your lordship after the amendment
Yes.
of rather I should say after the new act has come into existence, my lord, the scope has been widened. So much so that now, with regard to the running of the affairs of a company, if it is found that there is mismanagement, my lord, the arms of the court is long enough, my lord, to include everything. What is being sought for in arbitration, there can be sought for, my lord, in the by way of an application under 241. 29, my lord, 39, with your lordship, old section 393, 394, their scope was wide, but now it is wider. That is why, my lord, section 430 has come into existence. That was not there in the old act. Section
430 presupposes that in the first place the dispute has to be amenable to the NCLT jurisdiction.
This is exactly,
Only then 430 comes in.
absolutely. Therefore, my lord, your lordship will have to look into the nature of the dispute raised.
Absolutely. The
And
nature
my
of the
lord,
principal reliefs.
And your lordship will have to see whether it fits in 241, 242.
All right.
So
So
if
wasn't that entirely on the premise of the SPA rights? Entirely.
if it is even if it is on this is my submission, even if it is entirely on SPA, if it is found that the SPA, so far as the provisions of SPA is concerned, it impinges on the right of the either claimant or the respondent, which can be, my lord,
In company.
my lord, can be resolved in under Article 2, Section 241, 242. Then, my lord, I will respectfully submit to your lordship, the existence of the SPA is not by itself good enough. In fact, I was just asking this question to myself, what is it that the claimant is seeking before the arbitrator? It is with regard to the control of the company. It's an intra-company dispute. One company is saying that you have entered into an SPA with me under which you are to transfer your 94% shares. The other company is saying that, look, yes, I will transfer 94% share if you pay me this consideration. What is the consideration? A part, my lord, cash, and a part, my lord, by transfer of shares. Now, if it is found that this particular, my lord, this particular provision has not been complied with, and, my lord, the company which was to transfer the shares 94%, they turn around and say that I am not going to transfer the shares because you have not complied with your obligation under the SPA. Therefore, my lord, a dispute had arisen with regard to the management of the company. So, my lord, 241, 242 comes into existence. So this is my own submission. I mean, if my respectful submission will be that existence of SPA is only in consonance with the provisions of section 241, 242, in case, my lord, one of the parties, my lord, backs out from the SPA and thereby causes oppression on the other party. This is, my lord, this is the concept that I am, my lord, espousing for lordship.
Express the intention to file the
And, my lord, the reason why I am drawing your lordship's attention to this and going, my lord, serially, is for the purpose of showing at least on the 3rd of October 2022, when this Form 8K was filed,
28 September,
or 28 September, sorry.
which was after the DGM.
Yes.
The basis of
My lord, so on the 28th of September, when this was filed, at least up to then, the claimant was interested in proceeding before NCLT. And that will appear from page 303, the first
Yes,
paragraph.
yes, undoubtedly.
My lord, then, after this, my lord, on 24th October 2022, my lord, the claimant was had given the notice of arbitration. This your lordship will be pleased to find in the convenience volume compilation, which has been filed, volume 2 of convenience compilation.
Yes. Volume 2, Part A
Part
or Part B?
Part B, I think.
Part.
I shall just check up and tell you, lordship. Part B. The very first page.
so this is party. So
Kunta eta part A? I'm sorry, my lord.
No.
Kindly give me 1 second.
No, it's all.
Yes, my lord, this is part A. Page 1.
First page, yes.
Page 1, the very first document. 24th October 2022. This is the notice of arbitral disputes under clause 14.2.2 of the share purchase agreement dated so and so. My lord, kindly come to page 3, paragraph 4. While the upheld holdings had attempted to arrive at a workable solution, it is evident that you are deliberately acting in a manner willfully obstruct our interest in local healthcare in a manner detrimental to upheld holdings objectives and interest. Instances of breaches by CET include, then, my lord, 1, obstruction of appointment of upheld holdings designee in the healthcare board. Then 2, refusal to provide locals financial statement to upheld holdings. All, my lord, the company attempt to block access to critical information. Then, my lord, the next one, proceedings before Indian fora in breach of the arbitration agreement you have entered into the same before the NCLT. The aforesaid continuing multiple and egregious breaches, including but not limited to the breaches of SPA, fundamentally impairs upheld holdings investment in local healthcare and amounts to an arbitral disputes under clause 14.2.2 of the SPA. Upheld holdings reserves the liberty to invoke such other clauses. Then, my lord, the clauses have been mentioned here. I am not troubling your lordship.
this one. As well as appeals of right jurisdiction.
My lord, kindly, my learned junior rightly points out, subparagraph I of 4, paragraph 4, the last sentence, it says that you have actively obstructed such appointments by illegally carrying out voting at the designated extraordinary general meeting by show of hands to defeat
So this
the
is paragraph, sorry,
my lord, paragraph 4I
4I.
at page 3.
Yes, yes.
By illegally carrying out voting at the designated extraordinary general meeting by show of hands to defeat the objective of appointment at the EGM in violation of your obligation under SPA, as well as upholds right as majority shareholder in the local healthcare. In fact, my lord, the entire complaint is this: you are committing breach of the agreement, thereby you are violating my right as the majority shareholder. He is claiming to be the shareholder. My lord, I submit to your lordship this, that what is the dispute between the parties? Dispute between the parties is this, as I have been able to understand, that there was an agreement to transfer 94.1% shares by the claimant, by the respondent to the claimant. Now, the respondent did not do so. The reason given by the respondent is company is this, that look, you are to pay me by way of consideration this amount, partly in cash, partly by transfer of shares. You did not do so. So if since you did not do so, you are not entitled to have your consideration failed for the entirety of the amount. Even 94.1% you are not entitled, but you have paid me in cash. The cash amount covers 16.4% of the shareholding. Therefore, you are entitled to 16.4 share. This is the in summary and this particular issue in my very respectful submission. I am sure, my lord, if the matter is taken up before the NCLT, my lord, the SPA will come in to the picture. It is not that the SPA will be, but SPA will form a part of the proceedings for operation and minority. The court will, I should say, the tribunal will have to look into this particular document for the purpose of finding out, has there been really operation of the minority shareholder? Is it that the claimant is entitled to get this entirety of the shareholding? And if not, what relief can be given? Your lordship says, I shall presently place before your lordship 241, 242, the extent of the power of the NCLT for the purpose of giving relief. Whatever relief is possible, the NCLT can give it. It is almost, my lord, replacing, my lord, the court's jurisdiction. It is an alternative fora before which, my lord, what right could have been espoused before a court of law by way of arbitration or by way of a suit. My lord, the NCLT has come into the picture for the purpose of doing that. So this will be my ultimate respectful submission. So, my lord, this is 24th October 2022. There's notice of arbitration. Then, my lord, on 4th November 2022, the claimant requests for arbitration before the International Chamber of Commerce. This your lordship will be pleased to find at page 27 of this volume. The request for arbitration is from 27 to 122 pages. So various complaints have been made. Kindly look into, my lord. I don't want to trouble your lordship with this entirety of it. Well, kindly come to, after quoting, my lord, the provisions of the SPA, kindly come to page 68. Your lordship sees, my lord, paragraph 6, page 68, paragraph 68.
Yes.
Claimants also has the right as a supermajority shareholder of local healthcare under Indian law. Pursuant to SPA, claimant received a good and marketable title to the transferred shares of local healthcare, free from all encumbrances. In addition to its right with respect to local healthcare, claimant is entitled to additional rights under the Indian law as a shareholder of local healthcare. The additional rights set forth below are relevant to the claimant's claims in this arbitration. Kindly see 68.1, right to alter the articles of association. Then 68.2, right to vote on resolution. Then 68.3, right to call a general meeting. 68.4, right to appoint chairman of a meeting. 68.5, right to inspect the financial statements. Then 68.6, right to appoint directors.
They give the relevant sections of the Companies Act also.
Yes.
Obviously.
Well, I shall just draw your lordship. Right to remove directors.
They themselves mention the relevant sections.
Yes.
They claim the rights under those sections.
Absolutely. My lord, the grievances which have been made here is, my lord, basically that in violation of the SPA, what you are doing is contrary to the provisions of law of the Act. Well, there was thereafter, these on 4th November 2022. Then on 8th January 2023, there was an amended request for arbitration. This your lordship will be pleased to find at page 127 of this volume. This is the amended request for arbitration. Of course, they are relying on the SPA, no doubt about it. And then again, my lord, at page 172, there, my lord, the claimant is claiming
Similar.
as supermajority shareholders, the same prayers are there. And these are all, my lord, covered by this by 241, 242. This is also here. এখানে দেখো। এখানে না, in the amended one. But we'll kindly give you 1 second. Page 107. I am looking into, I am trying to find, my lord, if there is similar এটা কোথায় page 107 কোথায়? এরকম corresponding এটা আছে এখানে? Well, Lord, kindly come back to page 107 once. I am just trying to find out whether in the amended request for arbitration, this clause is there.
Page
107. Kindly come back unamended.
Yes.
Once more, I'm requesting your lordship to come back to the 107
Yes.
B.
Yes.
Respondents Group A has obstructed claimant's exercise of its statutory rights under the Companies Act. And they say that it, in addition to their breach of SPA, in fact, my lord, this failure to, rather obstruction to exercise statutory right is, my lord, flowing from the SPA.
Mr. Mitro, if the rights can be if the claims can be segregated,
Yes.
they specifically say these rights are not under the SPA, under the Companies Act. So then these rights, obviously, as per their admission, do not emanate from the SPA and so are amenable to the NCLT jurisdiction. If that be so, if those can be segregated,
My lord,
now the award has been passed, so we have to look at whether any of these were granted by the.
yes, I will take your lordship to the award itself. I am just showing to your lordship at
Yes, they clearly say there is no, they don't mince words. They say, in addition to breach of SPA, under company law, we have these claims. So they clearly distinguish between the SPA claims and the claimants. Apart from your other argument regarding the SPA claims, also you have a good argument.
your lordship. Well, I quite appreciate what is following from your lordship, whether it can be segregated one from the other. One,
At least regarding these portions, additional claims.
well, I will submit to your lordship that when your lordship looks into the claim, your lordship will be pleased to find that the provisions of SPA are such that they are enforceable under the
Yeah,
company.
Mr. Mitra, there are two parts of your argument. One, regarding these, it's pretty obvious that they themselves admit that these are not under the SPA. They say, in addition to the breach of the SPA, we have reliefs under company law.
Right.
So these are palpably amenable to the NCLT jurisdiction. regarding the other part which they say flows from the SPA also, although the rights have been recognized in the SPA, in the garb of vindicating those rights, what they're seeking is to invoke the company law jurisdiction.
Right.
So therefore, it has to go to the NCLT. These are two parts. This is more in your favor. I mean, this is very clear that they say themselves that under the company law, apart from the SPA. But the SPA claims that's a different argument of yours.
Yes, of course. But then again, my lord, I am trying to put it
Mix up the two.
yes, I'm trying to mix up the two in this because, my lord,
Yes.
if when your lordship is thinking in terms of enforcement of the provisions of the SPA
Yes.
in favor of the claimant, in fact, those are the very provisions which, my lord, the Companies Act permits under this act. So what happens is this, it is almost like this, that a suit has been filed. Suit has been filed, my lord, which is under a particular provision of an agreement. It is found that the provisions of the agreement are such that this is covered
By the law.
by the law. So then I will submit to your lordship, it will be not possible for your lordship, or rather for the claimant, to separate one from the other. They have been so mixed up together that for the purpose of enforcement of a right under the SPA, where the provisions of the Companies Act comes into existence. In other words, what I mean to say is this: if the provisions of the SPA which you are seeking to enforce are enforceable under the Companies Act, then Section 430A comes in.
Suppose you and I enter into an agreement which quotes the provisions of the Premises Tenancy Act 97, quotes the provision,
Lordship.
and say that I can evict you only if those provisions, Section 6 is quoted, and say that if these are satisfied. And if I go and file a suit, I say I seek a specific performance of that agreement. In effect, what I am doing is invoking the statutory provisions
Absolutely.
in the garb of specifically performing that agreement. So that's governed by the statute. It should go before the designated court under the 97 Act. This is a very bad example, but it is not so obvious here. It's nuanced, but the same thing you are saying.
This is exactly what I'm saying. I'm saying that you are seeking to enforce SPA, no doubt about it. But then again, those provisions which you are seeking to enforce are
Right.
covered by, my lord, this
The company law.
provisions. And therefore, if that is so, then you will have to go with the-
NCLT prevails.
Yes,
Jurisdiction.
because Section 430.
430. Yes.
Well, kindly see, my lord, in this connection, let me place Section 430, because this has been, Supreme Court has taken note of this particular provision. And this provision, my lord, kindly note, it was not there in the old act.
Vidyadroliya gives primacy to NCLT.
Absolutely.
430. If there is a conflict between arbitration and, because it has been an analogy has been drawn, if a civil court jurisdiction is barred, arbitration is also barred.
Right.
Because arbitration virtually replaces civil
Right.
court.
Yes.
So if that be so, then you say it's not the other way around. If it's covered by the Company Act, has to go before the NCLT under 430.
That is the only submission that I'm making. Well, this particular provision, I was just wondering, what can be the intention of the legislature? The legislature might,
Section 430.
yes, 430. Kindly, my lord, take
430, Mr. Mitra, is very obvious. It's very clear, but for 430, for invoking 430, we have to look into the other provisions also, 241, 242, whatever.
Of course.
Because we have to go to the principle whether this power is granted to the NCLT in the first place. 430 says if the power is given to the NCLT, it has primacy.
My lord, what I am emphasizing on is this:
Yes.
that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or appellate tribunal is empowered to determine. So, my lord, your lordship will have to see as to whether the tribunal or the appellate tribunal is entitled to determine this. By or under this act, or any other law for the timing in force, and no injunction shall be granted by any court or any authority in respect of any action taken or to be taken in pursuance of any power conferred by or under the act, or any other law for the timing in force by the tribunal or the appellate tribunal. Well, that absolutely wide power has been given. It's a couched in very wide language. Complete embargo. Complete embargo. You do not go to court if otherwise it is found that this particular authority has the power to determine this very issue. Now, the issue before your lordship is this: are the questions which are involved in the arbitration such that this is covered by any of the provisions of the Companies Act. And my lord, which can be determined by the Company Law Tribunal in to the exclusion of a civil court.
Hmm.
I was, therefore, my lord, kindly keep this in mind. And my lord, I shall draw your lordship's attention after I've shown to your lordship these factual. I shall come back to this issue, very issue I shall come back. Now, my lord, I have shown to your lordship the amended request for arbitration. Page 225. Na? 24. Yes, my lord, at page 224 of the amended request for I've shown to your lordship, my lord, 170. Now 224 in the amended request for arbitration, similar submission is there in B.
Hmm.
Respondents group A have obstructed claimant's exercise of its statutory rights under the Companies Act. Page 220.
Yes, yes, I've got.
Then, my lord,
The sections are quoted from the Companies Act, in fact.
yes.
There's no doubt that these are under the company.
Then, my lord, on 22nd June 2023, in the chronology of events, the claimant filed his statement of claim before the tribunal. And my lord, the reliefs claimed are contained in the award itself. If your lordship, my lord, takes the award, para 208 at page 93. Internal page 93.
Yes, amended
Uh,
reliefs.
Paragraph 208.
Right.
Claimant amended the relief, and these are the amended reliefs. Declaring that Upheld Holding holds so and so equity shares, 95.29 of the total equity shares, then 25,000 and odd preference shares, which constitutes 37.52 of the total preference shares, then 94.81 of the total equity share plus preference shares in Global Healthcare. Declaring that Upheld Holding has good and marketable title over its shareholding in Global Healthcare, detailed in para 463.1 above. Then free and clear of all encumbrances and together with all rights, title, interest, benefits, appurtenance thereto. Then issuing permanent mandatory injunction pursuant to clause 5.2.1 of the original SPA, directing respondent to take all necessary steps to convene a meeting of the local board to appoint the Upheld Holding and so and so, and at the meeting approve and authorize. My lord, this is, of course, as I was submitted to your lordship, this is in terms of clause so and so of the SPA. But this is exactly what so this is what I am saying. So one is interlinked with the other. Then pursuant to clause 5.2.1 and 12 of the original SPA, directing respondent both individually and jointly to file form DIR, DIR 12 with the jurisdictional registrar of the company, with the jurisdictional registrar of companies in relation to appointment of Upheld Holding designee in the local board. Then 3, pursuant to clause 5.2.1D and 12 of original SPA, directing respondents both individually and jointly to provide Upheld Holdings with true extracts duly certified by the local board. These are all, my lord, can be granted by the company.
So, Mitro, I'll be coming back in a minute and in 5 minutes, and I'll be asking you that please just apprise me on whether, because the principal reliefs are 463.1 and 2
Yes.
declaration, whether these two declarations can be granted by the NCLT,
I shall show you.
and if so, under which provisions? 463.1 and 460, because those are the principal reliefs.
Yeah, these are the principles. Correct.
Yes, sir.
Absolutely correct.
Comfortable. Just come back in 5-6 minutes and
I'm my lord.
Yes.
No, my lord, I will request your lordship to take, my lord, the Companies Act, section 241, 242.
Right.
I would like to, my lord, go slowly on this. Because the powers are enormous.
Yes. Yes. Sir.
Application to tribunal for relief in cases of oppression, etc. That is the title of section 241.
Right.
Any member of a company who complains the affairs of the company have been or are being conducted in a manner prejudicial to public interest or in a manner prejudicial or oppressive to him or any other member or members or in a manner prejudicial to the interests of the company. Now, I pause here for a moment. Public interest for the time being, I am not taking into account. In a manner prejudicial or oppressive to him. Here, my lord, the claimant is saying that it is oppressive to me because after agreeing to give me 94.1% shares, they are not doing so. And oppressive to him or any other member or members or in a manner prejudicial to the interests of the company. Then, my lord, the material change not being a change brought about by or in the interest of the creditors, including debenture holders or any class of shareholders of the company.
Mr. Mitra, are they members of the company?
My lord,
That is the prerequisite. Any member of the company can do this.
a person, my lord, who is claiming, who is contending that I should be a member
He
of
wants to be a member, but
yes,
in the first place, shouldn't he be a member
But-
to make the complaint?
my lord, he is a shareholder, my lord. He has come onto the records of the company as a shareholder.
But that is pursuant to the orders of the tribunal.
No, not really.
Prior to that,
Prior to that.
then
Prior to that. But he is complaining that even though I am a shareholder, I am not being allowed to exercise my rights as a shareholder. Your lordship knows, my lord, the definition of the member
yes,
in relation to a company. It is, my lord, definition section, section 2, subsection 55. Member in relation to a company means the subscriber to the memorandum of company, then every other person who agrees in writing to become a member of the company and whose name is entered in the register of members of the company, and every person holding shares in the company and whose name is entered in as a beneficial owner of the records of the depository. He is, my lord, what is being contended is this, that I am the owner of 94%, but I am not being allowed to exercise my right as a 94% shareholder of the company.
Right.
But perhaps so far as 16 point something percent is concerned, that is there. That
he is a registered.
Yes.
He is registered in there. So
and then, my lord, subsection 2, material change not being a change so and so, whether by alteration in the board of directors or manager or in the ownership of the company's shares, or if it has no share capital in its membership or in any other manner whatsoever, that by reason of such change, it is likely that the affairs of the company will be conducted in a manner prejudicial to the interests of the members of the class. Then subsection 2, powers of the tribunal. If this is the position, one may apply. Then the powers of the tribunal, if on application made under section 241, the tribunal is of the view that the company's affairs have been or are being conducted in a manner prejudicial or oppressive to any member or members, or prejudicial to public interests, or in a manner prejudicial to the interests of the company, and that to wind up the company would unfairly prejudice the member or the members, but that otherwise facts would justify the make of the winding up, or on the ground that it is just and equitable, but this ground has not been mentioned, the tribunal may kindly see the
wide, very wide.
with a view to bring an end to the matters complained of, makes such order as it thinks fit. So, my lord, in order to put an end to the complaint made by the claimant, the tribunal has such power that in order to bring that particular complaint to an end, that it can pass any order as it thinks fit. Similar, my lord, kindly see the opening words of subsection 2. Without prejudice to the generality of the powers under subsection 1, an order under that subsection may provide So, my lord, this is a general power.
Hmm.
Without curtailing that power, the subsection 2 is giving indications of the nature of the power that can be exercised by the company law board. A is the regulation of the conduct of the affairs of the company in future. That is absolutely,
Yes.
covers everything. Then B, the purchase of shares or interest of any member of the company by other members thereof or by the company. Here also, my lord, that power is there. Then in the case of purchase of its shares by the company, as aforesaid, it's not relevant, the consequent reduction of its share capital. Then D, restrictions on the transfer or allotment of shares of the company. Then the termination, setting aside, modification of any agreement, howsoever arrived at, between the company and the managing director or any other director, this doesn't apply. Kindly come to F. The termination, setting aside, or modification of any agreement between the company and any person other than those referred to in subsection E, provided that no such agreement shall be terminated, set aside, or modified, except after due notice and after obtaining consent of the party concerned. Then setting aside of any transfer, delivery of goods, payment, execution, or any or other act relating to property made or done by or against the company within 3 months before the date of application under this section, which would, if made or done by or against the individual, be deemed to be his insolvency or to be fraudulent preference. Then removal of managing director, then recovery of undue gain made by the managing director, manager, director during the period of his appointment as such, and the manner of utilization of the recovery, including transfer to investor education and protection of fund or payment. Therefore, my lord, under this clause, the company law board has, my lord, the NCLT has the right to recover any undue gain made by managing director, manager, or director during the period of his appointment as such. Well, therefore, my lord, this is my recovery of money. Then, my lord, appointment of subsection K is appointment of such number of persons as directors who may be required by the tribunal to report to the tribunal such matter. Then imposition of costs. Any other manner, this M is very important also.
Yes.
Any other matter for which, in the opinion of the tribunal, it is just and equitable that the provision should be made. This, my lord, covers everything.
And A also, in fact, in your case.
A and M.
Yes.
And my lord, ultimate purpose is to bring to an end the matters complained of. So, in order to, my lord, bring to an end the matters complained of, the tribunal can pass any order, such order as it thinks fit. Now, my lord, kindly, in connection with that, kindly come to section 59 once. The tribunal has this power also.
Yes. Yes.
If rectification of registrar members, if the name of any person is without sufficient cause entered in the register of members of a company, or after having been entered in the register without sufficient cause omitted therefrom, or if a default is made, this is one, or unnecessary delay takes place in entering in the register, the fact of any person having become or ceased to be a member, the person aggrieved or any member of the company or the company may appeal in such form as may be prescribed to the tribunal or to a competent court outside India, specified by the central government by notification in respect to the foreign members or debenture holders residing outside India for rectification of the register. So this also covers it.
Yes.
So in the light of this, if your lordship looks into these prayers made, I will submit to your lordship that there is nothing, even though, in fact, my lord, I will submit this way, that if a complaint is made before the NCLT, in terms of prayer at paragraph 463.3I and II. Then, my lord, the NCLT will also take into note of the SPA, the provisions of SPA. Because this is, the court, the NCLT will have to proceed on the basis that I am doing something in order to bring to an end the matters complained of. And if that is so, my lord, SPA will be one of the factors NCLT will take note of for the purpose of bringing an end to the grievances complaint. Kindly, my lord, come to section 243. Section 243. Where an order made under section 242 terminates, set aside, or modifies an agreement such as is referred to in subsection 2 of that section. Such order shall not give rise to any claim whatsoever in the company by any person or damages or compensation for the loss of office or any other respect, either in pursuance of the agreement or otherwise. No managing director or director of the company, etc. terminated. So, my lord, this is, my lord, preventing the damage being, the award of damages being given. Subsection 5. Then, my lord, kindly come to subsection 5 of section 242. Where an order of the tribunal under subsection 1 makes any alteration in the memorandum or articles of the company, then notwithstanding any other provision of this act, the company shall not have power, except to the extent, if any, permitted in the order, to make, without the leave of the tribunal, any alteration whatsoever which is inconsistent with the order, either in the memorandum or in the article. My lord, what I am submitting to your lordship is this, that if and when the matter goes before the NCLT for the purpose of considering the application made by the respondent under section 241 and 242, then, my lord, the NCLT has the power to go into the matter, including looking into the SPA.
Mr. Mitra, are you fettered by 244?
244. Right to apply under the following members of a company shall have the right to apply under section 241, namely, in the case of a company having share capital not less than 100 members of the company or not less than 1/10 of the total number of shares.
Because this is not a class action.
No. In case of company not having share capital, B doesn't apply.
A.
Less than any member or members holding not less than, my lord, in the instant case, the company, my lord, the company is complaining that I have got 94% shares in the company and I am entitled. That is why, my lord, they went before the company law tribunal under section 241, 242. And they are complaining that I am not being given the benefit of 94.1.
All right.
This is one of the grievances.
So, member holding not less than 1/10.
Yes. And in any event, my lord, 16.14%, that is also more than 10%.
Exactly.
As on date,
As per the current holdings also.
on date, the register is still 94%. ROC has not changed. So one of this you can show there. Why did you
Let it 244.
244 position?
Yes.
May on an application waive
Let-
all or any of the requirements.
Very well.
My lord, kindly come to subsection 2 of section 244.
Yes.
where any member of the company are entitled to make an application under subsection 1, any one or more of them having obtained the consent in writing of the rest may make an application on behalf of or benefit from. Well,
This is not.
uh,
244(1)(a) is sufficient,
yes.
more than 10%.
So, my lord, this is these are my respectful submissions on the this as to whether the on the jurisdictional point. Now, my lord, I take your lordship, my lord, to the some of the decisions
Yes.
on this. My lord, kindly come to class action can only. No, class action actually. My lord, kindly take, my lord. I will rely upon 3 decisions and I shall conclude my submissions.
Thank you.
My lord, first is 2019 18 Supreme Court cases 569. This is a very short judgment.
Yes.
This was, my lord, under 1956 Act, 111A. And, my lord, the Depositors Related Laws Act. My lord, kindly take, my lord, at section 430 had been considered here. That is
Yes.
why I am citing this. Paragraph 4. The learned counsel for the appellant has drawn our attention to the views expressed in ammonia supplies to canvass the proposition that while examining the scope of section 155, the predecessor to section 111, a view was taken that the power was fairly wide, but in case a serious dispute as to title, the matter could be relegated to a civil suit. The submission of the learned counsel is that the subsequent legal development to the impugned order have a direct effect on the present case, as the Companies Act 2013 had amended which provides for the power of rectification of the register under section 59 of the Act. The learned counsel has also drawn our attention to section 430 that has been quoted. The effect of the aforesaid provision is that in matters in respect of which power has been conferred on NCLT, the jurisdiction of the civil court is completely barred. Then it is not in dispute that where a dispute to arise, today, the civil suit remedy would be completely barred and the power would be vested with the National Company Law Tribunal, NCLT, under section 59 of the Act. We are conscious of the fact that in the present case, the cause of action has arisen at a stage prior to this enactment. However, we are of the view that relegating the parties to civil law now would not be the appropriate remedy, especially considering the manner in which section 430 of the Act is widely couched, widely worded. We are thus of the view that the subsequent development, the appropriate course of action would be to relegate the appellants to remedy before NCLT under the Companies Act 2013. এটা হচ্ছে না ডোলিয়া না ওকে দিলে যাচ্ছে
This was under 142, relegating to the, because Article 142, because savings clause is there.
Yes.
But Supreme Court felt it this. But paragraph 5 is very clear, wide,
Very wide.
completely barred.
My lord, I will request your lordship to, this has been cited before lordship in number of occasions, but my lord, I will just place a few of the paragraphs. This is, my lord, with the Drolia.
Yes.
2021, two Supreme Court cases, page 1. At paragraph 40, there is a quotation from my lord, Booz Allen, relying upon Ayasami's case. My lord, paragraph 40, my lord, I will request your lordship to come to page 56. Copy
Now I can follow it from a tab. We don't have a copy, no difficulty.
No, we have got copy. Of course.
The tab would be better probably.
তোমার copy দেবো। এত মোটা বইয়ের মতো।
আমরা এইটাই এক্সচেঞ্জ করেছি অনেকবার।
Well, this has been, as my learned friend says, this has exchanged hands so much.
Yes, exactly.
He has got back his
Everybody has a copy. Has
Has
multiple
got back his
copies, in fact.
Well, paragraph 40, my lord, see, from Booz Allen. This comment has been made.
Booz
Para 35 has been quoted. The court held that this class of actions operates in rem, which is a right exercisable against the world at large, as contrasted with a right in personam, which is an interest protected against specified individuals. All disputes relating to rights in personam are considered to be amenable to arbitration, while rights in rem are required to be adjudicated by courts and public tribunal. Hence, in addition to various classes of disputes, which are generally considered by the
But this was in a different context. This was
Yeah,
held
the
order
Booz Allen-
34.
Yes, that is right. But here, my lord, what is being said here is, my lord, my submission before your lordship is this, in this case, ultimately, if the reliefs are granted as they have asked for, this is not going to affect only these persons concerned. This is going to affect, my lord, all the other shareholders of the company. Change of the articles of association, change of the agreement.
Mr. Mittu, isn't that a collateral effect? I mean, yes, incidentally that happens,
Maybe
but
collateral.
the cause of action is against the company.
My lord, in every case,
Every case, yes,
in
somebody
every
would
case,
be
cause
right.
of action is against an individual, but its ramification is if it's, my lord, others are taken in within the.
But
within its-
241 and 242 cannot be said to be in rem proceedings.
No, but there is a class.
They are not recognized under the Evidence
Sir,
Act as in rem proceedings.
Since your lordship is very interesting,
Yes,
your lordship will please to see
yes.
241, 242 is not confined to, my lord, any personal days. Kindly, my lord, come to
Yes.
245.
Two 245 is on a different foot, class action.
But these are all.
Then
kinds-
Order 1 Rule 8 also, Mr. Mitra, has a in rem ramification. Order 1 Rule 8 of the Code of Civil Procedure. That's a different concept.
my lord,
Class action is representing a class. That definitely has wider ramifications.
well, after the last judgment, well, I'm just forgetting the name of the judgment decision.
Yes.
The trust matter has been brought in because in case of trust also,
Yes.
it is an individual fight by one against another individual. But since trust, my lord, is comprehends a lot of other people also, their interest, that has also been.
But in rem means against the whole world.
2016 it is, no? Whether additional thing was. Well, this is. Yes, and well, I shall show.
Very well. We'll
call
come to
lordship
that later.
attention to that.
No difficulty. We'll just come to that.
Lordship will please.
So let us carry on with para 40 you are
Yes,
placing. Yes.
para 40. Now your lordship will please to come to para 76. My lord, numerous judgments have been considered here, and then in para 76, it's a sort of conclusion from all these. In view of the above discussion, this is page 72.
Yes.
We would like to propound a fourfold test for determining when the subject matter of a dispute in an arbitration agreement is not arbitrable. 76.1, where the cause of action and subject matter of the dispute relates to action in rem and do not pertain to subordinate rights in personam, that arises from the rights in rem. Then 76.2. When the cause of action and subject matter of the dispute affects third-party rights, have agra omnes effect, require centralized adjudication, and mutual adjudication would not be appropriate. Then 76.3. When cause of action and subject matter of the dispute relates to inalienable sovereign and public interest functions of the state, we are not concerned. Then 76.4. When the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per mandatory statute. This is something, my lord, I am going to rely upon. Then 76.5, these tests are not watertight compartment. They dovetail and overlap, albeit all when applied holistically and pragmatically will help to assist in determining and ascertaining with greater degree of certainty when, as per law in India, a dispute of subject matter is non-arbitrable. Only when the answer is in the affirmative that the subject matter of the dispute would be non-arbitrable. However, the aforesaid principle have to be applied with care and caution as observed in Olympus. Then para 77. Applying the above principles to determine non-arbitrability, it is apparent that the insolvency or intra-company disputes have to be addressed by a centralized forum. I'm relying upon this. Applying the above principles to determine non-arbitrability, it is apparent that insolvency or intra-company disputes have to be addressed by a centralized forum, be the court or a special forum, which would be more efficient and has complete jurisdiction to efficaciously and fully dispose of the entire matter. There are also actions in rem.
This is the answer to my question.
There are also actions in rem. Similarly, grant and issue of patents and registration of trademarks are exclusive matters falling within the sovereign or government functions and have agra omnes effect. Such grants confer monopoly rights. They are non-arbitrable. Criminal cases, again, are non-arbitrable as they relate to sovereign functions of the state. Further, violations of criminal law, I am not going to trouble your lordship on that, my lord, the submissions have been made. Therefore, my lord, I am relying upon this judgment for this proposition, my lord, that even in case of, my lord, intra-company disputes, this is more efficient and complete jurisdiction, my lord, if it is disposed of by, my lord, a centralized forum or my lord, civil court.
To be disposed.
And my lord, the language is very imperative. Intra-company disputes have to be addressed by a centralized.
And the next sentence is it's a judgment in rem.
And has complete jurisdiction to efficaciously and
In rem matters cannot be arbitrable.
Right.
No in rem matter is arbitrable. That is one of the, you know, Mr. Mitra, much better than us. That is one of the characteristics of non-arbitrability.
Yes.
Matrimonial, probate.
Well, this is one judgment. The last judgment I am placing, my lord, is NN Global.
Yes.
That is, my lord, 2021, volume 4. Volume 4, my lord, Supreme Court cases, page 379. Just a copy did you?
NN Global. This has also exchanged hands.
This is also,
so many times.
well, these judgments.
NN Global, there are several Vidyadroliyas and NN Global judgments, in fact. So,
Right.
Maybe a possibility I'm getting what I had supplied to them.
exactly right. You're right. Like giving a birthday gift and getting it back.
Getting it back.
Well, kindly come to page 429. 429 to 433. Well, kindly come to paragraph 40.
Yes, Mr.
In our view, all civil or commercial disputes, either contractual or non-contractual, which can be adjudicated upon by a civil court, in principle, can be adjudicated and resolved through arbitration, unless it is excluded either expressly or by statute or by necessary implication. Well, I am emphasizing on this unless. The Arbitration and Conciliation Act 1996 does not exclude any category of disputes as being non-arbitrable. Section 2, subsection 3 of the Arbitration Act, however, recognizes that the certain categories of disputes by law may not be submitted to arbitration. In all adjudications, certain categories of disputes are reserved by the legislature as a matter of public policy to be adjudicated by the court of law, since they lie in the realm of public law. Traditionally, disputes relating to rights in rem are required to be adjudicated by courts and or statutory tribunals. A right in rem is a right exercisable by the world at large. Actions in rem refer to actions which create legal status such as citizenship, divorce, testamentary and probate issues, etc. A lis in rem is not arbitrable by a private tribunal constituted by the consent of the parties. Actions in personam determine the rights and interests of the parties to the subject matter of dispute, which are arbitrable. The broad categories of dispute which are considered to be non-arbitrable are penal offenses, which are visited with the criminal actions, offenses pertaining to bribery, corruption, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody and guardianship matters, which pertain to the status of a person, testamentary matters, which pertain to disputes relating to validity of a will, grant of probate, letters of administration, succession, which pertaining to the status of the person.
Admiralty is also probably recognized by the evidence sectors.
Yes, well, these categories are gradually increasing.
Yes,
There are three,
carved out.
5, now my lord 7.
Right.
Then my lord, this court in Booz Allen and Hamilton, oh sorry,
No,
para
43 is important.
43, very important. Certain categories of disputes such as consumer disputes, insolvency and bankruptcy proceedings, oppression and mismanagement,
Yes.
or winding up of a company, disputes relating to trusts, trustees and beneficiaries of a trust are governed by special enactments. So special enactments, governed by special enactments is an important factor. This court, my lord, Booz Allen, kindly see there are 6 categories were given. Disputes relating to rights and liabilities which give rise to criminal offenses. Then 2, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody. Then guardianship matter, then insolvency and winding up matter, then testamentary matter, grant of probate, and 6 is eviction of tenancy matters, etc. Then, my lord, para 45. The civil aspect of fraud is considered to be arbitrable in contemporary arbitration jurisprudence, with the only exception being where the allegation is that the arbitration agreement itself is vitiated by fraud or fraudulent inducement.
Probably 45 onwards is not really.
Not relevant. Then, my lord, kindly come to, I am not going to trouble your lordship, kindly come to page, paragraph 54. No, paragraph 54 is not.
No.
Well, this is, well, therefore,
Yes.
I am submitting to your lordship that this particular judgment has gone one step further and has said that the case of operation and mismanagement and winding up of a company are matters which perhaps should not go before arbitrator. That is one fact thing that has been recorded. And my lord, Indian Global has also in paragraph 40 says, unless it is excluded either expressly by statute or by necessary implication. Paragraph 40 and paragraph 43 are very important for the purpose of this.
Also para 77 of Vidadrolia.
Yes, with the
Intra-company.
yes. In this matter, in this case, my lord, para 40 and 43. So, my lord, this is the
Just to indicate, we fall under 40. Yeah. About 40.
and my lord, your lordship kindly sees takes my lord section 48
Yeah.
of the Arbitration and Conciliation Act. This is with regard to the enforcement of foreign awards.
Yes.
2, subsection 2B.
Is subject matter not capable of
Enforcement of an arbitral award may also be refused if the court finds that the subject matter of the difference is not capable of settlement by arbitration under the law of India, And the enforcement of the award would be contrary to public policy of India. 42A, my lord, perhaps will be, your lordship can look into. The subject matter, the difference is not capable of.
Absolutely.
Well, these are my respective submissions.
Thank you. So are all the respondents finished? No.
The respondent
someone
number
left?
6, the last respondent,
Who is it?
Mr. Abhijit Mitro, will be leading in that matter.
Where is he?
My lord, he's currently, my lord, may kindly keep it next week, he'll complete next week, I'm told. My lord, the last of the submission.
Very well. Heard Mr. Jayantu Mitra, comma, learned senior advocate appearing for the respondent company. For further arguments, comma, let the matter stand adjourned till July 11, 2025. Yes.
Great.
Thank you. This is the journey to the center of the earth.
Yes, with the tunnel boring machine.
Jules Verne. Yes.
So Lord, we were addressing on the issue of perversity because it has been our consistent case before your lordship in the petition for setting aside that our reports that we had placed, the experts that we had engaged to show, my lord, that it was the fault on the part of the contractor to maneuver the TBM. Because, my lord, the claimant, that is the respondent, had, my lord, filed or, my lord, submitted the report of the Herrenknecht, which is an expert or which is the tunnel bore, the machine manufacturer. There was no problem with the machine. In fact, my lord, the inflow of water inside the TBM was on account of improper maneuvering on the part of the TBM. Now, my lord, the second aspect of the award is, my lord, the role of our engineer, that is GC, that is the general consultant. What the arbitral tribunal felt was, my lord, that the general consultant did not foresee or there was the non-compliance of GC's direction. It was, since it has been the argument that GC is my engineer and there is a contract that we had entered into with the GC. GC is my engineer. It was GC's responsibility to supervise and foresee the eventualities that might happen while the tunnel boring machine was, my lord, preparing the tunnel for constructing the metro line. Now, my lord, this finding of the learned arbitral tribunal that GC is responsible and because of the GC's failure, this is an unforeseen physical event, this theory applied by the arbitral tribunal is incorrect. The reason being, my lord, clause 3.2 of the general conditions of contract, which we have disclosed, yes, my lord, defines what is the role of the general consultant. Now, my lord, the contract that was awarded to the respondent claimant, my lord, it was a design build contract. My lord, they had to design, they had to build, and my lord, the contract also contained various provisions that if at all there was any breach or failure or any situation or any damage, my lord, it was on the contractor to indemnify. And my lord, the reason of these clauses is, my lord, that in case, my lord, there is any fault on the part of the contractor, my lord, while performing the obligations, it is the contractor who, my lord, will rectify and, my lord, restore it back to the original position. My lord, GC is only there to supervise, but, my lord, the damage that is caused by the contractor's failure, it is on the contractor to indemnify the damage and put back to the original position.
But GC never raised any red flag. GC was all along supervising the thing along with you.
Yes.
It was never this issue was no issue was raised by the GC regarding the machine being not properly serviced or brushes not being changed or anything regarding. Yes. Yes.
Lord, the role of GC is not, my lord, to check at every stage what a contractor is doing. Now, GC's role is really, my lord, an extension of my role. So, my lord, when you give your method statement, you'll do the work, you'll give your choice of machine, give your drawings, that will be approved by GC. Now, when you're doing the work, there's no constant supervision. Ultimately, my lord, the contract says, if anything happens, contractor is responsible. Because otherwise, contractor will never be responsible. I, my lord, looked up law. If GC gives an instruction, then you must do this. That causes, my lord, an incident, or, my lord, the disaster. You can come and say that because I was compelled to follow your directions, I, my lord, suffered this failure. But GC is not a constant supervisor. Otherwise, the contract turns on its head. Because whatever happens, you'll say that you did not tell me. My lord, please see the defense today. The defense is you didn't tell me. You didn't stop me. So I'm not responsible. You are responsible. You didn't foresee. So, my lord, it's not a foreseeable event. This is the argument. And, my lord, this argument is really excluded by the contract. And it's an unreal argument. If your lordship sees, my lord, the role of the GC as per the contract, I would have understood if there is a clause that the GC would do day-to-day supervision and would ensure that the work is done in a proper manner, then, my lord, this is an argument which could have been made. On the other hand, the contract excludes this argument and says that whatever happens, you will be responsible. You, the contractor, will be responsible. So if that's the contract clause, today this is an inadmissible argument. And I'll deal with this issue, my lord. Now, no, iPad. These are modern day problems.
What?
iPad 1 is not synced with iPad 2. As a result, my lord, all notes made for 2.5 hours yesterday on iPad 2 isn't appearing in iPad 1.
Where is 2 before some
No,
appearing
two
before
is
some
here,
other
my lord.
code?
Must be outside.
2 must be appearing before some other code.
No, no.
iPad 2.
iPad 2 is
They
outside.
will come when iPads will appear before iPads.
Yes, yes. But it's so easy now. 6 months it takes.
So that does not take anything away from the artificiality of some of our intelligences also.
Yes. Well, AI is more intelligent than me, I have understood.
And some of our intelligences are artificial also. We're supposed to be intelligent, but
Yes.
it's very artificial.
Yes. Milord, from memory, Milord, if your lordship please takes, Milord, I'm
Clause 3.2 was being referred to by
yes,
Mr.
Milord, I'll come back to clause 3.2. Milord, I'll start with the main argument made by Mr. Shah. The argument is that these reports, there are two issues. One is, Milord, reports, one is, Milord, GC. These are the two, Milord, main arguments. Now, first argument is the reports. From, Milord, paragraph 98, page 265. Huh? Internal page 55 of the award.
Yes.
Oh, no. Oh, no, no, no. Oh, it's here, Milord. My mistake.
Here.
My mistake. Milord, paragraph 98. Milord, please see subparagraph C.
Yes.
Reports are divided as to pre-incident reports and post-incident reports, which will be discussed in detail subsequently. Lord, this is recognition by the learned tribunal that there is, my lord, a distinction between the two. However, my lord, as the award progresses, your lordship would not find any discussion on how and why pre-incident reports can also be relied upon, though it's my specific case that pre-incident reports are useless.
Mr. Chaudhary, I have a different bench at
Yes,
1.
Next Friday.
No, no, please continue till then.
Oh, till 1.
Yes, yes.
Yes.
Will
Milord,
until my
Friday-
brother comes, yes.
Milord, Fridays I have ensured I am not going anywhere outside Calcutta High Court to do anything till I will not finish this.
So that you can remain in the evening in Calcutta.
Yes. And that is a blessing. Now, Milord, so no discussion on pre-incident reports and, Milord, why they are not to be used. And in the passing, I'll just indicate even my, if I may use a colloquial expression, my number 1 expert, Dr. John Endicott, who's possibly the number 1 expert on tunneling in the world. My lord, pre-incident reports also says that till retrieval, I can't say anything with certainty. That's my report, which I've used. But it's on record. I never say that that should be followed. In fact, he has said that these are the probable causes. And while saying, my lord, what are the probable causes, he also includes their arguments and says A, 1, 2, 3, 4, all are probable causes. But I can't say anything till I see post-retrieval. So the biggest, my lord, defect of the learned arbitral tribunal's adjudication or lack of adjudication is that no, my lord, discussion as to why his 4 reports cannot be relied upon. Next, my lord, please see subparagraph D. Immediately after the incident, the claimant had engaged independent agencies, technical experts to ascertain the cause of the incident. Now, if you have engaged post-incident an expert to assess the cause, I'm sure the expert hasn't done it without remuneration. You have also paid. So you have engaged post-incident to help you and you have paid for him. The learned tribunal proudly, my lord, records engaged independent agencies, technical experts. But my reports, IIT Madras, etc., are, my lord, casticized because I paid for them. And it's after, my lord, the incident with, my lord, intending litigation in mind. So, my lord, this is a clear indication of, my lord, the mental frame of the learned arbitral tribunal. It's a telltale sign. Also, my lord, D 3 and 4, your lordship would see, my lord, Surbana Jurong and Herenschnet. And, my lord, Mr. Charles Mann, who's 1. Mr. Charles Mann came to the arbitral sitting to make a presentation. But, my lord, he is independent. My lord, I say he is independent. Experts of this caliber, my lord, are all considered to be independent till I can show his findings to be wrong. But, my lord, all of my experts go out of the window. 3 and 4, Surbana and Herenschnet, are his subcontractors.
So this is a double standard practice.
Absolutely. Herenschnet has supplied him with the TBM. Surbana Jurong is his person who has done reports. I'll come back on Friday.
Yes, yes, yes.
It's 1.
Third in part for further hearing on July 11.
Lordship, on the last occasion,
Yes.
direction was given for filing the written notes of argument. And I have given it to the landed.
You can hold it for some time
Yes,
if you had something
yes, I
because
take
we are not
the-
taking it
yes,
now.
I
Sir,
will-
may I take 2 seconds, my lord? Most interesting thing happened. My learned friend's advocate on record, after Mr. Shah, my lord, was about to settle it, one of the drafts, instead of sending it to Jishnu Shah, it came to Jishnu Chaudhary. So Ms. Chatterjee sent me an email saying, Jishnu, please ignore. And my response was, I will not.
I regularly used to have phone calls of clients of Mr. Shobhushaji Banerjee. And I had to, some of them I answered also. satisfactory.
Yes.
That yes, your case is.
No, no, I always, my
Your
lord,
case is what happened to my bail matter, and I used to answer. Sometimes I got bored and I answered also. Yes, those will be heard out. I don't know what happened to Mr. Banerjee after that. So that will be for
regularly happens.
namesakes. Yes.
Lord, I am for the petitioner. Lord, may I
Okay.
file the replies
Please.
that I have served on my learned friend in advance?
Opposition, you have already filed.
Opposition, they would file, my lord.
You have already filed.
Affidavit is complete.
No, মানে কোর্টে ফাইল করেছেন কিনা সেটা জিজ্ঞেস করছি। It's coming now.
Please be, yes.
দুটো আছে, হ্যাঁ? একটা না দুটো?
One copy. You're saved. Yeah, looking very tense, Mr. Basu.
I got very tense.
Yes. And Mr. Basu was taking the other, yes. Yes. What is the?
My lord, the petitioner before your lordship claims to have purchased a suit property from the erstwhile owners. The conveyance is not perfected in respect of the petitioner because of non-payment of stamp duty. During this time, anyway, during this time, my lord, one of the erstwhile co-owners has sought to transfer his undivided share to the contemner hearing. The petitioner, as advised, has filed a civil suit challenging that conveyance in favor of the contemner and made both the erstwhile owner who has transferred in his favor and the contemner a party in that suit. In that suit, upon moving of an injunction application, the petitioner before your lordship has been able to obtain an order in the trial court that till the subsistence of the suit, both the erstwhile owner and the contemner will not be able to project themselves as co-owners of or owners of the property. They carried an appeal from that trial court's order before your lordship's division bench. Your lordships have held in the order that no, you had ample opportunity to appear before the learned court. Learned court had given you ample opportunity. Your lordship has also gone into the merits and said, no, we are not interfering with this order.
It was at the ad interim stage or?
At interim stage. Now, my lord, that is continuing. Now, my lord, we say that in that event, my lord, the order of the trial court has merged into the order of the appeal court. Then what happened? Despite the pendency, despite this order which has been affirmed and merged into the appeal court's order, this very contemner, my lord, starts filing applications in several suits which are pending for eviction of tenants in respect of the suit property in question. And in those applications, he wants to be added as parties, as a co-owner. Also, he, my lord, starts issuing rent receipts to several, my lord, tenants, including, my lord, the state of West Bengal. Now, my lord, coming to know of all this, the petitioners file initially an application before the learned single judge of this honorable court saying that it is a contempt of the, no, first we file an application under Order 39 Rule 2A, Then, my lord, on advice, we file an application for withdrawal. And
Before the trial court.
before the trial court, before the city civil court. Now, my lord, during the pendants, but the judge the judge was absent on leave, or my lord, the post was vacant. In that view of the matter, since the recalling application, the withdrawal application couldn't be taken up, we mentioned that, and we filed an application under section 10 before the learned single judge of this honorable court, saying that I am already withdrawing that. Kindly treat it as a contempt by a subordinate order of a subordinate court. Kindly, my lord, takes cognizance. Honorable Justice Devanshu Boshak, sitting singly, my lord, takes cognizance and asks them to file, my lord, to appear. There, my lord, they initially say, yes, it is a mistake on our part. I will ask my learned advocate, my learned friend that appeared, that the counterpart in the trial court not to take any further steps. Thereafter, my lord, they filed an affidavit. They filed an affidavit, and there, my lord, they took a point, amongst other things, that no court, that the order which we are complaining of, contempt, in effect, stifles his right to legal proceedings. And that order could not be passed. My lord, there was some lengthy argument before the honorable judge. My lord, we ultimately thought that it is better that, my lord, on advice, that it is better that if we say that the order, since the order has merged in the appeal court's order, and those catena of judgments are there, that the appeal court, well, a higher court can pass such an order in respect of subordinate courts or courts inferior to it, or even courts, even a division bench in respect of a single judge of the same high court. So, my lord, on advice, we withdrew that proceedings before the learned single judge sitting in section 10 of the Contempt of Courts. Now, my lord, we are here pursuant to the liberty given by that judge, in any event that liberty was there, before your lordship, saying that since the order has merged into the order of the appeal court, and it is a fact, he has not denied that these applications, in the affidavit that has come, he has not denied that these applications have been filed, he has not denied that these rent receipts have been issued. He takes, my lord, in the affidavit, 3 to 4, my lord, defenses. Once he says, the first he says, I am a novice in this matter. I do not know what is the letter of law. I have not involved in any kind of litigation. So I did not know how to act under these circumstances and what is the ramification of the order concerned. To my lord, he says, whatever I have done, I have acted at the instruction and advice of my erstwhile advocate, Ashish Kumar Shanna.
Advocate in the trial court.
Before the trial court.
Yes.
Third, he has argued that same point, that this order itself, by the very nature of the order, is trying to restrain his right to legal proceedings and cannot be passed.
ফার্স্ট দিন ওরা বলেছিল যে আমরা এগুলো উইথড্র করে নেব, আমরা প্রেস করব না, এটাও বলে দাও ওইখানে যখন হয়েছিল।
And fourth, my lord, certain my lord, basic denials he has made. But basically these 3 points he has argued. Now, my lord, the fact remains, he admits that these proceedings have been initiated. Fact remains, even today as we are speaking, he is proceeding with this similar kind of applications before the single judge of this honorable court in another suit that has been filed. Day-to-day hearings are taking place.
Those applications are all for addition of party on the ground that he's a co-owner.
Yes. Yeah.
And he has also issued letters to the tenants.
Rent receipts, letters asserting themselves as owners. And my lord, he had, my lord,
Yes.
in fact made a prayer, if I am not wrong, my learned friend is there, before the learned single judge, that he may withdraw those applications, or he may not proceed with the same till the time the suit is pending and the orders have to be preserved. Now so even in this affidavit, nothing, my lord, there is no denial of the factum of the filing of the applications. Despite the order, there is no denial of the factum of issuance of rent receipts. He says that I am a novice. I did not know. I do not know how to read an order of court. Two, I have acted at the
The
instance of
substantive defense is that order restrains right to legal proceedings.
Yes, but just in the passing, because I believe I had showed those judgments before the learned single judge, where it was shown that if it's a higher forum, the higher forum has the right. It cannot be a coordinate bench injuncting each other, my lord, from proceeding, but a higher forum can definitely pass an order injuncting.
That is on the contempt application.
On the contempt, no, my lord, on the order itself, whether the order, whether
Higher
the civil-
forum, lower forum, how does that come?
because if it's
Because in a different suit, oh, you are saying that
if it's a higher forum passing an order restraining, my lord, somebody from, my lord, proceeding in a lower forum, or, my lord, proceeding in respect of certain rights which is only
the specific relief act only contemplates parallel or
yes
or superior forums. You
judgments
cannot.
are there, my lord. I shall place those judgments, my lord. I'm
The
not saying
statute is also clear.
yes,
যে আমরা
exactly, statute itself is clear.
Statute is clear.
Yes, yes.
বলেছি আমাকে যখন এখন বর্তমান উকিলবাবু বলে দেওয়ার পর থেকে আমরা আর প্রসিড করি
And lastly, very important, I'm grateful to my learned junior. He has said that after my current advocate has given me the correct advice, I'm not proceeding with this.
They are stated in the opposition.
Yes. Now, my lord, this is the scenario. There's no denial that these things have been done. But he says that my entire blame is on the erstwhile advocate. Now, what we have done is we have written letters to that advocate that these kind of allegations are being made. What is your response? Well, Lord, he has received the notice, but there is no response from him, which is quite well expected.
Is he
Now-
still there appearing for them?
No. My learned friend is appearing now for them. And probably
In the trial court also.
trial court, my lord, I do not know.
Advocate has been changed or same advocate? Same advocate. Changed.
Naturally, that fits into the narrative. Vokalatnama has been filed, changed. Now, my lord, sending him to prison and all that will come later. But first and foremost, my lord, if he admits that and he realizes that these things could not have been done, first of all, I would argue that howsoever bad an order is, even if he was aware that the order passed by your lordships was bad, say for example, but he could have gone to the Supreme Court to challenge it. It does not lie in the mouth of a contemner that because the order is bad, I have flouted it. And those are, I don't think it is even anymore open to argue that because the order was bad, I have flouted it. That's number one. Number two, I have judgments which say that if it's a higher court where your lordship was sitting in the appeal bench, my lord, your lordship could have passed the order, restraining him from, my lord, proceeding in or asserting his legal rights in respect of this suit property, in respect of any proceedings subordinate to your lordships.
Higher court argument has some, it is arguable, somewhat arguable. Mr.
Somewhat.
Post may argue
Somewhat.
because the merger doctrine comes in. We were sitting, we are a cylinder.
I know.
The emanates
But
from
I
that
have
court.
judgments
If
to
it
support that.
merges,
Yes.
then it's the trial court order which we are affirming.
Really affirming.
So therefore, the effect is that the trial court is, but that argument, whether that can be taken at all, that will be going behind the order.
Behind the order.
Contempt, which
That's my first defense, that you
not
cannot go
contempt.
behind.
Obviously, yes. The merits of the order cannot be challenged in contempt.
In contempt. That's the first elementary defense I am taking.
If it's impossible to execute, that's different.
That's different.
There is no such.
So that
This cannot
he
be such a case.
admits that yes, on advice I have done
Building
this.
to be demolished, the building has already, it's no longer there. That's a good defense.
That's a
But
good defense. But here it's not the case. He
Very good.
admits that he has done this. He admits he is on wrong legal advice, and he admits that after the correct advice.
let us hear Mr. Basu first,
Yes,
then
yes,
we'll
yes,
come back.
because
to
I
it.
don't think-
I don't think there's much. I mean,
This
Mr. Basu,
well, I have a battery of cases I can cite, but if he agrees
just
to
ascertain
withdraw,
their stand first. Mr.
Yes,
Basu, what is
sir,
your
I-
stand in the matter? I mean, if you want to argue on merits, then we'll let him cite judgments and all those things. I mean, let us ascertain your stand first. What is your?
withdraw করে নিলে we have no problem, right? জেলে পাঠিয়ে তো কোনো লাভ নেই।
Kindly takes up.
Just-
Mr. Basu, if you want to address on merits,
Yes, I'll address it.
so then we'll hear him fully, then we'll come
Then,
back.
my lord, only one thing, just to indicate my mind, I have talked to my clients. My lord, we are really not interested in sending him to prison.
If he stops,
Yes, and he has said that I will stop. I have got good advice now.
in the opposition, he has stated.
Yes, that
Shows that paragraph.
after we have not done so. That's the affidavit, I believe. No.
if there is an if and but, then
No, I know. Hedged and couched with any kind of paragraph to follow.
এইরকম এই প্যারা এইটটা পড়ো যে আমার আগের অ্যাডভোকেট এটা ইয়ে করে
না না, যেখানে ও বলেছে যে উঠে গেছে বলতে চাইছে।
এই
he has stated in paragraph 15 that he has stopped all acts
Yes,
which may be contumacious.
yes. Also
But-
paragraph 8.
8. Acha.
8.
Read, he has no intention to go on stopping.
Correct.
Yeah.
No, that's
He has stopped for the time being in deference to the, I mean,
yes, stop
whatever.
all acts which may be contrary in nature to the audited session despite the
But
same.
he maintains his argument that that these do not prevent him from doing it because from participating in legal proceeding on that defense is taken.
defense is taken.
He
and
said
that's
for the
what he
time
did.
being I'm stopping because a contempt is pending in deference
But
to
he
the.
cannot sail in both boats. If he said
They're saying I stopped
I
all
know.
acts which may be contumacious in nature, but they still make this argument that those are not contumacious in nature. So that is a part of this. If I have committed contempt, I apologize
so,
types.
it's sort of a
Yes.
qualified.
Qualifier.
qualified.
It's qualified, and then he'll definitely argue. So we'll hear you on the next day. I mean, on this legal proceeding argument. That is the primary argument
That's the
you have.
primary argument.
Yeah, need not. Yes.
এবার
You can nod your head only. That will do.
কিন্তু
Affidavit in opposition and reply filed by by the respective parties today be kept on record. Full stop. Although hearing is commenced, comma, the same cannot be concluded due to paucity of time. Let the matter stand adjourned till July 11, 2025 for further hearing. Acha, we'll take it up. Should we take it up a bit earlier?
Because I'll take something. 12:30, I believe.
12:30.
12:30 makes sense.
The
Madam.
act to be taken up at 12:30 p.m. 12:30. And Mr. Ghosh and Mr. Bose, both of you just be as, I mean, brief as possible.
This court, my lord, we know there is
This
no
quote
point.
the advocates also.
This-
We have full trust on that also.
We know there's no point.
Be as precise because otherwise this matter will carry on.
That's
We'll
why
have
I
to
summarized in 3 points.
My
like this.
ignorance is so deafening, I cannot prolong.
My lord.
matters, I'd like to thank my court's officers for being there.
But my lord has to,
They deserve a special thanks.
but my lord has
From us
to.
also, gratitude from
Yes,
us.
absolutely. From the litigants also.
But my lord, why my lord will give me some leave, my lord.
Give me half a second.
Madam,
আচ্ছা, last
item number-
matter টা যেটা হলো,
My lord, item number 40.
ওতে ঢুকবে।
My lord, item number 46, there's a contempt application, my lord. So I suppose because I was under the impression because of these things, my lord, no, not to pass any adverse order, my lord may not take up. So my lord, we have already, there was an order of my lord. By mistake, we had issued a letter that we have recalled within 3 days.
You are for the alleged contempt, na?
I am for the alleged contempt. My lord, there was an interim order not to debar the petitioner company. Now, my lord, by mistake, we had issued a letter on 26th of June. We revoked it on the 1st.
So let the matter be called on. When the matter is called on, when the matter is.
My lord, as a matter of apprehension, I thought, my lord, after 3:30, if they are not, because my officers have come, my lord, though there was no direction for personal appearance by my lord.
No, if I did not direct, if I direct personal appearances, generally I keep those matters at a fixed time
My lord, I
so
was
that they are not in difficult.
because of the rigmarole of event, my lord, I beseech. my lord,
Let us see, Mr. Trivedi, if there is
Because, my lord,
poor
first
attendance.
matter
Then
only will 1 to 4 will go on for the major time, I suppose. My lord. Therefore, I mentioned.
no idea. Let us see.
My lord, I have idea because everybody.
You are there.
My lord, ED.
For the alleged contempt must be.
My lord,
Usual. Yes.
My lord, I'm grateful.
Let us see. Yes. You are mentioning. You are mentioning a matter for inclusion in the list. Yes, hand over.
Because contempt was stayed because of division bench passed
No,
order.
contempt application as a matter of rule. Yes, it will be included in the list. Yes, you're with him. Yes, we'll take up the advocates first, then come to. No, you stay there. You stay there.
I'm not mentioning.
Anyone else wants to mention? No.
Content application for inclusion.
Yes, hand over. Yes. What is your?
Your Lordship, you have already directed on 22nd, so which I have already taken the step for paying the money, but there was no direction that it has come as a left. So if you kindly give me the
Is
order.
the matter in the list?
Not today's list, it was previous.
We cannot take matter documents like that unless the matter is before me appearing in the list.
So that's why I mentioned so that you can keep it on the other day,
You want the matter to be included in the list?
on next Friday.
Very well. Yes. A matter to next Friday, it will appear next Friday.
Much obliged.
Call on the list.
I do not know whether your lordship is aware of the resolution. There is some.
Yes, to pass adverse orders.
Yes.
Yes, I'll pass adverse.
Lordship, I am appearing with the applicant.
For the,
Mr. Dotto, I don't understand this. The employees will have a pens down and some of the advocates have left court for that. This logic, you have to be on sounder logic, at least.
well,
You, I mean,
we will
get
discuss
it
on
settled
another,
by,
some other platform.
get it settled by someone else. Yes, Mr. Das?
I am appearing the applicant.
But now,
Petitioner applicant.
now we are on rule, so
No, yes.
Rule is your issue.
No, what was the nature of the contempt?
Contempt lawsuit's order was violated. Lordship.
Obviously, the order was violated. What was
there was delay.
Let us hear Mr. Dotto because he's right. He's on rule, so yes.
The primary contention of the petitioner and your lordship's order records
Yes.
that your lordship had, while passing the order, had indicated a time period of 2 months within which the hearing by the subdivisional officer was
Yes.
to be conducted. But apparently, on the last occasion, my learned friend had indicated the first date of hearing was beyond that 2 months period. So, lordships felt that
The direction was the concerned SDM shall now proceed from the stage where the proceeding had reached at the
Yes.
time of passing of the impugned order.
Yes. But the hearing, prima facie, your lordship had opined that the first date of hearing,
Even the
after
first date was before.
beyond 2 months.
Yes, why that?
But no, it is not. The first date was within a month. Yes, it was with some delay, but within a month, and the first hearing also within a month. Next hearing
The direction was for the entire thing to be done within
to
a
be
month.
within 2 months. But
2 months.
within 2 months, but it could not be completed within 2 months. But I have given a detailed explanation of the delay. I have also served him a copy with.
Have you put it in
Yes.
the? It has to be a show cause sort of. Yes.
My lord,
Yes. What is the stage of the hearing now, Mr. Dutta?
Now the learned
The
SDM,
contempt is personally present.
yes, personally present. The learned SDM had closed the hearing, saying that he could not gather enough information and had relegated the matter to the block level officers to give them further inputs, give him further inputs upon proceeding with fresh proceedings. Your Lordship, while hearing the writ petition, had directed him and given him liberty to avail all opportunities to gather information while conducting.
So why
the
does he
hearing.
close the hearing?
Yes, that part
Was under threat of contempt.
that part.
No, if you have done, if you can show the court that you have taken
Lordship.
steps,
Yes,
because an impression was.
Lordship.
Please, don't disturb.
Lordship.
An impression was given to the court that even the first hearing was fixed, the date was fixed after the
no, that is
timeline.
not a fact.
That is not correct.
That is not.
You started hearing within time.
But concluded after it.
Why did you conclude it?
Yes, my lord, that part only is a mistake of understanding. But, my lord, may I say,
You
with all,
purge the contempt by reopening the hearing.
my lord, we have reopened and passed an order now,
After-
after the rule being issued.
What is that order? You have gathered information from.
Yes, we have gathered information
Very good.
and passed an order.
Where is that order?
My lord,
Just show us that order. You are in this matter, Mr. Pandit?
Lordship, I am for the private respondents in the writ petition, Your Lordship.
So you are not concerned with the contempt application.
Lordship, with your Lordship's kind leave, I wish to bring certain facts to the kind notice of Your Lordship. That's it. If Your Lordship allows me.
Acha, I will.
Mr.
Let me first hear Mr. Dottu. Yes.
page
This is that
76.
order, page 76.
But after the rule being issued. My lord, my humble endeavor was to explain the delay, that there was no contumacious act. Yes, there was delay. My lord, preliminary, there was intervening elections. There were, my lord, multiple efforts done by the officer concerned to the block level officers to provide these information. The block level officers could not provide the maps. My lord, there were two LA cases of 1965 and 66. One LA case did not provide the adequate map, but indicated that PWD had acquired. There was a certificate showing that PWD had acquired. On the last occasion, my learned friend had indicated in the order by which the contempt arises that the SDO had observed that the particular land is acquired by PWD, but does closes the proceeding. Why so? Because, my lord, the PWD or the SDO, it was presented that yes, PWD had acquired, but only a certificate. No possession document, no map was available with him.
Now those have been produced.
Yes. Now, my lord, 65 encroachers are there. My lord, it was a huge area. My lord, he had to take into account whether actual demarcation was there, because to complete the my lord, process of entire evacuation or demolition of the or removal of encroachers, he had to identify all encroachers, and exact map had to be presented before him to direct removal of encroachers. But those were not before him in the first instance. Now, upon conducting a fresh hearing, the block level officers have conducted fresh inspection, produced maps. Now, this order has been passed.
Let us hear Mr. Pandit what he wants. Yes, Mr. Pandit, what do you say?
Challenging that order passed by the 10-3 authority, private respondents who are the alleged encroacher, some of them have preferred 10-4 appeal before the DM, Purva Mendripur being the appellate authority, and some of them has preferred a writ petition before this honorable court, Your Lordship.
Mr. Pandit, that is entirely beyond the scope of the contempt.
Lordship.
So that does not pertain to the whatever happens to those appeals will happen.
Lordship.
Yes. Yes, Mr. Das, there is
Yes,
no
Lordship.
no contempt. We don't feel there is any.
Lordship, in my contempt, Lordship's order was passed on 6th December 2023.
6 December 23, yes.
Lordship was directed to complete the entire proceeding within 2 months. Thereafter,
Those are directions in terrorism, basically.
Lordship,
Those are directions in terrorism, like we direct the trial courts.
Lordship. Thereafter,
What is the direction in terrorism, Mr. Das?
Lordship, I cannot understand.
Not mandatory.
Lordship, you kindly see the order, mandatory, Lordship.
Anyway, complete your arguments.
Yeah. Thereafter, proceeding was on the basis of initially I challenged the remand order. initial order
These
was
are not, these are beyond the content. What is your answer to his
no,
reply?
be-
It appears that the officer has done his level best to do whatever he could.
yes, Lordship, I am showing that. Lordship.
And the first notice was given and the first hearing was held within the timeline.
Yes, but proceeding was not concluded.
Might not, proceedings are not concluded for various reasons. He has given sufficient reasons.
Lordship, I showing the Lordship's order, Lordship, initial order, Lordship.
No, Mr. Das, we are satisfied. Yes, come.
Lordship, kindly giving
The
permission.
reply to the rule
Lordship,
showing cause to the same, comma, filed by the alleged contender today, comma, be kept on record, full stop. Learned counsel appearing for the alleged contender submits that contrary to the perception of the court as recorded in the previous order, comma, the notice of hearing was initially issued within the timeline stipulated by this court by the order under contempt. Full stop. Even the first hearing was held within the said period. Full stop. However, comma, due to the insufficiency of documents and materials available before the alleged contender, comma, the hearing could not be concluded within the timeline as stipulated. Full stop. It is further submitted that the relevant map and other necessary material could not be obtained initially. Full stop. Thereafter, comma, upon passing directions on the concerned block development officer and other officials, comma, the complete materials were placed before the alleged contender. Full stop. The alleged contender also had to ascertain whether there had been any actual demarcation of the property for the purpose of coming to a justified conclusion with regard to whether there has been any illegal or unlawful encroachment on the property in question. Full stop. Next para. Subsequently, upon getting those materials, comma, the hearing has been concluded and a final order has been passed, which has also been annexed to the reply to the show cause. Full stop. Next para. It is further submitted that although initially, comma, due to insufficiency of the documents, comma, the hearing was closed, comma, subsequently, upon gathering further information, comma, the same was reopened and concluded as indicated above. So next para, learned counsel also submits that there were intervening elections which also deterred the alleged contender from gathering all materials and concluding the hearing within time. Full stop. Para, it is further pointed out that due to the number of encroachers, comma, about 65 within bracket,
64.
about 64 bracket, comma, it took some time to ascertain the outcome of the inquiry. Full stop. Next para, learned counsel for the private respondent in the writ petition seeks to argue that challenges have been preferred by the said respondent. Full stop. However, comma, such submissions are entirely beyond the scope of the present contempt jurisdiction. Full stop. Next para, learned counsel for the petitioner submits that the order under contempt categorically directed the alleged contender to conclude the hearing within a particular timeline which has been flouted, comma, thus giving rise to a contumacious act. Full stop. Next para, however, comma, this court is unable to agree with such contention, full stop. The premise of penalizing a person under contempt jurisdiction is that there must be some willful and deliberate violation of the order of this court. Full stop. The timeline stipulated in the order under contempt was in the nature of a direction in terrorem, and as such, comma, cannot be so strictly construed to penalize a person merely for violation of the said period. Full stop. Next para, particularly, comma, in the present case, comma, it is found that there was no willfulness or deliberate act on the part of the alleged contender in concluding the hearing late. Full stop. Sufficient justification for the delay in conclusion of the hearing and the proceeding has been furnished before this court. Full stop. Next para, as such, comma, this court desists from penalizing the alleged contender for willful violation of its order. Full stop. Accordingly, WPCRC 95 of 2025 is discharged. Full stop. CPN 188 of 2025 stands disposed of. Accordingly, full stop. Needless to say, comma, further personal appearance of the alleged contemner is dismissed. Next.
Already lordship, their report,
It is
they are
between the contemptor and
intentionally
the court.
violated lordship. So I,
Very well. Next.
if I
Yes, Mr. Banerjee.
Before us, Mr. Bikram Chaudhary, he's from Delhi. He's one of the finest minds in ED right now. No, that is true, my lord. We get to see him argue. We follow YouTubes to see how he's arguing. Most of his judgments are path-breaking judgments as on today. So we are lucky that my lord, Mr. Bikram Chaudhary.
Bikram.
He's here, my lord, he'll be leading us.
Maybe, Lord, that's too unfair, but my friend is extraordinarily kind. He's biased towards me.
No, it's a privilege to have you, Mr. Chaudhary. No difficulty on that. Probably your other side should not oppose that.
My lord, may I only mention this, my lord? The matter
Yes,
has
Mr.
been
Raju.
argued. Yes, matter has been argued. Reply is there. Now, my learned friend has to only give rejoinder arguments.
Right.
He need not begin afresh, my lord. That's what. Because
My Lord,
learned
my learned brother, Mr. Raju, will give me benefit of appearing for the first time, and being his younger brother, will have more leverage.
No, I'm giving you the benefit. I'm not saying. I'm only saying that you are arguing on rejoinder.
Absolutely, brother.
You cannot reopen the hearing, Mr. Chaudhary, as Mr. Raju points out. He's absolutely right on that. So we are on
My
rejoinder.
Lord, we'll be with the leave and liberty of the court, whatever, my Lord, pleases your lordships. If I'm able to, my Lord, make out some point on a neat question of law, my lordships will not, my Lord, disallow me to make that.
Point, then I will have the right to reply. You can't raise a new point.
Absolutely, you always have right, brother.
If you
I'm
raise a
not
new point, definitely, Mr. Raju.
addressing the court.
My Lord, allow me.
Let us get on with the hearing, Mr.
There was a direction of,
Please use the microphone.
there was a direction by your lordship of exchange of affidavits.
Right.
So far CBI is concerned, my lord, we have served the affidavit in opposition. With your lordship briefs, we are filing the affidavit.
Whatever has happened.
Now, on the last occasion, the
Well,
hearing
there are-
was started.
There are two sets of matters, my lord.
ED and
First set is against CBI,
right.
read petitions, where your
No,
lordship directed them to file their affidavit in opposition,
Right.
to exchange the affidavits. So far as the second set is concerned, against the ED, the criminal revisions are concerned, there was no such direction, because your lordship found it's a question of law, no affidavits are required. Your
Absolutely.
lordship was supposed to decide it on 20th of May, when they short for some time, and matters have been kept together on today.
Right. Questions.
Just filing the affidavits, my lord, so far.
At this stage, don't.
My lord, 6 to 8, my lord. Where CBI is the.
What was the time given to you for filing? You have affirmed within that time.
Yes.
You have affirmed within time.
More or less, my lord, more or less.
More or less.
I have some, no, of course. Here was-
More or less.
The advocate on record,
Sir, which
my
should-
lord,
I'll just
unfortunately-
correct.
Have you affirmed it within time? Otherwise, we won't let you reopen at the hearing stage, Mr. Mitra. We are being very candid.
My lord, 13th of June was the date.
What was the deadline for filing that?
13th of June. And we affirm on 30th of June.
So you're late.
Where is it?
At the hearing stage, we won't reopen. Mr. Raju, you are appearing for the CBI? Or
I'm
the
not
ED?
appearing.
You-
But I have some points for the CBI also, if my lord permit. I can appear for the CBI, but there's no
No,
problem.
Mr. Raju, you are for CBI or ED?
No, right now I'm for ED, my lord.
Right now, you're for ED.
My lord, the learned ASG will appear for CBI, my lord.
At this stage, no.
Kindly, my lord, give us, my lord, this is in appellate side, your lordship knows,
Apple said what?
my lord, your lordship knows, my lord. My lord, there is a process of.
I know what.
My lord, there is a process of vetting, my lord. That is.
We are in the midst of hearing. Why are you? I mean, let us hear the matter. It was on
Only
a.
one law point, my lord.
It's a law point. Yes.
Only one law point as far as CBI is concerned, my lord. I'll just point out.
Yes,
that
yes,
the
Mr. Raju. Yes, yes.
At the initial,
Yes, Mr. Lai.
one thing. Listed.
Mr. Lai, please use the microphone. Mr. Mitra, please give him the microphone. Either give him space or give him the microphone. Either of the two.
I'm
Yes.
6, 7, and 8 are concerned.
Yes.
Have instructions to appear on behalf of State Bank of India.
State Bank of India. All right.
But because State Bank of India Lordship members, it was really on the complaint lodgment of
Right.
the State Bank of India that will the CBI was activated.
You probably, Mr. Lai, don't have much of a role to play in this.
Except pointing out
Because you are the complainant. So you you set the ball rolling, yes. And then it's between the CBI and the ED as well as the accused persons. So
Lordship,
there is very little scope.
that the State Bank has a role to play or has to make some submission before Lordship. Regarding that, I must point out.
Right.
I also wonder, I remember I may have pointed out to your Lordship earlier that State Bank has not been made a party yet.
State Bank probably is not a necessary party because this is regarding the investigation. They have challenged the investigation by the ED as well as the CBI.
The State Bank.
Your role ends with the complaint. You don't have an adversarial role in this proceeding.
And
Mr.
they
Lahiri.
have made party a retired.
You have not been implemented in this writ petition.
A retired officer of State Bank of India
Has been made a party.
has been respondent number 4. A retired officer who lost the complaint.
He was the complainant, that's why.
He said in the complaint that he was lodging the complaint as authorized by State Bank of India. He was not the principal. It was clarified by him that this complaint is been lodged by me as authorized by the State Bank.
Very well. So you say the State Bank should have been implemented. Should have been implemented.
Yes. State Bank of India should have been implemented.
So we can, I can decide on that oral prayer right now, if you want. I'll turn it down, but I'm on the reasons which I said.
She may decide it right now, Milord.
The scope of the challenge is regarding the investigations by ED and CBI only.
Yes.
Lord, there are two different writ petitions.
Yes, yes.
So,
but
Lord, one is confined to the CBI case.
the other is ED.
The other one is ED, my Lord.
But regarding the investigations, you're challenging the investigations.
The entire process, my Lord,
Process.
of registration as well as, my Lord.
Mr. Lahiri, we'll just deal with your point right now. একটা order record koro. At the outset, comma, Mr. Lahiri, comma, senior advocate, having instruction to appear on behalf of the State Bank, comma, submits that although a retired officer of the State Bank of India, comma, who lodged the complaint, comma, which was the genesis of the present investigations, comma, has been implemented in the writ petition in the present proceedings, comma, the State Bank itself has not been implemented. Full stop. It is contended that since the complaint was lodged in the capacity of an officer of the State Bank of India and at the behest of the State Bank, comma, it would only be appropriate if the State Bank of India itself was implemented. So next para, upon hearing Mr. Lahiri, comma, this court is of the opinion that the duty of the complainant is discharged, comma, insofar as an investigation is concerned, comma, after lodging the complaint, comma, particularly in investigations of the present nature. Full stop. As such, comma, insofar as the present proceedings are concerned, comma, the same challenge the process of investigation by the Enforcement Directorate as well as the Central Bureau of Investigation. And the complainant does not have any adversarial role to play therein. Full stop. Accordingly, this court refuses the prayer of the State Bank of India to be implemented as a party on the ground that the State Bank of India is not either a necessary or a proper party to the present proceeding, taking into consideration the nature thereof. First, we update with this.
My Lord,
Now we'll continue the hearing.
Question is, my Lord, whether that gives me a standing to, my Lord, participate in the proceedings or not. If Lordship holds that I am not necessary party.
In this proceeding, no.
De facto complainant. Then whether, my Lord, as a de facto complainant,
I've decided that, Mr. Lahiri.
whether, my Lord, I get I mean to say, privilege of participation or not. That is the question, my Lord, to be decided by Lordship.
In the investigation?
In the proceedings before Lordship. Because here, my
No,
Lord,
I've held that you're not a necessary or a proper party.
so, my Lord, I have no role to play in this proceedings, my Lord. I'm not to take.
Insofar as the challenge to the investigation is concerned.
Except, my Lord, being a spectator in the proceedings.
Except?
Being a spectator in the proceedings. Not to make any submissions.
No, no submissions.
No submissions.
My Lord, as rightly pointed out by my learned junior, only there is 5 days late. And at that material point of
At this point, we won't permit you to reopen the entire.
I'm not
scope of argument. Because
I'm just complying your Lordship's order, my Lord.
Mr. Mitra, when did I direct you? At the last hearing, we directed you.
Yes, last hearing.
Not at the last hearing. The
Yes.
last hearing was
In the first hearing.
First
In the rate.
definitely not in the last hearing.
My Lord,
Last
on
hearing
the-
was
on the
What was the
just tagged.
Kindly cease.
Hey, file ta din to.
Second May.
Four matters are criminal revision petition.
25,
I am appearing
2025.
6 to 8, my lord, subject to correction from your
The
lord.
matter was part heard on the last occasion, Mr. Mitro. Did I pass that direction in the last date when the matter was taken up?
Subject to correction, your lordship kindly checks, my lord.
No, I won't check. You tell us. You are an officer of the court.
Yes. No, kindly see the last.
This which one is yours?
No, the order reads, my lord, on consent of all the parties, let the matters be listed on July 4th at 2 p.m. for being heard along with writ petition number so and so, so and so, so and so. This direction was never passed.
Yes.
This is the last order.
My lord, when the
25
matter was heard and interim order of stay was passed, your lordship has been
was a
pleased to
different
direct
date.
us to, my lord, there was a time limit. I must be candid before your lordship. The date was to, my lord, serve the affidavit in opposition and affirm by 13 June.
May
Your lordship kindly sees para 46.
Order dated?
Order dated?
2nd May.
2nd of May.
No, এখানেও আছে.
That's in the writ.
That's in the rate.
That's
Yes.
in the writ.
In the writ petition?
Yes.
Petition.
And I have served, my lord, and service is completed. I am filing the affidavit of service. Only in place of 13, it was affirmed on 18.
This writ petition is also being heard along with this?
Yes.
So after this date, there was no order passed in this writ petition?
No.
No.
Then you can take on record the affidavit.
Kindly, my
Very good.
May I just indicate one? Sorry.
No, both of us.
We are just indicating one thing.
Will you use a reply to this?
Yes. Till the time the decision is taken, may I just apprise your lordship one small fact. Since Mr. Chaudhary is leading it, my lord, the sequence of events was such, which is leading up to today's hearing, is that first, my lord, there were orders passed in the suit court.
Yes.
Thereafter, the orders were passed in the writ court. My lord, after the writ orders were passed, which were signed before your lordship,
Yes.
then criminal revisions were heard.
Right.
Now, the writ orders were passed first. The writ orders were passed first on 2nd. Then the revisional applications came up, so far as challenging the ED proceedings are concerned. That happened on 20th.
No, the CBI proceeding, but the writ petitions pertain to the CBI proceeding.
Writ petition is for CBI.
So therefore, they have a right to file an opposition.
We are not here to oppose. All that I am saying is, my lord, the writ was heard on 2nd.
Mr. Banerjee, as far as I can recollect, a composite argument was advanced on behalf of the petitioners
exactly what I'm
relating to
saying,
the
my lord.
ED as well as the
But
CBI
it
investigation.
was primarily with ED. Now that was for an interim order. Now what your lordship indicated was the
Entire hearing.
entire thing your lordship would want to hear from 4th. So we have a right of full-fledged hearing from 4th onwards.
Not, my lord, that's
It's
simply
not a
rejoinder.
simply a rejoinder because our interim orders were not to be passed. It was decided that we would be arguing the case out threadbare because there was no question of an interim order. Your lordship would be hearing out full on completely. There's no question of a piecemeal hearing for interim orders anymore.
That's what my lord, I was in.
No, it was only rejoinder. It was only rejoinder. I'm sorry. It was only rejoinder. My learned friend, Mr. Chaudhary, was not present.
Mr. Raju, on 20th of May, was it 20th of May 2025 when the last order was passed?
Yes.
Is that the last order? Please just ascertain and tell us.
Yes.
If 20th May is the last order, it is recorded there that on consent of the parties, because we heard you at length, I recollect that vividly, both of you. But that was for the purpose of interim order, as Mr. Banerjee is pointing out. And you had given your reply.
Yes.
But after hearing you, I was of the opinion that the main matter can be taken up probably.
Yes.
And on consent of parties, let these matters be heard on July 4th, along with WPA. Today is the date fixed for final hearing, Mr. Raju.
Yes.
So we heard you, definitely, but that was at the inception for the purpose of ad interim order.
My
You'll be entitled to a full-fledged reply, Mr. Raju. No difficulty on that.
That's all. Grateful, my lord. Sir,
let me have a hearing
I
on
can't be
the
very
entire matter.
technical, my lord, sir. Right? I don't want to be
Let us
technical.
not be technical. That is what I'm saying.
my lord.
Thank you.
Mr. Raju
But-
starts,
Then Mr.
My lord,
Chaudhary
it's all.
starts afresh, my lord.
Very yes.
Grateful, my lord.
You're so happy, Mr. Banerjee.
My lord.
My lord, it's always a privilege with Mr. Raju, my lord, always there on this side. He has been more on this side than that side always. But my lord,
I'll just record a one-liner after that. যেটা record করলাম তারপরে লেখো affidavits in opposition filed on behalf of respondent numbers.
Yes.
In all the 3 petitions.
Yes.
Affidavit in reply filed on behalf of the CBI.
Affidavit in opposition.
Affidavit in opposition filed on behalf of the CBI in WPA 7872 of 2025, WPA 7875 of 2025 and WPA 8043 of 2025 today be kept on record. If you want to use a reply, we'll give you that opportunity.
My lord,
within a fortnight.
What my lord, we can file a rejoinder to this reply. We'll go through it. But my lord, may I only set the pace so that my lord, your lordship start?
No, it can't be either, my lord. I'm sorry, my lord. He can't have a rejoinder and then argue. Either it is after the rejoinder or
are you
appearing
for CBI?
He can't say then he raises new points in the rejoinder. That's not permissible.
Well, I am arguing.
Should be fair.
I am
he can't
arguing
write 2
for
horses.
Reply, if any, thereto shall be filed within a fortnight from date by the petitioner. So next para, however, as directed earlier, the hearing of the main matter is commenced.
Would your lordship release the other matter? Sir, would you take that?
My lord, depending upon my lord, first, my lord, the issue is very short. And let me, my lord, if it could be finished in a few
Mr.
minutes.
Chaudhary, you will confine your arguments to CBI.
My lord, I'm first.
The CBI.
The first 4 matters are ED case, and it's a very short argument. If I'm able to, my lord, persuade your lordships there, and my learned brother concedes, which he has done in many cases, this case would be over in no time.
No, I'm not conceding.
So, my lord, 1st July 24.
Very well. We will start with the ED
matter, my lord, and a singular point for the time being. 1st July 24.
Yes.
PNSS 2023, my lord, comes into force. And my lord, section 223 now provides, there's a proviso, and I read that proviso, my lord.
Yes, please. BNSS আছে?
BNSS,
এখনকার
please.
যেটা CRPC, IPC যেটা 3টে criminal major acts.
Give the digest. Case digest, please. Can you pass on the case digest?
Demonk.
We have the section. Case digest.
পড়ে যেও না।
No.
তুমি ছেড়ে দাও, বসো। আপনি ছেড়ে দিন, ওখানে বসো।
Yeah, just pass on to the honorable court. May I pass on this case digest, my lord? Your lordships will have the section also, everything here. I've just, my lord, for the sake of
that will be easier because I can mark also.
I can, my lord, I've extracted all the relevant judgments. My brother has also conceded at many places.
Oh, thank you, sir.
And my lord, colleagues.
Right.
Let's have a look at 223, my lord, to begin with.
Yes.
The first one, my lord. Now,
Right.
this is the new section, my lord. And just see the proviso, my lord.
Yes.
Which I have highlighted and underlined. Provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. This is, my lord, the new chapter, chapter 15, new one now, where, my lord, that complaints to magistrate used to be section 200 CRPC earlier. Now, my lord, it is 223, and this is the proviso. Now, this proviso, my lord, came to be interpreted by the Supreme Court in Kushal Agarwal, my lord. Please, Kushal Kumar Agarwal's judgment. Yeah. The extract, my lord, in the extracts, your lordship will find. And my brother, Mr. Raju, was there, my lord, in this case as well.
Yes.
I have extracted, though, my lord, I am passing on the short judgment also.
Right.
May I start from, my lord, the second paragraph at the page 1 of this judgment?
Yes.
In the present case, a complaint was filed under section 44(1)(b) of the PMLA on August 2, 2024. The appellant is shown as accused in the complaint. The Bharatiya Nagarik Suraksha Sanhita 2023 came into force on July 1, 2024. Section 223 BNSS reads thus, which I just read, my lord.
Yes.
Proviso. The next page, my lord. Section 223 of BNSS corresponds to section 200 CRPC. However, a proviso similar to the proviso to subsection of 223 does not find place in section 200 of the CRPC.
Yes.
This court has taken a consistent view that a complaint filed by the Enforcement Directorate under section 44(1)(b) of the PMLA will be governed by sections 200 to 204 of the CRPC. This view has been taken by this court in the cases of Yash Tureja versus Union of India and others, and Tarsim Lal versus Enforcement Directorate. Therefore, the provisions of chapter 16 containing sections 223 to 226 will also apply to a complaint under section 44 of the PMLA. As the complaint has been filed after 1st July 2024, section 223 of the BNSS will apply to the present complaint. The proviso to subsection 1 of 223 puts an embargo on the power of the court to take cognizance by providing that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. In this case, admittedly, an opportunity of being heard has not been given by the learned special judge to the appellant before taking cognizance of the offense on the complaint. Only on that ground, the impugned order dated so-and-so will have to be set aside. Mr. Raju, the learned additional solicitor general, has made two submissions. Firstly, he submits that hearing given to the accused in terms of proviso to subsection 1 of 223 will be confined to the question whether a case is made out to proceed on the basis of complaint, and hence only the complaint and the documents produced along with the complaint can be considered at the time of hearing. His second submission is that it is well settled that cognizance is taken by the criminal court of the offences and not the offender. Therefore, after taking cognizance and after following procedure prescribed by proviso to subsection 1 of 223, if cognizance is taken, there will be no occasion to again take cognizance of the same offense when supplementary or further complaints are filed. Therefore, at that stage, there will be no occasion to give the accused the opportunity to be heard. The aforesaid two submissions made by Mr. Raju, the learned additional solicitor general, need not be considered, as the same do not arise in this appeal at this stage. However,
here also the facts are similar. That
absolutely,
occasion does not. Mr. Chaudhary, what is the date of filing?
Please, Your Lordship.
Of
Your
lodging?
Lordships would just take the date of filing of this complaint.
Yes.
The 15th February 2025.
Thank you.
The cognizance is taken, my lord, on that very day. So I don't have to say anything, my lord, but to say that my learned brother, he's one of the beacon of light. He made a very fair statement, not in one forum, but more than one, and his colleagues also. One of them is, my lord, that case before a trial court in Sonia Gandhi's case. He said that very fair, it had to be given, an opportunity ought to be given. And I have orders since yesterday, my lord, in Gujarat High Court, where a similar concession was made, that yes, the court has passed an order without affording an opportunity of being heard. I have case from Delhi High Court, where his colleague, Mr. Zohaib Hussain, has made a similar statement. I have all that, my lord, in that compilation, the case extracts. So, my lord, this matter has to go back at that stage, and therefore there is no need for us to argue on anything else today before, so far as, my lord, this PMLA case is concerned. They can be disposed of as such. Subject to, of course, if my brother wants to argue something, my lord, I'll argue in rebuttal.
Mr. Raju, do you concede to this? Then we won't proceed further. Mr. Raju, probably your microphone is muted.
Yes,
Yes, now it's all right. Yes.
My lords, may kindly have a look, my lords. There's a difference regarding the stage. Now, supposing the magistrate has taken cognizance in violation of the proviso, are the proceedings vitiated? Is a question which is required to be addressed. Therefore, kindly have a look at section 506 of the BNSS.
Yes.
Yes.
Yes, please.
If any magistrate not empowered by law to do any of the following things, namely, kindly go to E, my lords.
Yes.
Take cognizance of offence under clause A or clause B of subsection 1 of 210. Earlier it was 190. Now kindly come back to, then, my lords, erroneously in good faith and does that in proceeding shall not be set aside merely on the ground that of his not being empowered. So magistrate was not empowered to take cognizance without hearing the other side. Yet he has taken cognizance But on that ground, it will not be set aside, is what 506 says. Now kindly come to 210, my lords.
Yes, yes.
Now 210 and 506, my lord, if it is A and B, my lords. Subject to provisions of this chapter, any magistrate of first class or any magistrate of second class, specially empowered in this behalf, under subsection 2, may take cognizance of any offence upon receiving a complaint of the facts, including complaint filed by a person authorized under any special law which constitutes such offence, upon police report submitted of such facts. Now, therefore, my lords may kindly have a look. So, in violation of 223, if the magistrate takes cognizance, it could be the cognizance in this case would be either under 210A or a 210B. 210 if it is treated as a private complaint, or 210B if it is a police report. Therefore, my submission is the proceedings are not vitiated. If they are not vitiated, they can't be set aside. This is the first submission.
Yes.
Second submission, my lords may kindly have a look. The procedure under 223 applies to complaints. It doesn't apply to charge sheets. Kindly have a look at 223.
Yes.
Get those two judgments. Deepak Mahajan. My lords may kindly have a look at 223 again.
Yes, please.
Having jurisdiction while taking cognizance of offence on complaint shall examine on oath the complainant witness present. Therefore, this is on a complaint. Though technically it may be termed as a complaint, the CBI complaint, but it is in reality a charge sheet. It's not a complaint. I'm relying on two judgments for this proposition, my lord. There, it is akin to a charge sheet. I'll tell my lords why it is akin to a charge sheet. It is preceded by investigation. No complaint, ordinarily complaint is never preceded by investigation. Of course, it is investigation by the ED officials. It is preceded by a remand. Accused can be taken on remand. Kindly have a look at section 167, the new section, my lords, may kindly have a look. ED, before filing a complaint, can take a person on remand. That is, my lords, the new section will be 187.
Yes, please. Yes.
My lords are aware that day in and day out, accused persons are arrested by the ED, which is not so in a complaint case. Pure complaint case, nobody can be arrested. But this is not a pure complaint case, therefore the accused are arrested. They are produced, get those two judges and send it to them. They are produced before the magistrate. Now kindly have a look at section 187. Whenever any person is arrested and detained in custody, it appears that the investigation cannot be completed within the period of 24 hours fixed by section 58, and there are grounds for believing that the accusation or information is well-founded. The officer in charge of the police station or police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the diary herein specified relating to the case, and shall at the same time forward the accused to such magistrate. My lords, I am not arguing that it is a charge sheet, but I am saying it is akin to a charge sheet. But therefore, my lords, and if the period of 60 days and 90 days are not over, as far as investigation is concerned, the accused are entitled to default bail. Now, kindly look at two judgments of the Supreme Court, my lord. One is Deepak Mahajan's case, and the other is Ashok Chunila, my lords. So, have you sent to the other side?
In the group, they will share.
I have sent it in the group, my lords. Not got it. But Deepak Mahajan's case was a case under the Customs Act, where the Customs Act or under the FERA, where the accused were to be arrested and the procedure was to file a complaint.
Mr. Raju, can we get the citation or a copy of
I
the?
am giving the citation. I give the what is citation?
Deepak Mahajan is
1990.
1994, 3 SCC.
1994, 3 SCC.
440.
440.
Right.
Huh? My net, there's a problem with my net, my lord.
No difficulty. Just try to.
Yeah, it's now. Then get Ashok Chunila. So, can you send me the Ashok Chunila's judgment also?
2018, volume 16, SCC.
Yes.
158.
Thank you.
This is Ashok Munilal Jain.
Yeah, that should be 1980. Huh?
I'm going to send it, sir.
There is a problem here at my office. But kindly have a look, Murad.
Yes, we are looking
Kindly
at
come to para 116 of Deepak Mahajan's case.
Deepak Kumar.
Para 116.
Yes, please. Para 116.
It should not be lost sight. My lords have got it?
Yes, I have.
Of the fact that the police officer making an investigation of an offence representing the state files a report under 173 of the code and becomes the complainant, whereas the prosecuting agency under special act, this is a prosecution agency under special act, files a complaint as a complainant under section so and so of the FERA and under section 137 of the Customs Act. To say differently, the police officer, after consummation of the investigation, files a report under 173 of the code, upon which the magistrate may take cognizance of any offence disclosed in the report under 191B, which is now this also similar provision, which I read on the BNSS. Whereas the empowered or authorized officer of the Special Act has to file only a complaint of the facts constituting any offence under the provisions of the Act, on receipt of which the magistrate may take cognizance of the offence under so and so. After taking of the cognizance, either upon a police report or upon receiving complaint of the fact, magistrate has to proceed with the case as per the procedure prescribed in the code or under the special procedure if any prescribed in the spec. Therefore, the word investigation cannot be limited only to police investigation, but on the other hand, the word is of a wider connotation and is so flexible so as to include investigation carried out by any agency, whether he be a police officer or empowered or authorized by a person not being a police officer under the direction of the magistrate to make an investigation vested with the powers of investigation. Now then, my lords may see 117.
Yes.
It may be recalled in this connection, complaint to magistrate and magistrate on receipt of complaint of an offence to which is authorized to take cognizance or which has been made over to him under so and so, can direct an investigation to be made by the police officer or by any such other person as he thinks is as regard the confinement of such person. That is different, but that is with regard to power. From the above, come to paragraph 120, my lords.
Yes, 120.
From the above discussion, it cannot be said that either the officer of the enforcement or custom officer is not empowered with the power of investigation, though not with the power of filing a final report as the case of the police officer. And ultimately, my lords, their lordships have held that the complaint is to be treated as if it is a charge sheet for the purpose of 167. And that is how
Where is that, Mr. Raju? Which paragraph?
136.
Right.
In the result, behold that subsection 1 and 2 of section 1 squarely applicable with regard to production and detention of person arrested under the provision 35 FERA 104 of custom and the magistrate jurisdiction to authorize detention of the person arrested by authorized officer and FERA taken to the in compliance of 135(2). But I'll just come to that where they've said that it is the charge sheet, my lord. My lords may give me.
Where is that?
Just give me a minute, my lords. That is probably 116 which I've read, my lords, because they said that it is the same as a police report. Complaint is same as a police report because
Mr. Raju, does it say so? I mean, please clarify because I have some doubt on that.
There is a line.
Yes,
I'll
it
come back
appears
to
to be
that.
that it has been equated by a special agency investigation is equated with a police investigation. Only that.
Yes, but a complaint is equated to a charge sheet.
That
Because they
we are
file a
not
charge.
finding from this judgment.
I will just give it to my lords.
It's my failure, my limitation. I can't understand from this judgment.
Just give me a minute, my lord, because I will just give it to my lords, my lord. Then come to the other judgment, my lord, Ashok Chunilal.
Very yes.
Ashok Munilal Jain, my lords.
That's very well. We'll come to that.
Yes, my lord. Kindly can I have a look at para 114 of Deepak Mahajan, my lord. I'm sorry, I missed the para. Of Deepak Mahajan.
Please give me half a minute. We have gone out of it. (114) Yes, 114.
Apart from those two special acts under consideration, there are various other central acts containing provisions of prevention of offences enumerated therein, also for enforcement of such provision. Certain provisions of central acts, which you'd like to give below by way of illustration in a tabular form, showing the powers officers enjoy certain powers during the course of any investigation or inquiry or proceeding under the special act concerned, though not in the strict sense of investigation under Chapter 12, and undertaken by the police officer, including filing a police report under 173(2) of the code. So those powers are there, my lord, that my lords will see, including
yes,
the filing of police report under 173(2).
So they can act as an investigating agency just like the police.
Yes,
no doubt
for
on
the
that.
purpose of remand and for the purpose of filing of a charge sheet, the complaint is treated as a charge sheet, because otherwise, my lords are aware, if the charge sheet is not filed within 60 days, they get default bail. So in the case of an investigation by ED, the charge sheet, instead of a charge sheet, the complaint is treated as a charge sheet. Now kindly come to Ashok Munilal Baloots. Which is the paragraph?
Four and five.
Kindly have a
Yes,
look
sir.
at para 4 and 5 of Ashok Munilal, my lords.
Para 4 and 5, yes. Yes. Please place it.
We may also refer to the judgment of this court in Directorate of Enforcement. Get those prejudice arguments. We may also refer to the judgment of this court in the Directorate of Enforcement versus Deepak Mahajan, wherein it was held as under para 136. I have read 136, I must skip. Thus, we do not agree with the opinion of the High Court that provisions of 167 CRPC would not be applicable to proceedings at the PMLA. In the present case, as no complaint is filed even after the expiry of 60 days from the date when the appellant was taken into custody, he was entitled to statutory bail in view of the provisions contained there. And therefore, it is equated with a charge sheet. Therefore, stricto sensu, it is under 190B. That is, therefore, the provisions of 223 will not apply. Then, my lords,
It's there in the compilation of this.
it's in the compilation there.
Yes, it will go this way.
But there's a now kindly have a look, my lords, at the third submission. Kindly have a look at section 511 of the BNS, which is akin to section 465 of the old CRPC, my lords.
Yes, please. Section 511.
Just give me a minute.
Yes.
Just give me 1 second.
Yes, it's absolute.
This is similar to section 465. It is identical to 465 of the old code. Now, this has been interpreted by the Supreme Court on 2 or 3 judgments. First, I'll read this 511, my lords.
Yes.
Subject to the provisions herein before contained, no finding, sentence, or order passed by a court of competent jurisdiction. So, order taking cognizance was passed by a court of competent jurisdiction.
Yes.
Shall be reversed or altered by a court of appeal, confirmation or revision, or on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before or during trial, or in any inquiry in other proceedings under the Saita, or any error or irregularity in any sanction for the prosecution, unless in the opinion of the court a failure of justice has been occasioned thereby. So, failure of justice has to be occasioned, and they have to demonstrate before an order is set aside.
All right.
Now, how that has been interpreted, I'll come to that. Before I come to that, my lords would appreciate that the accused have a right of hearing at the stage of discharge. My lords may kindly have a look. That the accused have a right to plead and argue for discharge. So even if cognizance was wrongly taken, they can always move for discharge. This is one of the grounds I'm pitching for saying that no prejudice, there will be no failure of justice. Now kindly have a look at one judgment of the Supreme Court, Vertigo Marketing, when it appeared, 2021 2 SCC 525. Serial number 17 of my compilation.
Compilation. 2 volumes were handed over.
Oh, yes.
May I kindly take page 313 at the second volume.
Mr. Raju, you've always been courteous. Give me the compilation.
We have handed over. On the last occasion, we have handed over. On 19th of May.
Mr. Banerjee has usurped it.
Yes.
300 and Mr.
313 at volume 2.
Just a minute.
Right.
It was
Got
a case
Got it.
when in violation of. Where have you given it to me?
Yes, yes. Paragraph 23.
Yes.
Is given 324.
My lords, may kindly have a look, my lords. The facts, my lord, that CBI had investigated, CBI did not have any jurisdiction. Now, my courts, my kindly have a look, my lord. The CBI, the issue was CBI did not have jurisdiction. My lord, kindly have a look, my lord, to paragraph 12, my lords. What was the contention?
Yes, please.
Sri Mukul Rodge, learned senior counsel appearing on behalf of the appellant, submitted that in absence of the consent of the state government under Section 6 of the DSP Act, DSP CBI had no powers to conduct investigation in view of the provisions contained in Section 6 of the DPSC Act. So that CBI had no powers to conduct the investigation. Then, my lords, kindly come to para 15 where my submissions are recorded.
Right.
First part is not relevant, my lord.
No.
Para 15, my lords have got it?
Yes,
1-5.
yes. Yes.
The so-and-so learned additional Solicitor General would submit that prior consent under Section 3 is not mandatory, but directly submitted in any case, unless the appellants point out that on account of the procedural irregularity of not obtaining prior consent, prejudice is caused to the appellants, or it has resulted in miscarriage of justice, the investigation would not be vitiated. He submitted that insofar as the appellants' private individuals are concerned, the grievance of the said appellant is totally unwarranted in as much as notification so-and-so, which is general consent, has been granted to investigate the matters arising of the PC Act, unless it concerns the public servant under the control of the state government. In so as public servants are concerned, the learned additional Solicitor General submit that in any case consent has been granted after completion of investigation on so-and-so, and as such defect, if any, stands cured. He submitted that in any case, there are no pleadings by the appellants, public servant, with regard to prejudice caused to them or with regard to miscarriage of justice. He therefore submit that no interference is warranted with the judgment of the High Court. So there has to be pleadings, and I'm not sure whether there are pleadings in this regard. Then, my lords, kindly come to paragraph 23.
Yes, please. Paragraph 23.
It would be apposite to note the following observations of this court in state of Karnataka versus Kuppuswamy Gounder. So, while considering the provisions of Section 460, 465 is identical to 510, my lords.
All right.
I could, however, observe that the provisions of Section 465 cannot be made use of to regularize this trial. No reasons have been stated for this conclusion. Section 465 reads as under. I may skip because it is identical to 510.
Yes, yes.
My lords.
No need.
It is provided that a finding or sentence by a court of competent jurisdiction could not be set aside merely on the ground of irregularity if no prejudice is caused to the accused. It is not disputed that this question was neither raised by the accused at the trial, nor any prejudice was pleaded either at the trial or the appellate stage. My submission is they have not pleaded here also.
Factually incorrect. We have taken a specific ground.
Mr. Raju is just taking a chance. He has not gone through the pleadings.
Yes. It is.
It's very obvious from his. Yes, Mr.
It is
But
not.
let us learn the
I
law
show
first,
that
then
there's no
they will-
prejudice. My alternate submission, even if they're pleaded, there's no prejudice because they get a right at the
It's
stage of
generally
decision.
not pleaded, so you took a chance.
Yes, madam. Therefore, even if it's pleaded, On law, it is incorrect because law provides them an opportunity at a later stage, which is a bigger
Prejudice
opportunity.
also has to be shown, right?
Yes. It is not disputed that this question was neither raised by the accused at the trial nor any prejudice was pleaded either at the trial or the appellate stage. And therefore, in the absence of any prejudice, such a technical objection will not affect the order or sentence passed by the competent court. Apart from Section 465, Section 462 provides for remedy of trial in wrong places. We are not concerned with wrong places. This court, para 24, blood.
24, yes.
This court in Union of India versus Prakash B. Hinduja, by relying upon judgment of this court in H.N. Risport, held that if cognizance is in fact taken on a police report initiated by breach of a mandatory provision, so breach of a provision of hearing if cognizance is taken, there can be no doubt that the result of trial which follows it cannot be set aside unless the illegality in investigation can be shown to have brought about a miscarriage of justice, and that illegality committed in the course of investigation does not affect the competence and jurisdiction of the court for trial. This being the legal position, even assuming for the sake of argument that CBI committed an error or irregularity in submitting the charge sheet without the approval of CVC, the cognizance taken by the London Special Judge on the basis of such a charge sheet could not be set aside, nor could further proceedings in pursuance thereof be quashed. The High Court was clearly in error in setting aside the order of the Learned Special Judge, taking cognizance of the offence and in quashing the further proceedings. It could thus be seen that this court held that even for the sake of argument that CBI had committed an error or irregularity in submitting the charge sheet without approval of CVC, the cognizance taken by the Learned Special Judge on the basis of such a charge sheet would not be set aside, nor could further proceedings in pursuance thereof be quashed. Recently, a bench of this court consisting of one of our Justice Khanwilkar had occasion to consider the aforesaid provisions of Delhi Special Police Establishment Act in Kanwal Tanuj versus State of Bihar. In the said case, the question arose as to whether an offence was committed in the Union Territory and one of the accused was residing and employed in some other state outside the said Union Territory. The members of DSP had no power to investigate the same unless there was specific consent given by the state concerned under Section 6 of the DSP Act. The contention on behalf of the appellant before the High Court was that once the appellant was employed in connection with the affairs of the government of Bihar, an investigation was not permissible unless there was specific consent of the state of Bihar under Section 6 of the DSP Act. This court rejected the said contention, holding that if offence was committed in Delhi merely because the investigation of the said offence incidentally transcends to the territory of the state of Bihar, this would apply for the CBI case also.
This is relevant for the CBI.
Yes. And there's one submission I will make in the CBI case for
on the last package. Yes.
Submitter, which goes to the root of the matter.
Yes, yes.
Merely because the incident transcends to the territory of state of Bihar, it cannot be said that the investigation against an officer employed in the territory of Bihar cannot be permitted unless there was specific consent under Section 6 of the DSP Act. While considering the argument on behalf of the state that such a consent was necessary for the CBI to proceed with the investigation, this court held the respondent said having granted general consent in terms of so and so, it was not open to the state to argue the contrary. In the present case, there are no pleadings by the public servants with regard to prejudice caused to them on account of the non-obtaining of prior consent. Under Section 6 of the DSP Act, quad them specifically in addition to the general consent enforced not with regard to miscarriage of justice. So there has to be pleading with prejudice and with regard to miscarriage of justice. In so far as reliance on the judgment of Mayawati and Mayawati escape, my lords, that was on facts. In the result, we find no reason to interfere with the findings of the High Court. My lords are aware that even under the administrative law, the earlier law was failure to comply with natural justice vitiates the order.
Yes.
But now there is a sea of change. They must plead and prove prejudice is now the latest position of law. Now, my lords, may kindly have a look. I will have a look at their petition. My lords, give me the petition because my lords are right. I did not read the petition. Is there a prejudice?
Mr. Raju, we are
short unless my learned friend points out where they are pleaded, my lords.
Mr. Raju, I think we
are
at the moment we are confining ourselves to this section 223 first proviso argument only. I'm not hearing you on the other points because since you have opposed that and you have argued also on that. So, should we permit Mr. Chaudhary to complete his argument on the merits of the matter? Otherwise, also then take your comprehensive
So
objection.
let me, my
Yes,
learned
Mr.
brother
Chair.
may my lord conclude on this. Whatever he wants to say, I have no
Yes,
problem.
No, no.
this point,
This
Mr. Raju,
point-
please conclude. Yes.
This point I'll point out from the only
I
thing
will,
that
my lord,
remains,
make.
I'll point out from his
I,
pleadings.
my lord, ended it abruptly by citing that Supreme Court
Yes,
and
exactly.
said that if my
He was
brother was to
overconfident,
concede,
but
I
he
have
was
nothing to say.
overconfident.
If he's
Exactly,
arguing, I'll
because
respond. my
there
lord.
is no question of concession. So,
Hmm.
Mr. Raju, let them, let you have the advantage of hearing them first.
Yes, ma'am.
Fair enough.
On the,
Only
But
on,
actually, Manoj, my
only on this
hearing in
ground.
that
Mr. Raju is
Rahul
saying
Gandhi case is going. My hearing in the Rahul Gandhi case is going on. Actually, Mr. Singhvi's arguments have started. Anyway, I'll be here. But in case
Mr.
5 minutes,
Mr.
I have
Raju, you
to go, I'll
can
tell my lord.
probably manage that and come back and ask
No,
someone
no,
to take your
I'll
notes.
do it virtually. I
My
can't
lord,
go there, Manoj.
just don't leave for 30 seconds, my brother. Right? So, my lord,
No, no,
a
I am
fairest
here only. Don't
counsel,
worry.
a fairest counsel like Mr. Raju appears in this case, Rahul Gandhi's case, and concedes before the magistrate that don't take cognizance without hearing them. You have to hear them. Now, another counsel in Kolkata goes, the learned court is not apprised of 223, and he takes cognizance. And now my friend, my lord, holds a flag that this should be justified. Accused have to show prejudice. I do
I'll
not
tell
know,
my
my
lord
lord.
the
Just a
difference.
moment, brother. Let me complete
And there's a
the complete
difference
the
between
sentence.
the
Let me
Rahul
complete
Gandhi's
the
case
sentence.
and this case.
Article 21, my lord, is couched, all fundamental rights under part 3 of the Constitution are couched, my lord, in a negative preface, my lord. No person shall be deprived of his life or liberty except in accord with procedure established by law. Now, procedure established by law, the moment it is violated, your lordships have said that's, my lord, the fulcrum, the heart and soul of the Constitution. Would I have to show prejudice? Is it a case of an unempowered magistrate taking cognizance? But cognizance is taken by application of judicial mind. End of the matter. Therefore, it is irregular, which do not vitiate proceedings. A magistrate not following procedure, fundamental right under Article 21, my lord, is not only at the hands of investigating agencies. With utmost respect, even the procedure before adopted by a court can violate an accused right under Article 21. And this is exactly the position. And if this was the case, rest I have to respond to 5-6 things, but just note one thing, my lord. The main judgment that I'm citing, the exact argument my brother is making here, he's appearing there. What was the occasion for him not to make that argument before the Supreme Court in Kushal Kumar Agarwal? There was a cognizance order taken, it has been set aside. Direct SLP was filed against an order of a special judge in that case, my lord. Please mind it.
Mr. Chaudhary, we should not personally castigate
No, my lord.
counsel. Counsel are creatures of instructions. So,
No, I'm not, my lord. There is
us-
no question of us.
Mr.
In
Raju
fact,
or
on
Mr.
the
you
contrary, I have the greatest regard. What I'm saying is,
might have consented in another case, but not consenting, not conceding in this case. So let us forget that. Just let us be on.
but if it's done on this, I have 5-6 submissions to make on this issue alone. So that I conclude it.
Exactly.
My lord.
So, Mr. Raju, if you have concluded on this point, let Mr. Chaudhary conclude on the other points, and then we will
No,
take
this
your
point, my lord, first. I have to
This
show
point
to
I have to
nothing.
show from the writ petition. I have to show that there are no averments of prejudice,
Right.
contrary to what my learned friend has said. And therefore, I'll have to take my lord to the writ
So
petition.
by now your learned, your competent learned junior who was assisting you must have
read.
done that.
This is Samrat Goswami who is from Calcutta is with me, my lord. I pulled him up from Calcutta. He has done it. I found him to be quite good. Therefore, I called him from Calcutta here.
You must have done it by now.
He has done it. Yes, my lord. I come here and show you here. I don't know whether
So
you
we
know
can
my lord.
we can get the paragraphs so that he can respond. Yes.
So he has looked up and he has said, I don't know whether my lord recollects.
That's
So
right.
he is assisting me very able. He assists me very ably, my lords. And my lords may say that he has gone through the writ petition. There are no averments of prejudice or miscarriage of justice.
Very well.
Correct?
Then it is the duty is cast on Mr. Chaudhary to show me the
Point out the paragraphs.
Right.
In any case, even if there are averments, my submission is because of law there can't be any prejudice.
Yes, yes. So, Mr. Raju, you have completed on this point, the first point.
This point of yes.
Yeah, no, I'll yet to argue, my lord, on anything else. I'll argue later if I'm not able to persuade your lordships here.
No,
So, lord,
I think you should complete your arguments on all points. Then we'll take, because otherwise this will ping pong game.
Lord, let me say that I am
My
confining
learned
my
friend
petition
began by
as
saying
being
that I'll finish off in 10 minutes. My learned friend said, yeah, I'll finish off in 10 minutes. I don't have to argue
I had
anything
taken only 3 minutes, brother. You've forgotten. You have taken all the time. I'll just
No, Mr.
complete
Chaudhary,
on this
please.
aspect.
Absolutely, please.
And I'll confine it to this aspect for the time being, brother. So I may not bother your lordships on anything else. So, my lord, 2 things. my learned brother concedes that section 223 proviso had to be honored by the court. If not honored, then, my lord, it's an irregular proceeding which does not vitiate the trial. And, my lord, if at all it was to vitiate, then, my lord, the accused have to stand for a test of prejudice. That's all. So his contention is not that this proviso is completely ocious.
No, my contention is because the charge sheet is not applicable is also my contention.
I'm answering that, brother.
Don't put words in my mouth, sir. Don't put words in my mouth.
All right. Let us say, my lord, let us, my lord, start with the other way around. There is a judgment of the Supreme Court of India in Kushal Agarwal, my first argument, my lord, which deals with this very situation. An identical order passed by the magistrate, a special judge under PMLA. It is taken in SLP before the Supreme Court because it's a coal block case, my lord. In coal block case, there is an order of the Supreme Court that all, my lord, cases will come directly before it. So, my lord, a direct SLP was filed before the Supreme Court. The Supreme Court entertains it, and, my lord, I wish to, my lord, reiterate and reread just those 3 lines. And those are, my lord, in Kushal Agarwal's case, page 4, my lord. My lord, the Kushal Agarwal's case.
Kushal Agarwal, you hand it up.
Yes, I hand it over. My lord, page 3. Page 3.
Page 3, yes.
Now, please have a look at this 3rd paragraph in this, my lord. In this case, admittedly, an opportunity of being heard was not given by the learned special judge to the appellant before taking cognizance of the offense on the complaint. Only on that ground, the impugned order will have to be set aside. I don't have to labor much, my lord, that this is complete declaration of law by the Supreme Court. Good, bad, or, my lord, not considered, say, my lord, 465 CRPC, or, my lord, the other arguments will not stand in the way. The arguments made by my learned brother would amount to, my lord, your lordships taking review of the Supreme Court order. If there is any grievance,
sorry to disturb you. Mr. Chaudhary, this judgment does not consider the previous judgment cited by Mr. Raju.
My lord, just a moment, my lord. I am therefore, my lord, I am constrained to say, my lord, that's my submission. Your lordships may note it. That my learned brother, the enforcement director, let me say, my lord, the enforcement directorate or the union is well represented by the most able people. Whether the Supreme Court has considered or not taken it fit to consider, I do not think, my lord, that the Honorable High Court would venture into look at the Supreme Court judgment. If he is aggrieved, he could be filing a review. I ask a simple question. If the judgment has failed to consider something very vital, and it is per incurium, let us assume, is a review filed? Is anybody aggrieved with this?
According to you, what is the law if there are 2 conflicting Supreme Court judgments?
Please, my lord. If there are 2 conflicting
Supreme
Court
does not consider the previous.
My lord, the first latter will prevail. That's the law. If they are of co-equal strength, then the latter will prevail. But, my lord, be that as it may, there is no conflict. Let me show, my lord, no, there is no conflict because there was no occasion. This provision came in 1st July 2024, and this is the first judgment on the subject. There is no other judgment. So, my lord, let me say that with some kind of responsibility. No, my lord, just look at, my lord, the submissions made by my brother in, my lord, totality, and I'll just make it good. Ashok Munilal Jain, my lord, I happen to be the culprit counsel. I went to Madras, my lord. Madras, a person is arrested.
Yes.
60 days period elapsed. They don't file a complaint.
Right.
Now, my lord, the argument there is that we are not police officers. 167 speaks of charge sheet, police case diaries. We are not meant to maintain it. And therefore, 167 will not apply. If we arrest a person, he will languish in custody even if we don't file a complaint. That's, my lord, the essence. The High Court, my lord, with utmost respect, obliged at that time, and my lord fell into that error. I had to come in SLP before the Supreme Court. In Ashok Munilal Jain, 2 things were considered, my lord. First, please have a look at section 65 CR of the PMLA.
PMLA. PMLA Act আছে?
Yes, my
lord. Yes.
That's why I'm conceding.
Yes, I'm going to read. 65.
65. Yes. Yes, please. Yes, CRPC applies.
Code of Criminal Procedure,
no doubt,
applies to, my lord, what? Please have a look at, my lord. to arrest, search, seizure, attachment, confiscation, investigation, prosecution.
Right.
Mark that word, my lord. Prosecution and all other proceedings under this act.
Yes.
Now, two judgments of the Supreme Court, your lordship may just note because they are mentioned in Kushal Kumar Agarwal, which is my lord Yash Tuteja. Yes, Yash Tuteja, and my lord the other one.
This is for the proposition that
No.
this is for the proposition that BNSS or CRPC applies.
Yes, my lord.
That is the law is that.
The law is settled, and my lord, the Supreme Court holds that procedure. Now, please mark this, my lord. The Supreme Court is holding on those two judgments. Your lordships are asking me which judgments, my lord. I am saying consonance, not conflict. Yash Tuteja, Tarsemlal hold that procedure of complaint cases. Now, please mark this, my lord. Please go to chapter 15 of the CRPC for a moment. Just have a look at chapter 15 of CRPC, section 200. CRPC, my lord, it's complaints to magistrates.
Yes.
Like section 223 today.
Yes.
So that procedure applies. That is why, my lord, come back to for a moment to Kushal Kumar.
It's the other way around actually. It's to say that investigation process applies to special agencies as well, just as the police officers.
No, my lord. I'll show, my lord, Vijay Madan Lal Chaudhary what was the argument. Here, my lord,
No,
with his usual erudition.
The regards of investigation have to be adhered to by the special agencies also, just like the police officers.
When they are arresting, my lord, they apply CRPC. But, my lord, the law is, the last line is, unless it is inconsistent with the provisions of the Act. And section 71 of the PMLA says that PMLA has an overriding effect.
Yes.
Right? Now, overriding effect, unless it is inconsistent. So, law, my lord, comes as Constitution Bench in A.R. Antule's case.
Yes.
That, my lord, CRPC is the parent statute. It always applies to either offences under IPC or any special statute. But wherever special statute prescribes a procedure which is contrary to the CRPC, that will prevail.
65 is there.
65 is that same.
It
It is
endorses-
reiteration of section 4.2 of CRPC.
Endorses that
Absolutely. Correct, my lord. Absolutely. I don't have to say anything else.
Yes, no.
Now, my lord, on this aspect alone.
Yes.
So once, my lord, the PMLA provides two things now. Please have a look at section 44.
Yes.
Lordship would see, my lord, section 44, which is, my lord, offences triable by special courts. Now, please have a look at 44(1)(b). Thank you. First, my lord, start with notwithstanding anything contained in CRPC. Now, this is displacement of CRPC. This is exactly 65 and 4.2, which we are talking about. Notwithstanding anything contained in CRPC, please see B now, my lord, 1B. A special court may, upon a complaint, please mark this word, my lord, made by an authority authorized in this behalf under this act, take cognizance of the offences under section 3 without the accused being committed for trial. They displace the word charge sheet completely. It is complaint. Now, complaint, you read it as, my lord, charge sheet. It is not complaint. I don't think, my lord, that would occur in the present case. Wherever legislature wanted that a complaint would be treated as charge sheet, they have said so, and I'm going to demonstrate section 212 of the Companies Act 2013. Now, in 2013, in Companies Act special, my lord, that's SFIO, the Serious Fraud Investigation Officer, came into being. And my lord, earlier it was not a statutory body, now it is a statutory body.
Yes.
Now, there 212 subsection 15.
Yes.
212(15). I just read these three lines.
Yes,
Your lordship,
the same regards apply to them also.
my lord, same regards, no, they say something else. It is very interesting. So 212(15) says, my lord, notwithstanding anything contained in this act.
Yes.
Can
you can read out just. I have the company law, but
my lord, I'll just read it. This is just 3 lines. My lord.
yes, please read out.
Notwithstanding anything contained in this act or any other law for the time being in force, the investigation report filed with special court for framing of charges shall be deemed to be a report filed by a police officer under section 173.
Right.
So this is legislative intent, my lord. Legislature does not omit anything. The, my lord, statute has to be considered on, my lord, the first basis, which is, my lord, a simple basis. You cannot give it a colorful interpretation of your own. So complaint word is used. Now go to section 45 of PMLA, my lord. Section 45. My lord.
Yes.
Now, please mark this, my lord. The words used were offences to be cognizable, the head note. Now, cognizable offence, my lord, under section 154 CRPC, the moment cognizable offence, FIR was to be registered.
Yes.
Under 157, a report would have to be sent to the court, and then a charge sheet is filed after conclusion of investigation under 173. Exactly, this is what we argued in Vijay Madan Lal Chaudhary. It's my case too, Vijay Madan Lal Chaudhary, my lord. And in that case, my argument was precisely this. And the, my lord, Supreme Court, how it deals with it, I'm going to show, which is, my lord, Mr. Raju's argument, which is that ECIR is not equivalent to FIR. It does not follow chapter 12 principles. 173 is also in chapter 12, what he now pleads here. To the contrary. So Supreme Court holds, my lord, whatever they wanted it, my lord, they argued that it is not equivalent to FIR. No 154 report is, FIR is to be filed. No report to a magistrate ought to be sent. And it is an internal document. And copy will be supplied only after filing of complaint. If this is, my lord, the law laid down.
Argument.
No, that's the law laid down now. And please mark those 3-4 paragraphs, my lord. Paragraphs, Vijay Madan Lal Chaudhary, 456 onwards, my lord, for about till about 459 of Vijay Madan Lal Chaudhary. Exactly, and with the caption ECIR versus FIR. And exactly that argument repelled. We made that argument on the contrary, that it should be treated as this. But, my lord, the Supreme Court said in. Just see, my lord, 45, I want to show. So 45, my lord, after the head note, please come to second proviso in 45.1.
Yes.
Second proviso, my lord, which says provided further. Do your lordships have it?
Yes.
First proviso is the twin conditions of bail. Second proviso, my lord, is provided further that the special court shall not take cognizance of offence punishable under section 4 except upon complaint in writing made by so and so. They have displaced section now 210 BNSS, earlier 190 CRPC. Now 210, my learned brother read, its law takes cognizance on 3 aspects. 1, on a police report. 2, on a complaint. 3, the court on its own motion. So, my lord, all 3 things are distinct. If this legislature 44(1)(b), second proviso to 45, contemplates it is only on a complaint, then to argue that this is equivalent to a charge sheet, my lord, is nothing short of blasphemy. It is, my lord, contrary to the spirit, legislative intent and spirit. We can't rewrite what the parliament has enacted. This is the lawmaker's intention. It has to be complaint. It has to be a complaint. You have to follow procedure. You have to follow procedure. So therefore, my lord, in this compilation which I had given case digest, just have a look at few of them. I just want to show to your lordships. There's not one, and they have all been accepted orders. Different high courts across the country. And as I said, my lord, since yesterday I got an order from Gujarat High Court. Day before yesterday, my lord, we have, my lord, got orders in Chandigarh High Court, where also there was a concession in PMLA case by Mr. Hussain, who's a special counsel. In PMLA case, there is a concession that yes, order has been passed without hearing. We have no objection, but you do it. I'm not saying, my lord, you may concede in one case, but not in the other. But, my lord, this practice, with utmost respect, has to be consistent. ED can't be seen as, my lord, doing things differently in Calcutta and, my lord, differently in Bombay, Chandigarh, or, my lord, Delhi. It has to be consistent. This one department. So, my lord, it has to be pristine standards of objectivity. So, my lord, in that compilation, your lordships will find 2-3 concession orders.
Will we get a compilation?
Sorry?
Will we get
Give him a case digest.
compilation?
Case digest.
Yes, yes.
This one.
This is a case digest. No, my lord, please have a look at.
Yes, you may.
No, this is Delhi High Court at serial number 3.
Yes.
This, please mark this, my lord, it's Delhi High Court, we've not mentioned. So, my lord, as sequitur to the submissions made and on a bare reading of the impugned order, whereby it is clear that no opportunity of hearing was granted to the petitioner before cognizance was taken against him, and relying on the bare text of the first proviso, the effect and operation of the order dated insofar as it applies to the petitioner shall remain stayed. There was a stay and subsequently set aside. See, my lord, the next one, Patil's case, my lord, this is a case from, my lord, Karnataka High Court. You've not mentioned the High Courts. Please mark this, my lord, Karnataka High Court.
Yes.
My lord,
I'm
just
sorry, my lord, interim orders can't be cited as precedent. There shall be a stay, my lord. How can it be cited as a precedent? My learned friend is citing interim orders as precedent, unheard of.
Give me the liberty to argue it wrongly, brother. You will always be kind to me. You will condone my lapses. Please have a look at, my lord, the next order.
Yes.
My lord, therefore, notice shall be issued. The last lines. Notice shall be. I'm reading page 3 top, my lord.
Yes, I'm there.
It to the accused at that stage and after hearing the accused take cognizance and regulate its procedure thereafter. Next, my lord, Rakesh Kumar Goyal. This is, my lord, Punjab Haryana High Court.
Yes.
And, my lord, Punjab Haryana High Court also takes the similar view after an exhaustive analysis and says, my lord, the order is set aside, though, my lord, albeit it is in the realm of 174 IPC. See, my lord, Arvind Dham's order, which is passed. Last page of the compilation, my lord, I'm told. Second last page of the compilation. Show me Sonia Gandhi's order.
Yes.
तो पहले सोनिया गांधी दिखाओ.
In the index, it appears that Arvind Dham has signed it, but it's actually.
My lord, it's please see Mr. Zohaib Hossain. Para 3, my lord, of the order. You lordships have it. The Delhi High Court. Mr. Hossain, special counsel states, make instructions that prosecution complaint was filed on so and so. Therefore, fairly concede that in terms of section 223, so and so. The order set aside. Now, see, my lord, this Sonia Gandhi's, though, my lord, this is an order before the special judge. And I'm not my brother may take umbrage, but my lord, I'm only showing his own statement. Para 6.
We can take it as your argument. Right?
Please, my lord, please take it as my argument. My lord, I'm grateful.
Para 6.
Para 6, my lord.
Cite as my statement, I have a reply to it there.
It's all right. Let me show your statement, Mr. Raju.
Mr. Raju, you are writ large on all over these judgments.
All over.
So you are now in a difficult position.
Please
Anyway, we'll come back to you.
Para 6.
Para 6.
Mr. Raju Leonard ASG appearing for the ED has submitted that agency has no objection to the issuance of such a notice and that procedure specified in section 200 to 204 CRPC, corresponding provisions in BNSS being 223 to 227, is liable to be followed in complaint cases under PMLA by virtue of the decision of the Apex Court in the same law. I do not know. This was, my lord, even prior to Kushal Kumar Agarwal. How, my lord, today the stand has changed that this is not a complaint case. This is a charge sheet. Consider it under 173. Something, my lord, out of the blue. Which is, my lord, I would say only for Calcutta. Nowhere else. So, my lord,
for this court.
No. My lord, I'll just make one or two more. Sorry.
Yes.
State amendments अभी PMLA.
No, बेटा मेरी अशोक मुली का एग्जाम को तुमने क्यों दूर किया? आप अपना लिखो मेरा मत रिमूव करो, okay? Don't do that. Now, my lord, my brothers, one or two submissions, and I must, my lord, I make good in Ashok Munilal Jain. Now, Deepak Mahajan and Ashok Munilal Jain. So, my lord, I traveled to my lord Supreme Court. Once 167(2) was denied to me. Default bail was denied. My lord, what was held in Deepak Mahajan, and actually that's my brother's argument, and my argument is what he's arguing today. So I always said that they should be treated as police officers, and they should be treated as a cognizable offense. They should be actually registering cases and filing charge sheets. That's what we were saying. So, my lord, there also, the Supreme Court then took into consideration. Pardon?
Copy of Deepak Mahajan, which
It's
was
all right. My lords have it. My lords have seen the citation.
I've seen it.
My lords have seen it.
Good. Thank you so much.
Now, my lord, Deepak Mahajan and all, my lord, were dealt with in the context of, my lord, the Customs Act, where a complaint is prescribed, or a FERA, my lord, at that time, Foreign Exchange Regulation Act, which is repeated later, my lord, where also a complaint procedure was prescribed. That, my lord, their argument was, again, my lord, the court said that once person is arrested, 167 OSHIOS. So, my lord, they said no. Remand can be given under 167. So wherever the word police officer occurs, reads it as custom officer. It was not that custom officer, is a police officer. On the contrary, their argument is custom officers, ED officers are not police officers. So therefore, there's no question of filing of charge sheets. There's no question of lodging of FIRs. That's, my lord, the case.
That will be against the scheme of section 65 also.
Correct, my lord. Therefore, my lord, when the procedure prescribed under PMLA was seen,
yes,
and in the light of Vijay Madan Lal Chaudhary's emphatic judgment in those 4 paragraphs that it is not equivalent to FIR, my brother's argument that, my lord, this is equivalent to Ashok Munilal Jain, my lord, came to my rescue. Supreme Court said that unless, my lord, please have a look at Ashok Munilal Jain for a moment. And that is a paragraph which is the heart and soul of that. I
have made it clear, my lord. May I only So I made it clear
Just a moment, brother.
that I'm not saying it's a charge sheet. I'm saying it's akin to a charge sheet.
That's right.
Akin to.
So that's, my lord,
Yes.
equally misconceived, my lord. And that's what I'm arguing. Please have a look at, my lord. Ashok Munilal Jain for a moment. Paragraph 3, my lord.
Paragraph 3, yes.
Paragraph 3, my lord.
Yes, yes.
No. My lord, we have gone through the orders passed by the trial court as well as the High Court. We may state at the outset that insofar as High Court is concerned, it has not given any reasons in support of the view except endorsing the view of the trial court to the effect that provisions of 167(2) are not applicable to the cases under PMLA Act. Look, my lord, the sweep of ED's arguments. There they wanted to take away 167(2). Now they are relying on 167 and saying we are, read 167. It's a case diary. It's akin to charge sheet. Now, my lord, next line. 160 not applicable to cases under PMLA. This position in law stated by the trial court does not appear to be correct. And even the learned attorney general appearing for the respondent could not dispute the same. We may record that as per the provisions of section 4.2 CRPC, the procedure contained therein applies in respect of special statutes as well. Unless, please mark this, my lord, this according to me, these 4 words are the fulcrum. Unless the applicability of the provisions is expressly barred. That's what the expression used, my lord. Moreover, section
On the contrary, section 65 is, applying the...
they extract section 65 after these lines.
Yeah, exactly.
And they hold. Now, my lord, please come in this light. In this vein, I'll just meet the test of prejudice. What, my lord, is being pleaded here, as if I have to do it. I'm sorry, my lord. Section 465 CRPC, or, my lord, for that matter, 510, BNSS have no application in a case where procedure established by law is violated.
I was also thinking that what can be more prejudicial than being stigmatized by an investigation? I mean, that.
My lord, if,
anyway, Mr. Raj will answer that.
Yes, my lord. If procedure established by law, section 223 proviso is the procedure established by law. And if article 21 has to have any sanctity, even a minutest fraction, and your lordships will not hesitate to interfere. Here, my lord, abruptly, with utmost respect, there were 3, my lord, stakeholders there. The, my lord, the investigating officer, the public prosecutor, and the learned court. There were 3 people. I was definitely out. If they do not even apply their mind to 223, that there is a statutory provision existing, there is a caveat. It's like sanction, my lord. No court shall take cognizance. Now, my lord, I just asked my learned brother, under the Prevention of Corruption Act, section 19, no court shall take cognizance of any offense unless there is a previous sanction. Now, my lord, assuming a case without sanction, cognizance is taken. No, it's a curable irregularity. You can go and argue at the time of charge. I am astonished. Will this argument ever prevail, my lord? This is, my lord, with utmost respect, wherever Article 21 is contravened, there, my lord, the laxity of the, my lord, would say authorities lies, in the laxity of the authorities lies the, my lord, liberty of person. The history of liberty is history of procedural safeguards. And that's what your lordship is about. Allow me to read 2 paragraphs, my lord. They're very close to my heart. 2 judgments, my lord.
Absolutely.
One is the Constitution bench in Baldev Singh. And, my lord, the other one is an NDPS matter. And second is, my lord, Bhajan Lal. Though we cite Bhajan Lal for, my lord, quashing and those principles. But, my lord, I am reading a different paragraph, which is paragraph 60 for a moment. Bhajan Lal.
The definition of police report to forwarded by police officer.
My lord, no. Let me take. Please, Bhajan Lal, para 60. My lord, the citation of the judgment is, my lord, 92 supplementary, 1 SCC 335. 335. You have it on your screen. Please give it. Please give it to my please. May I, my lord, have the liberty of showing it through an iPad?
That will be quicker than...
Yes, my lord. Yes, my lord.
Yes, thank you.
I'm sorry, Bhajan Lal.
Yes. My lord, just have a look at paragraph 60, which would your lordship will find at page, my lord, though this was at the stage of, my lord, quashing an incompetent officer.
Right.
Had, my lord, started to investigate a PC Act offense.
Paragraph 16, Mr.
My lord, 60, which is at page 364. 364.
Yes, please.
The sum and substance of the above deliberation results in a conclusion that investigation of an offence is the field exclusively reserved for police officers whose powers in that field are unfettered, so long as the power to investigate into cognizable offences is legitimately exercised in strict compliance with the provisions falling in Chapter 12 of the Code, and the courts are not justified in obliterating the track of investigation when the investigating agencies are well within their legal bounds as aforementioned. Indeed, a noticeable feature of the scheme under 14 is that a magistrate is kept in the picture at all stages of the investigation, but he is not authorized to interfere with the actual investigation or to direct the police how that investigation is to be conducted. Now, see, my lord, this 5-6 lines now. But if an officer transgresses the circumscribed limits and improperly and illegally exercises his powers in breach of any statutory provision and causing serious prejudice to the personal liberty and also property of a citizen, then the court, on being approached by the person aggrieved for the redress of any grievance, has to consider the nature and extent of the breach and pass appropriate orders as may be called for, without leaving the citizens to the mercy of police echelons, since human dignity is a dear value of our constitution. It needs no emphasis that no one can demand absolute immunity even if he is wrong, and claim unquestionable right and unlimited powers exercisable up to unfathomable cosmos. Any recognition of such power will tantamount to recognition of divine power, which no authority on earth can enjoy. I am not making this submission in a context. It is not on facts, but in context. See one paragraph of Constitution bench in my lord Baldev Singh. My lord, we'll just point out from here.
May I only request my learned friend to read the facts on what grounds the Supreme Court.
That's right. I brother clarified. I put a caveat. I know where it is coming from.
It is watered down. It was an investigation by not by a DYSP. That was the ground.
Correct.
That has now been watered down in large number of judgments.
My lord, with my most erudite, my lord, opposing counsel, who is actually my lord, with utmost respect, I've learned a lot from him. We've been together, and his going to that side has been a big gain for me on professional side. Though I always tell him that. My lord, see paragraph.
But on the monetary side, it has been a bigger profit.
So whichever way, Mr. Raju, you might have been in my shoes here. Had you not been there, we would have.
Your shoes are now costlier. Your shoes are now costlier.
My lord, see paragraph 28, my lord. The argument was, what if section 50 has not been complied with? What? There is some recovery affected of a contraband. What will happen? So, my lord, that's the answer being given by the Constitution when this was, my lord, whether section 50 is mandatory. Again, it's not on fact, but, my lord, it's on a position of law where Article 21 stands. Please, paragraph. My lord, your lordship will find at page 28. Page 28, para 28.
Para 28, yes.
Please, I'm there. This court cannot overlook the context in which NDPS Act operates, and particularly the factor of widespread illiteracy among persons subjected to investigation for drug offences. It must be borne in mind that severer the punishment, greater has to be the care taken to see that all the safeguards provided in a statute are scrupulously followed. We are not able to find any reason as to why the empowered officer should shirk from affording a real opportunity to the suspect by intimating him that he has a right that if he requires to be searched in the presence of an officer or a magistrate, he shall be searched only in that manner. As already observed, the compliance with procedural safeguards contained in 50 are intended to serve a dual purpose: to protect a person against false accusation and frivolous charges, as also to lend creditability to the search and seizure conducted by the empowered officer. The argument, now Lord, this is where it starts. The argument that keeping in view the growing drug menace and insistence on compliance with all safeguards contained in 50 may result in more acquittals does not appeal to us. If the empowered officer fails to comply with the requirements of 50 and an order or acquittal is recorded on that ground, the prosecution must thank itself for its lapses. Indeed, in every case, the end result is important, but the means to achieve it must remain above board. The remedy cannot be worse than the disease itself. The legitimacy of the judicial process may come under a cloud if the court is seen to condone acts of lawlessness conducted by the investigating agency during search operations and may also undermine respect for the law and may have the effect of unconscionably compromising the administration of justice, that cannot be permitted. My lord, this is the situation as we stand today. One, my lord, critical aspect that I, my lord, my brother's argument, and I wanted to, my lord, highlight with some kind of, my lord, assertion. So, my lord, we have traveled together, me and Mr. Raju, for the last about, my lord, 6-7 years together in this journey of PMLA. And I always state, my lord, that it's a work in progress, it's constant evolution. One of the cases, my lord, Pankaj Bansal, which set the tone for grounds of arrest, etc. We started from Punjab High Court. My brother argued that court cannot look into section 19 because its viris has been upheld. High Court dismissed my writ petition. I had to travel to Supreme Court with my learned brother with his most erudite discourse opposing. The Supreme Court, while allowing my lord SLP, and said the High Court should have intervened and should have gone into reading down of certain, my lord, aspects of section 19, which were left according to Supreme Court, left uncharted in Vijay Madan Lal Chaudhary. My lord, sounded a sage counsel, a word of caution, and accorded them a sage counsel. I wish to read only that paragraph, my lord. Pankaj Bansal, please.
এটা ফেরত দিন অনিন্দিতা প্রত্যেকবার হয়ে গেল না একটা জাজ এটা ফেরত দিতে হবে
You have it?
সাবধান এটা পড়ে গেল আমার অত পয়সা
I have it. I have it.
Pankaj Bansal is coming to me.
Pass on mine.
Mr. Chaudhary, the difficulty is with utmost respect. I mean, nowadays it appears that
Yes.
nowadays it appears that there are as many propositions as judges.
Please, my lord.
Nowadays it appears that there are as many propositions as judges. That is the difficulty, and thank God we don't have 142. Really, I mean, it depends on the judge. What is the perception of liberty and all these things?
Absolutely. No, there's no doubt about it.
We are in very difficult waters nowadays.
We were.
If you are a believer in personal liberty and every day you are being, I mean,
my lord,
that is,
I have always said, my lord, when my lord, happened to, my lord, go to National Judicial Academy and somewhere,
yes.
I always say, my lord, that the principle of stare decisis, as we were taught in the law schools, has gone for a toss. We have, my lord, Supreme Courts sometimes, my lord, with utmost respect speaking, and in different tones.
Yes.
And that, my lord, becomes. So I remember, my lord Justice Badar Duriz Ahmad, I was arguing a preventive detention matter. And identically, my lord, there were 2-3 judges bench on the same subject. Different, totally different.
Totally different.
So, my lord, now in writing that judgment, I was saying, my lord, that the latter would prevail and things like that. My lord says I have been asked to follow either of the two judgments. For me, my position is like a child who's called in a court to see whether he chooses his mother or father. Since I am going to go towards liberty, I choose this judgment. So it is a beautiful judgment, Lord. How
is the interplay we have to face in every matter now.
Yes, my lord.
Anyway,
my lord,
we are ready to face that. For that, we have chosen our profession. No difficulty.
So, para 21, my lord, just have a look at one paragraph. And I always cite that, my lord, for a reason. That, my lord, when your lordships look at it, this was a sage counsel, not just confined to this.
Let me
page 21, my lord. Para 21, page 12.
Give me half a second for the citation. Para 21, Mr.
Yes, my lord.
Yes.
This chronology of events speaks volumes.
Para 21.
Para 21, my lord. Page 12. Oh, my lord, maybe my brother has given your lordship. Para 26, maybe then. Para 26 with your lordship's file. This chronology, does it start with this chronology?
Yes, para 26.
Para 26. This chronology of events speaks volumes and reflects rather poorly, if not negatively, on the ED's style of functioning. Being a premier investigating agency charged with onerous responsibility of curbing the debilitating economic offense of money laundering in our country, every action of the ED in the course of such exercise is expected to be transparent, above board, and conforming to pristine standards of fair play in action. The ED, mantled with far-reaching powers under the Stringent Act of 2002, is not expected to be vindictive in its conduct and must be seen to be acting with utmost probity and with highest degree of dispassion and fairness. In the case on hand, the facts demonstrate that ED failed to discharge its function and exercise its power up to these parameters. My lord, this was just one-off case. What I'm, my lord, urging before your lordships is that this is the position of law as emanates from the Supreme Court's judgment. my lord, to read any further into that or to argue to the contrary is, my lord, would tantamount to a review of that judgment, which only the Supreme Court can do. And there is no parallel judgment where your lordships can hold that, well, there is a conflicting judgment and this is totally different to that judgment and something is held earlier. My friend, with his usual erudition, my lord, he may have a very valid point, but in the wake of, had there been no Supreme Court judgment, my lord, it was a valid point until, my lord, the law was declared by the Supreme Court. Though, my lord, I would say that law declared by your lordships is also binding. I'm not saying that.
No,
But Article 141, your lordships, my lord, there's more than...
Firuddin, बोलो मैं
Don't
protect
you want to say
the judgment
anything?
side.
Yes. What do you want to say? So it's okay. My brother wanted to say something. It's okay. Right. Yes, yes, yes. No, my lord, those two judgments, we'll just mark the paragraphs, Tarsem Lal and Yash Tuteja. They were prior to, my lord, Kushal Agarwal, where they said CRPC applies complaint cases CRPC. Chapter 15, section 200 to 204 CRPC. To specifically complaint cases. That's my first argument of my learned brother. That, my lord, CRPC, please forget it, complaint cases. This is akin to a charge sheet. Apply the other test. Don't even look at 200 CRPC. I'm astonished, my lord, that is in the wake of at least now 3 Supreme Court judgments. Yash Tuteja, Tarsem Lal, and finally Kushal Kumar.
If you can please formally just give the citations.
My lord, Kushal Kumar actually mentions,
you have already cited.
actually mentions those 2 judgments. If I can read that one paragraph, my lord, in Kushal, yes, yes. So that your lordship are clear. No, beta, please, Kushal Agarwal. The judgments are mentioned there. Let's see. My lord, please have a look at page 2, my lord, of Kushal Kumar Agarwal. Just take the last paragraph, my lord, at page 2.
Yes.
This court has taken a consistent view that a complaint, please mark the word complaint, my lord, filed by the Enforcement Directorate under section 44(1)(b) of PMLA will be governed by sections 200 to 204 CRPC. This is 223 now. To CRPC. This view has been taken by this court in the cases of Yash Tuteja versus Union of India and others, and Tarsem Lal versus Enforcement Directorate. Those 2 citations are given at the footing of page 3.
Yes.
So therefore, the provisions of chapter 16 containing sections 223 will also apply to a complaint.
The rest coming. Yes.
So I don't have a better case to argue after this Supreme Court judgment. That's it. They do. Pass on. We are formally, my lord, passing on the judgments also.
Thank you.
Please. Well, so I will confine today, my lord, only to this issue. And, my lord, subject to, my lord, whatever your lordships would, my lord, accord imprimatur, or, my lord, whichever way your lordships will decide. I don't want to argue anything further, because if your lordships choose to reject my contention, my lord, then, my lord, of course, my lord, all the other, at this stage, I confine my petition only to this, so that I, my lord, not seen as, my lord, coming back again, your lordships deciding against me, for example, and coming back again. I'll myself confine it to this for the time being. And if I was to succeed, my lord, then obviously your lordships will send me back and I don't have to argue. I'll argue before the learned court at the stage of cognizance. The parliament had introduced this safeguard, my lord, and this is a procedure established by law. Grateful, my lord.
Thank you.
Yes. Yes. So I'll reserve my right, Lord, if I have to file if need be, at any stage to file a fresh petition on other grounds. I'm confining this today to this ground. I'm making a statement.
No, but Mr. Chaudhary, you can comprehensively argue. I mean, if you have other points, you argue that.
My lord, then,
otherwise it
so,
will be
my lord, if that's what I'm saying, my lord. If I succeed on this ground, then, my lord, Mr. Raju, I'm not pressing the petition on other grounds. Lord, that's my choice. That's what I'm saying. Today, my lord, at this stage, I'm not pressing the petition on any other ground. And, my lord, I confine it to this ground. And, my lord,
all other grounds.
Mr. Raju, I'm dominus litis. Allow me to make a statement.
No, but today you're supposed to argue. It was fixed for final hearing.
That's what I'm finally arguing. I'm not pressing it. When you force me to argue, I'm not willing to argue.
Raju,
I can force you because the matter is fixed for final hearing. It is not fixed for
This is final hearing. This is final hearing. I am not. I am making a statement. The lordship may record, my lord, that I'm not pressing on other counts. And, my lord, I'll if at any subsequent stage, my lord, any need arises, I'll file, my lord, a proper petition. Please, your lordship. Just the PMLA case, my lord, of course.
4 matters.
But in these other case, my lords are giving time to file reply. In other case, my lord,
they're filing CRR matters.
Yes. And, my lord, in the second case, since they have filed a reply today in court, we'll file, my lord, a reply. Your lordship may keep it after a week or so.
CRRs are the
In Delhi, we call it
CR,
WP, my lord, we are reserving the right to file our.
right. CRRs are the ED.
Yeah.
Right.
My lord, may I only make 2 submissions, my lord?
Absolutely, Mr. Rao. Yes. Thank you, Mr. Chaudhary. Thank you so much.
Grateful.
As far as
Yes, Mr.
Sonia
Rao.
Gandhi is concerned, it is not after the cognizance was taken, my lord. Sonia Gandhi was before the order of cognizance.
Mr. Chaudhary is probably more on the principles and the liberal views taken by the Supreme Court and the
Therefore,
general tenor of the judgments
I understand.
regarding Sonia Gandhi at least. Yes.
Sonia Gandhi is cognizance is not yet taken. We are still arguing on cognizance. Now, as far as 21 is concerned, kindly have a look at Article 21.
Constitution. Yes, Article 21. You can argue
No,
what
this
you.
well, I need to-
Yes.
No person shall be deprived of his life or personal liberty except according to procedure established by law.
Right.
516 is procedure established by law.
Yes, we are arguing. You are arguing only on law, both of you. So no difficulty on that. Yes. ছেড়ে দাও। Constitution করতে গিয়ে পুরো আইন তো উল্টে গেল।
Now, Bhajanlal, which my
Yes,
learned
yes,
friend
Mr. Raj,
argued.
no doubt on that. Section Article 21. Yes.
Now, Bhajanlal, the
yes.
issue was, which my learned friend did not go into the facts, but under the Prevention of Corruption Act, Section 5A, as it then stood under the 1947 Act, but only a DYSP was competent to investigate the offences. So if the offence is not investigated by a DYSP, what would be the result was in question. But there are a large number of judgments of the Supreme Court not considered in Bhajanlal, before Bhajanlal and after Bhajanlal, which have taken the view that even if it is not investigated by officer of the rank of DISP, the proceedings are not vitiated. I can give a long list of judgments right from HN Risput onwards, which are of a greater strength as far as Risput is concerned. But one judgment, which is a later judgment, but which relies on Risput, is 2005-12 SCC page 628.
It is there in your compilation.
Not there because he just cited it just now.
Achha.
I was
Mr. Raju, 2005-12 SCC. Can you please repeat the page number?
2005-12 SCC 628.
Yes.
628.
Right.
And rightly, my learned friend did not go into the facts of Bhajanlal. Now, kindly have a look, my lords. But kindly have a look at paragraph 5.
Paragraph 5, yes.
Learned counsel for the state contended that the impugned order of the High Court is contrary to settled principles of law enunciated by this court, and a catena of decisions is liable to set aside. Avoiding multiplicity, we may refer to the decision of this court rendered in the case of State of MP vs. Ram Singh. This court in Ram Singh, after noticing the various decisions of this court, inter held that a defect or illegality in investigation, however serious, has no direct bearing on the competence and procedure relating to cognizance or trial. The recent decision in Union of India vs. Prakash Hinduja, which one of us is the author, the judgment after noticing the various decisions of this court pointed out in paras 20 and 21 of the judgment as under. Thus, the legal position is absolutely clear and also settled by judicial authorities that the court would not interfere with the investigation or during the course of investigation, which would mean that from the time of lodging of the FIR till the submission report by officer in charge of police station in the court under 173(2) of the CRPC. With this field being exclusively reserved for the investigating agency, an incidental question as to what will be the result of an error or illegality in investigation or trial of an accused before the court may also be examined. Section 5A of the Prevention of Corruption Act 1947 provided no police officer below the rank of deputy superintendent of police shall investigate any offence punishable under section 161, 165, 165A of the IPC or section 5 of the said act without the order of the magistrate of the first class. In HN Dispute, the investigation was entirely completed by an officer of the rank lower than the Deputy Superintendent of Police. And after permission was accorded and little or no further investigation was made, the special judge quashed the proceedings on the ground that the investigation on the basis which the accused was prosecuted was in contravention of the Provisions Act. But the said order was set aside by the High Court. Appeal preferred the accused in this court. Assailing the judgment of the High Court was dismissed with the following principle laid down. Question that requires to be considered whether and to what extent the trial which follows as investigation is initiated. Now, the trial follows cognizance and cognizance preceded by investigation. This undoubtedly is the basic scheme of the court in respect of cognizance case. That does not necessarily follow that an invalid investigation nullifies the cognizance or trial based thereon. Now, my lords, come back to the facts of Bhajan. Bhajan Lal is contrary to respect with the larger bench judgment. Bhajan Lal is, my lord, my learned friend cited. My learned friend should have been fair and pointed out that this Bhajan Lal is an aberration, my lords, if I may use the words. Kindly have a look at para 60, my lord, which my learned friend cited, my lords. What was the contention?
Yes.
Sorry, my notes will just give me a minute. Kindly come to my lord, para 140.
Yes.
We set aside the judgment of the High Court, quashing the first information report as not being legally and factually sustainable in law for the reasons mentioned. But however, we quash the commencement as well as the entire investigation, if any, so far done for the reasons given by us in the instant judgment on the ground that the appellant 3 SHO is not clothed with the legal authority to take up investigation and proceed the same within the meaning of 5A of the Prevention of Corruption Act as indicated in this judgment. So the submissions and the paragraph which my learned friend was with respect to 5A, officer of the lower rank investigated the matter. It is in this context that the judgment of Bhajan Lal was rendered without taking into consideration HN Disputes case, HN Disputes case and other judgments which are cited in 2005. Disputes is a larger bench judgment, my lord. Therefore, the law is not that the investigation goes for a toss. They have to show plead and prove prejudice still remains. It is in this context that section 60 has to be read, my lord. You can't divorce a judgment from the facts of the case. On quashing, the Supreme Court said we are not quashing on any other ground, but for this limited ground of 5A. These were the facts of Bhajan Lal's case, my lord.
Now, Mr. Raju, could I ask you a question? Now, here the premise of one of the premises of your argument is that yes, just because of an irregularity, an investigation cannot be set aside unless there is a prejudice shown.
Yes.
Now, can you give me an example of what sort of prejudice at this stage? Do they have to say that I have these documents which I could have produced, or what is prejudice according to you? Apart from
yes, I'm obliged. Therefore, kindly come to 223. What is the stage of 223? I'm grateful for my lord for this question. But there are different stages which a magistrate is required to follow when a complaint or a charge sheet is filed. First is required to take cognizance. And second is issuance of process. After taking cognizance, process is issued. Issuance of process is different from cognizance.
Hmm.
My lords may kindly have a look at 223. It doesn't say issuance of process, it only says cognizance. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard.
Yes.
What is whether the magistrate shall take cognizance of the offence or not take a cognizance of the offence is required to be heard. That's all. No further hearing is required to the process. The process for is subsequent, my lord. Now kindly have a look at after it takes cognizance, he issues process. Cognizance is of offence. Process is against the accused. You may take cognizance of the offence and issue process against not all the accused, but a few accused only.
So do you mean to say, Mr. Raju, that the accused can at that stage point out that as per the complaint itself, no such offence is disclosed at all?
Made out. That's all.
All right. All right.
And there is no requirement. There is cognizance. The court is not bound to take cognizance. Now, at that stage, the magistrate is not required to go into the question whether I am going to convict him or not. It is very elementary stage.
All right.
There are judgments of the Supreme Court on this, which are good in Sonia Gandhi. There are judgments which say that at the stage of cognizance, Kanti Batra's case of Supreme Court says he need not even record reasons. Now, kindly, therefore, when a magistrate takes cognizance, 223, and kindly come to my lords, 227.
Yes.
Issue of process. So issue of process is different from taking of cognizance. My lords, about it?
Yes,
Even the
yes.
opinion of a magistrate. Get the compilation. There is sufficient ground for proceeding and the case appears to be a summons case. He said summon the accused for attendance. Provided the summons and warrant may also be issued through electronic means, etc. So this is the stage of summons, my lord. It comes later on after he takes cognizance. Then, my lords, may kindly have a look, my lords. To 226.
Yes.
If after considering the statements on oath, if any of the complainant and the witness as a result of the inquiry investigation 225, the magistrate is of opinion there is no sufficient ground to proceeding, he shall dismiss the complaint, and in every case he shall briefly record his reasons to do so. So while taking cognizance, there is no requirement of recording reasons. But while dismissing the complaint, there is a requirement of recording of reasons.
Reducing
The earlier law was, my lord, I may just point out. Earlier in K.M. Matthews Court, the Supreme Court said that the accused can apply for recalling of, what is the citation? Give the citation. Give my judgment sheet again. K.M. Matthews in 1992. What is it? Sonia Gandhi ka judgment. K.M. Matthews case, the Supreme Court held that if the process is issued, the accused can go to the trial court and say, recall the process. That held the field till Adalat Prasad and Subramaniam Seturaman. I'll give those citations, my lords may just give me a minute. K.M. Matthews is, my lord, 1992, 1 SCC 217.
Yes.
Supreme Court said in a summons case, an accused has the right to apply for recall of process. Because in a summons case, after the process is issued, there's only a plea and he has to face the trial, unless he goes for quashing. In a warrant case or in a sessions court, there is a stage of discharge, where the accused has valuable rights. He can say, no offense is made out, discharge me. Now, all PMLA cases are warrant sessions tribal cases because of section 44 and 45, and therefore they have the right to discharge, apply for discharge. In a summons case, the accused, if a false case is filed, magistrate has been misled, poor fellow had no right to go anywhere except the High Court under 482. So K. Matthew carved out an exception, said you can go to the magistrate and apply for recalling of the order. But Supreme Court later, 3 judges, Adalat Prasad and Subramaniam Seturaman, my lord, those are the 2 judgments. That, my lords, may kindly have a look, my lord. Adalat Prasad is, my lords, 2004 7 SCC 338.
Yes.
And Subramaniam Seturaman is 2004 13 SCC 324.
Right.
Supreme Court said K. Matthews is wrongly decided because the magistrate cannot recall his order, it doesn't have inherent powers. So only remedy is that you have to file a 482 petition or a 227 petition and get the order quashed. That was the law. This is all pertaining to summons cases. Because K. Matthews applied to summons cases, the poor accused had no remedy if he is wrongly hauled up before the court. So the amendment in 223 was essentially made to overcome this difficulty of accused faced in a summons tribal cases. Because he had no remedy, therefore they said he has to be heard. Many times what used to happen, my lords, which procedure which we have followed when I was in the trial as a trial judge, in a summons case, I used to give an application saying convert it into a warrant case. That procedure that is permissible. The summons case can be converted into a warrant case. And then I would apply for discharge. But that is the court may or may not allow. That was a different procedure which some lawyers used to encounter at that stage. So now to see that the accused were faced with this problem in a summons case, 223 was amended. Though the objections and reasons do not say so, but that's for the purpose. Otherwise, the accused is heard, my lord. Therefore, kindly have a look at the session trial. I'll take my lords to 220, the Prevention of PMLA Act.
Yes.
That it is a session trial. Kindly come to my lords. 44 1D.
Yes.
A special court while trying a scheduled offence of or the offence of money laundering shall hold trial in accordance with the provisions of the Code of Criminal Procedure as it applies to trial before a court of sessions. So PMLA trials are as if it is a session tribal case. Now come to session tribal case, my lords. It starts with Chapter 19, 248 section of the BNSS. So this is the threshold. It is even before the trial has commenced because the Lordship of the Supreme Court said trial commences after the charges are framed. So at the threshold, an accused gets the right to go and tell the court that discharge me. Now kindly have a look at 250, my lords. The accused may prefer an application for discharge within a period of 60 days from the date of commencement of the case under section 230. 60 days is the new amendment, my lords. Upon consideration of the record of the case and documents submitted therewith, and after hearing the submission of the accused, the prosecution in this behalf as judge considers that there is no sufficient ground for proceeding against the accused shall be discharged. He shall discharge the accused and record reasons for doing so. So elaborate hearing is provided at the threshold where the question of prejudice. You have a limited right to say don't take cognizance of the offense. You have no right to say that don't take cognizance, don't issue process against me. That hearing is not afforded. Actually, it was meant for a summons case where the poor accused had no right. But unfortunately, the language is not happily worded in 223. Therefore, today, even if court has taken cognizance, he is not remediless. He can go to the court and say, discharge me.
So you see, if a full-fledged hearing is given to him, then it will be a double hearing. I mean, at this stage,
In a way, it is a double hearing. But but there is no prejudice. I'm saying maybe, but there is no prejudice. There was no prejudice, and the order can't
So
be
that's why the
quashed.
prejudice angle has been brought in, so that he has to satisfy an additional satisfaction that there has to be a prejudice.
Yes.
All right.
There has to be prejudice. There has to be miscarriage of justice.
So this
That has
opportunity of hearing is somewhere in between an illusory remedy and a full-fledged hearing. Somewhere in between.
Yes, there is required to be another amendment because if the guy is getting a full-fledged, almost a full-fledged hearing at the stage of discharge. There is a sort of a mini lacuna in the because this was not meant to protect this warrant tribal cases, accused and session tribal cases where they already had a right. This was meant for those type of cases where it was summons tribal case. That was the purpose.
But the parameters of the hearing should have been there in the statute. I mean, what is the parameter of this hearing? That has the contour of the hearing has not.
Therefore, we'll have to go to the Supreme Court judgments, which have said what is required to be done at the stage of cognizance. The parameters will have to now come out from Supreme Court judgments. But that, my lords, will find. Kindly have a look at 2019-20 SCC 539. And my lord.
Lord, if you can add to an academic aspect, your lordship may give me just 30 seconds
on this.
On this one.
Sure.
Lord, your lordship may just be cognizant of only one fact. This is the first time in the history of, my lord, our criminal jurisprudence.
Yes.
After 1973 Code of Criminal Procedure was introduced, original criminal CRPC was 1898.
Yes.
But my lord, 73 CRPC, I take it, because we have learned with that CRPC. This is the first time in Indian criminal jurisprudence that a provision is introduced pre-cognizance hearing. So whatever judgments we will read prior to this may have absolutely no value. This is a work in evolution now.
Get your point, Mr. Chaudhary. This is a new novel concept.
10 seconds more, my lord.
Yes.
Just go back to, my lord, that Kushal Agarwal, what my brother's first contention was. His first contention was,
He can't do this, Malani. He is not permitting me to argue the matter.
Mr. Chaudhary, he has not finished. He is right. For a change, you are wrong. Yes.
My learned friend is like a give me an inch and he takes a yard, my lord.
He's trying to intimidate you, which is impossible, Mr. Rai.
Excepting for the Supreme Court, my learned friend is always given that opportunity.
But in the process, I have lost that citation. Please repeat the citation. 2019.
2019 20 SCC page 39. But there are other judgments also, my lord.
Very well, yes. If you can give the paragraph.
Paragraph numbers would be, my lords, may kindly have a look. And just give me a minute, my lords. Kindly come to para 20 onwards. 20 onwards, my lord. May I read para 20, my lords?
2019, volume 20, SCC 39.
539. 539.
Sorry. My mistake.
I'll read from para 18 onwards, my lords.
Yes.
Learned senior counsel appearing for the respondent accused relied on various judgments to contend that while taking cognizance, the court has to record reasons that prima facie case is made out and there are sufficient grounds for proceeding against the accused for that offence. This was the submission, my lords.
Yes.
Then, my lords, he relied on judgment. Then kindly come to para 20, my lords.
Yes.
In a case instituted on a police report, the warrant cases under so-and-so, upon consideration of police report documents filed along with it under section 1, the magistrate, after affording opportunity of hearing to both the accused and prosecution, discharge the accused if the magistrate considers the charge against the accused to be groundless and record his reasons for so doing. That is same to applies even not to sessions trials. Then comes chapter 29C, conclusion of trial. Magistrate to render final judgment and to further considering various provisions and pointing out 3 stages of the case, observing that there is no requirement of recording reasons for issuance of process under section 204 CRPC. Rajkumar Agrawal, State of UP, the London Single Judge of the Allahabad High Court held as under. As such, there are 3 stages of the case. First is under 204 at the time of issuance process. Second is under 239 before phrasing of charge. And third is after recording of the entire evidence of the prosecution and the defense. Question is whether the magistrate is required to scrutinize the evidence at all the 3 stages and record reasons of his satisfaction. If this view is taken, it will make speedy disposal a dream. In my opinion, the consideration of merits and evidence at all the 3 stages is different. At the stage of issuance of process under 204 CRP, detailed inquiry regarding the merit and demerits of the case is not required. The fact that after investigating the case, the police has submitted the charge sheet may be considered as sufficient ground for proceeding at the stage of issuance process. Even filing of a charge sheet may be considered to be sufficient. At the stage of issuance process, however, subject to condition that at that stage the magistrate should examine whether the complaint is barred under any law. That's a limited inquiry. At that stage, section 204 CRP, the complaint is not found barred under any law, the evidence is not required to be considered, nor a reason to be recorded. At that stage of charge under 239 and 240, the evidence may be considered very briefly, though at that stage also magistrate is not required to meticulously examine and to evaluate the evidence to record detailed reasons. That is at the time of framing of charge. 239, 240 deals with framing of charge. We fully endorse the above view taken by the learned judge. A very limited inquiry at that stage of cognizance.
So
Therefore,
you see the right of hearing cannot exceed the scope of inquiry.
Yes. And therefore, very little chance of prejudice. Absolutely no chance of prejudice if hearing is not given.
Then you neutralize the section.
No.
If you say that, there will no prejudice.
No, it's not neutralized. It is saying that the type of hearing, I'm not saying no hearing, but type of hearing. If I'm not neutralizing the section,
that will be governed by the limited scope of inquiry. That is
yes. You have very limited hearing, whether it is barred, etc. Simple. Anyway, which you get at the stage of discharge.
All right. All right.
In para 21.
The scope of this petition.
Now kindly come to para 22, my lords.
Yes, yes.
So kindly have a look at para 21. Mohammed Rahman, this court has made a fine distinction between taking cognizance based on charge sheet filed in the police report and a private complaint under so and so and held as under section has the advantage of police report under 193 has the information or knowledge of commission of an offence. This is not a case of 191C, my lord. So either 191A or B. But under section 191A, he has only the complainant before him. In the ED case, it is not only the complainant, there is a long list of relied upon documents, history of investigation. So therefore I said ED complaint is akin to a charge sheet. Therefore, a complaint on the face of it does not disclose commission offence, the magistrate shall not. Therefore, what is the inquiry? Therefore, the complaint on the face of it does not disclose commission of offence. So only the inquiry is, does the complaint on the face of it disclose an offence? That's all. The complaint is simply to be rejected. In summoning the accused, it is not necessary for the magistrate to examine the merits and demerits of the case and whether the materials collected is adequate for supporting the conviction. Court is not required to evaluate the evidence and its merit. Standard to be adopted for summoning the accused under 204 is not the same as at the time of framing of charge. framing of charge, that more detailed inquiry is required, where he will be heard. At this threshold, where absolutely it is akin to almost a non-hearing. Why is he raising such hue and cry? This is my submission, my lord, as far
Very
as
well, sir.
stage is concerned.
Very
And I will address my lords after my learned friend addresses on the other point. I am also ready, though I have not been authorized, but I'll appear for the CBI and make one point which would dismiss the CBI case also, my lords.
CBI argument, Mr. Raju will be taking up on the next day because we have given time. Affidavit in opposition was filed by the CBI today only. So we have given time for reply. So we'll keep it after 2 weeks, suppose 1 or 2 weeks.
But may I just go leave one of my cases being called out in Sonia Gandhi?
Yes, absolutely, Mr. Raju. You're please.
Just 5 seconds, my lord, on that. I wanted to read that again. My friend, my lord, at page 3 of Kushal Agarwal, this very submission, that what should be the hearing of the accused? What kind of contours? And he wanted to argue the same, that it can only be on what prosecution complaint he has filed. The Supreme Court said, sorry, this is not the stage for us. We are simply setting it aside. We leave the question open. You can argue everything before the special court. So, my lord, that is not the issue before your lordships today. What will be the contours? Let the, my lord, that the court will decide as to, my lord, why legislature has created this. So earlier law on cognizance was only prosecution and the court. Today, my lord, a new stakeholder has been introduced with a right of hearing.
No, Mr. Chaudhary, I actually asked that question to understand the prejudice. What can be the prejudice?
Please, my lord.
Sorry, what can be the scope of this hearing?
So, therefore,
understand the prejudice.
Correct, my lord.
Because prejudice will have to take the color of this.
My lord, assuming that I am able to demonstrate to the court.
Exactly what you have to demonstrate at the hearing.
Please, my lord.
The prejudice aspect will be colored by that. So
Yeah,
that's why I asked his opinion.
So, my lord, simply said, my lord, I'll add just one liner. The court has the power not to take cognizance after hearing me.
Yes.
That will be end of the matter. I don't have to travel anything beyond.
That's the discussion, Mr.
That's a discussion, my lord. That's a
that has been
possibility.
exercised by the you are challenging that.
That is the possibility, my lord. That is why I've been introduced. What is the, my lord, fun of a hearing? Assuming, my lord, that I'm not heard at the stage of charge. Can he argue that he has to show prejudice? He can get an acquittal in trial.
Mr.
So, my lord, it's the same position.
Another question to you: wouldn't be a double hearing if a full
That's right,
hearing
my
is
lord.
given?
That's exactly what I wanted to say. My lord, the legislature, parliament consciously, my lord, put this embargo. We never conceived it. Nobody ever thought of this. Now parliament has introduced it. It has to have its sacrosanct purpose to achieve. Parliamentary legislative intent has to be honored. I have to be given a hearing. Well, whether it is double or triple, of course, at every stage I can seek. Police, the moment, my lord, they start investigating, there is now a provision under, my lord, section 44 to file a closure report. They can file a closure. When it goes to the court now, one additional safeguard, the court can refuse to take cognizance. It could earlier also, but now after hearing me, it can also refuse to take cognizance. Third, my lord, at the stage of charge, the court can consider, my lord, that the charges are groundless, it can discharge me. My lord, at the stage of, supposing I apply principles of Vijay Madan Lal Chaudhary, I get an acquittal or quashing in the scheduled offense. The PMLA proceedings will then go. I can, of course, seek that order that now it has to go because scheduled offense has gone. Go to, my lord, the final stage, 313. No material to give a statement under 235 CRPC. The court will order an acquittal right away without even calling me to record a statement if no prosecution material comes. Final stage, my lord. After hearing arguments, the court will come to a conclusion that I am, my lord, worthy of an acquittal. I can still get acquittal. So it could not be said that I would be given multiple hearings. Therefore, the first hearing should be denied. I have a hearing on this. This is how the procedure is carved, my lord. This is the procedure established by law, that every stage, the prosecution or the investigating agency has to undergo a test of fire. Test of fire. That's, my lord, the test. So they cannot, my lord, imply what will be my fate. What if this has not happened? It is casual. This is not a casual saying. What? You are not denied. You have a right again. You will argue at charge. My lord, I am astonished. This cannot be the position of law.
One other question, Mr. Chaudhary. Have you pleaded any prejudice? What is the pleading of?
My lord, that's why I said, my lord, test of prejudice. And I make this statement. This is a quote from the Supreme Court. In matters of personal liberty, test of prejudice does not apply. Article 21 violated. End of the matter, my lord. So my friend showed you, lordship, my lord, with utmost fairness to him. and he's the fairest of all. 510, which my lord said that if a cognizance is taken by a magistrate who's not empowered to take cognizance. So assuming cognizance is taken by, my lord, a court which is not a special court under PMLA. Let me put it that way. So court is not designated as a special court under PMLA, 43 section, my lord, PMLA says, and it takes cognizance. This argument will come handy. If I come to your lordships and say that this court is not designated, your lordship will say, Mr. Chaudhary, this is an irregular proceeding. But you might have to show prejudice. After all, it's a judge's order. So your lordships may condone that lapse. But my lord, here is my procedure built in my favor. If the legislature, parliament prescribes, statute provides, my lord, I can't cite better than that, my lord, Khwaja Nazir Emperor, 1951. That, my lord, if a statute provides a thing to be done in a particular manner, all other modes or manner of doing that thing are forbidden. This is exactly the position today.
And refusing your right of hearing, which has been given by statute, cannot be equated with a procedural irregularity.
Please, your lordships.
So
It
that-
cannot be irregularity. My lord, I coined two words, a curable irregularity vis-a-vis an incurable illegality. My case is of incurable illegality. And that's precisely why the Supreme Court intervened.
Put it very well.
Please, sir. Grateful, my lord.
Thank you.
Deeply obliged. And my lord, of course, your lordships are not going to say that, my lord, the magistrate will, my lord, do a particular course, or my lord, I may be considered.
That's a procedural.
That's
So you're distinguishing between that and a right of hearing, which
absolutely, my
is
lord.
more substantial.
About right of hearing, nothing else, my lord.
So you are closing arguments on the ED matter.
Please, your
I'll pass judgments later.
Deeply obliged.
As
Deeply.
pointed out by my learned senior,
No, CBI will take up on the next.
as pointed out by my learned senior in the ED matters, Lordship will consider once again non-obstant clause starting section 45 or 44(1), clause B and clause D. Whether in the light of the same section 223 BNSS is at all applicable.
तो मैं 103 पे ले आऊंगा.
Learn it. Yes. No, we have given you how much time to file reply to that?
My lord, we'll file it within a week, less than a week's time. And if they
already
want to
given-
file, in fact, your lordships may give them time. I take it, my lord, that I'll file within the next 5 days. And let them, if they want to file something, they should also file it before the next date of hearing.
At the inception, I've already granted some liberty to file reply. গোড়ার দিকে ওটা পাওয়া এটা রিপ্লাইটা কতদিনের মধ্যে?
They are asking for 10
Within a
days or 2
fortnight.
weeks.
So you'll file it by when? Give us a date.
My lord,
Today we are on 4th.
4th. My lord, have it on, which is the Friday?
Sir, it's 18th. Oh, sorry. It's
File it within a week, Mr. Chaudhary. I'll keep it on 18th.
18th, my lord.
18th? You won't be able to come?
No, my lord, 18th is fine.
To come.
Yes. Please, my lord.
May I request 1 or 2 days?
Yes,
here or
absolutely,
there?
Mr. Raju. Yes.
17th, I'm in Bombay for a matter, but so I mean, it will be difficult on 18th. I will try, but in 1
Bombay,
or 2 days.
Delhi does not matter, Mr. Raju. You will be online. So what is the difficulty?
No, Bombay, I'm going physically. I'm going physically to Bombay.
Yes.
My lord, probably he's understanding. He's not appearing in the CBI matter. These are for CBI.
Oh, Mr. Raju is not appearing in the CBI matter.
I'll make one submission in the CBI matter. I have to make one submission, which I'll make, Manoj. Then
Which you make in the next date.
You convey it, Mr. Raju, to you, whoever appears.
Yes.
Put it
There's
up.
one point which I missed in the ED matter, Manoj. Kindly have a look. One point.
Difficulty is that I will not be there from 21st till for 2 weeks. I'll not be there because I'll have to hold circuit in Jalpaiguri. So
18th.
therefore, it has to be 18th, or if not 18th, then 8th.
My lord, may keep it 18th the second half, my lord. 18th second half.
Second half. It's a 2 o'clock. 2 o'clock, my lord. That's second half is
18th, 2 o'clock. Yes, yes, absolutely.
Yes.
Second.
There's
Thank
one
you.
submission which I missed, my lord, in the ED matter. One submission which I missed.
What is that, Mr. Raju?
Kindly have a look at section 210.
Should I do this, Mr. Raju? You make your submission, and I'll require you to file bullet point notes of arguments.
All right.
So that I don't miss any point.
Very well, Manoj.
It was very fast. So I have taken my notes, but I'll just tell you that with your bullet point written notes of argument. And you just indicate, Mr. Raju, what you will be arguing. What is the point you missed? So that
Point is 210, which talks of cognizance of offense by a magistrate.
Yes.
When it refers to a complaint, says it should also be a complaint filed under a special law. So
Yes, yes.
210, it
Covers
is special
special
law,
law.
PML offense.
Yes.
But when 223 is concerned, that special by special officer is missing.
Acha, very good. Very good.
In any cognizance, this applies.
So therefore, my lords, when the legislature has in 210 said including special officer and not said that in 227,
Not mentioned
the
here.
same legislature using it in two different places in the same statute, the implication would be that special officer's procedure is included. That is going to be my submission, my lords.
My brother, my lord, has all along conceded that in any case, I'm covered by Kushal Agarwal, my lord, I don't need not argue.
And another thing is, judgments by consent are not precedents. I don't know why Mr. Chaudhary has cited those.
Your consent matters a lot, brother. Your consent is the word
We
of
never
the
cited as
Your
precedent,
consent is
sir.
like a judgment.
We never cited as precedent.
When
I'm
Mr.
obliged
Raju
for a
says,
patient.
when Mr.
Patient.
Raju says something, Lord, nobody takes it lightly.
As the force of law.
Yes, my lord, as the force of law.
Thank you so much, both of you.
Deeply obliged.
Hearing is concluded in আচ্ছা এটা হচ্ছে এই যে কটা সিআরআর আছে এই কটা সিআরআর 2072 থেকে
2, 3, 4, 5. 2 to 5.
2 to 5 hearing is concluded learned counsel for the parties are requested to file their respective written notes of arguments within
My lord,
I'll keep a particular date Monday
by Monday.
by Monday
By
on the
Only
written
request-
yes Mr.
only
Raju
request his statement that he is not pressing other point may be recorded. He is
Yes,
not
of course.
pressing
I will write in my note itself, my lord.
no I'm saying that hearing is concluded so
Yes, yes.
that need not be recorded learned counsel for the parties are requested to file the respective written notes of arguments on July 7 2025 when the matter shall next be listed July 7th single postpone আচ্ছা এটা তো বলা দরকার নেই shall file their respective written notes of arguments by July 8 2025 the written notes of arguments whoever is appearing the advocates on record please file the written notes of arguments with my officer I won't put it on the list judgment is reserved in the matter to বলে দিয়েছি না হলে
Because your lordship will not be sitting singly Monday.
that's why I'll be sitting singly next on Friday why wait till Friday file a written notes by Tuesday
Send it over to your lordship's office.
by Tuesday you can file it on Monday also whatever date
Please, your lord.
by Tuesday
Fine.
by Tuesday
Court master.
presence of
আচ্ছা
my
regarding the writ petitions যেটা বললাম the writ petitions এর নাম্বার গুলো দিয়ে the writ petitions bearing number such and such shall be listed next for hearing on July 18 2025 at 2 p.m.
Please, my lord.
at 2 p.m. at 2 p.m. fixed
my presence and presence of Mr. Zoeb Hussain, my assisting counsel, and Mr. Samrat
Extension,
Goswami.
my lord, can you-
yes Mr. Raj.
Well, the I'm sorry.
I won't serve you a copy obviously they'll serve a copy why should I put that in my order
Or extension of time to file the affidavit in reply, my lord, in read.
For a rest, please, yes, 7.
reply you have already granted you time for
Most of,
that is at the beginning of the order
most of. My apologies, my lord, if I have missed it out.
Accept. Deeply obliged.
Deeply obliged.
It was a privilege, my lord.
thank you sir it was both ways
Grateful, my lords.
thank you so much এটা না একটুখানি ঠিক করে ঢুকিয়ে দিতে হবে হ্যাঁ